Mm-hmm. Good luck. Good morning and welcome to the second day of our discussion, and it's a pleasure to see all of you, and hope you had a very good rest after our fruitful day yesterday, and I would like to thank you one more time for the intense and very fruitful day of the discussions yesterday. Before we go to the first session, please let me just in a nutshell stress a couple of points from our discussions yesterday, and as from the high-level dialogue, as also from the sessions we had in the afternoon. In relation that what was mentioned by all of the countries, so the question of trust was mentioned very broadly as the high-level dialogue in the morning, as also the further discussions we had, and we highlighted a couple of times that trust is very important for the well-functioning of justice systems, and a number of countries mentioned that there is necessity also, and there is a room for the improvement of the trust in the justice systems, and access to justice plays a key role in order to help the improve the trust. And here there is a room also for the more open communication between the justice systems and society and non-governmental organizations, and it should be improved by the means of the communication. Then also, very broadly, we emphasized also the importance of international cooperation and cross-collaboration actors as at national and local levels, and also international levels, and support of the exchange of practices in delivery of people-centered justice services, also at the different levels, as international level and also in the framework of the discussion we do have today. And here I would like to thank OECD one more time for the opportunity for the open discussion we do have today. Then we also talked a lot about the business perspective, and it was highlighted that access to justice is also very important to support the businesses and environment for the investment. And here we see the access to justice in a very broad perspective, speaking again on the trust to the justice institutions, and that business experiences are could be looked in the very broad perspective. And the certainty of legal framework, alternative dispute resolution and enforcement mechanisms were mentioned also among important aspects to help businesses to prosper in jurisdictions. Then also several approaches were mentioned how to ensure that justice services works, and among them, for example, was mentioned digital technologies to improve the design and delivery of justice services, and now we will speak in more details in relation to the digital transformation. Then the data-driven justice sector was also mentioned as a priority. So the analysis of the data and designing of the policies based on the data should remain the priority also in the future. Then we also spoke a lot about the capacity of the legal professionals and capacity building in society, also empowering also people's legal capacity, and in order to boost access to justice. And also importance of interagency coordination was also mentioned as one of the important elements. So we also mentioned that particular attention should be also devoted to the different minority groups in order to ensure the access to justice. And today there are a number of the further topics to be explored, and between them is improving responsiveness of justice systems via digital transformation, enhancing measurement and data strategies for people-centered justice, sharing experiences among participants on people-centered services, and in particular, we will also have two sessions on designing and delivering strategies to build also justice with a focus on particular groups. And between these groups, we should mention children and young people. And the second session will be devoted to minority communities and people with disabilities. Also, the last session of today will be devoted to the broader perspective of the justice systems in the changing environment today, keeping in mind these global risks of security and energy, and in light of the current challenges as such. And climate issues will be also included in this session. Now I would like to go to start our first session of today on enhancing responsiveness of justice system via digital transformation, and in the framework of this session, we would like to touch upon a couple of elements related to the opportunities that provides by the technologies to the justice sector. And as one of the responsible for digitalization in Latvian judiciary, in particular in Latvian justice sector, in just starting our session, I would like to mention a couple of elements and our observations in implementing digital technologies for the judiciary. So without doubt, as we work on the development of a case management system, that technologies simplify the daily work of the judge, of the judicial institutions, and simplify also cooperation between different judicial actors. But sometimes we observe that different digital case projects comes with a number of difficulties, and we have very difficult sometimes discussions on how to put in place the digital procedures. And here we reflect also on lack of digital skills for the legal professionals also, and necessity to enhanced cooperation between the different actors, for example, prosecution services and courts, probation services, and necessity to interconnect the different systems. And we thought about why we often stuck in our discussions on the digital cases. And sometimes we came to the conclusion that we need to change our mindset, and we think on how to put our existing procedures, our existing laws to the new digital technologies. But sometimes maybe we need just to also to look on the existing procedures and procedural laws from the broader perspective. And because the new digital technologies provide us an opportunities that were not provided years ago. And here maybe we see that potential that we should look in another perspective on existing procedural laws and make them more suitable for the digital world. And this maybe could solve our discussion in relation to why it's so complex just to bring the civil procedure and put it in the framework of the case management system, for example. Another aspect that I wanted to mention is also when we think on people centricity, on that technologies provides us an opportunity to deliver the best services for the more accessible services for people. And here we could look in more broader perspective, not only to the court services, but also to provide different e-justice services also outside the court. And just, for example, to mention that 2 years ago in court administration, we started the discussion and we implemented the out-of-court advice. So before party come to the court and submit the claim, it's possible to go to the website of Latvian courts and to receive the legal advice, which is to be navigated on the possible solution. And the solution is not binding, but still there is opportunity to better prepare your claim and to receive the information before coming to the court. And here we see also the potential to broaden this solution that has been already implemented and used in Latvia, and here we also see it as an example to other potential solutions, how, for example, e-devices could be used in order to simplify the access to court. So there are a number of other observations, but I would like to stop here and provide the floor to our distinguished panelists. And at first, I would like to provide the floor for the reflections on the latest initiatives undertaken by Japanese colleagues to advance digital technologies of justice systems and in particular to support the people-centered approaches. And I would like to provide the floor to Takashi Kikawa, Takai Kentaro, Hajasume Makato for your presentation. Okay. Thank you very much.
Good morning. Thank you, moderator. I'd like to begin by expressing my sincere gratitude for inviting me to this very important meeting. In the time allotted, I would like to give an overview of the key aspects of Japan's initiative to digitalize civil court proceedings, which falls under the scope of ODR, broadly defined. Japan is currently in the process of taking necessary legislative measures to digitalize civil court proceedings. At the same time, it has launched a pilot program to incorporate digitalization in court practices under the current civil procedural rules in force. The key components at the heart of Japan's initiative are e-filing, e-case management, and e-court. I will first address the issue regarding a gap between e-filing and e-court management. I will then discuss the state of play of e-court, as we call it, and the potentials that DX, digital transformation, has in further enhancing the delivery of justice. Lastly, I will invite a colleague from the Japanese Supreme Court to share further details about the court-specific measures. It is broadly acknowledged that digitalization of the justice sector serves to improve access to justice and expedite court proceedings. It is, however, also underscored that there are accompanying drawbacks to be addressed, including the issue of digital divide. Access to high-quality dispute resolution services is a fundamental right that all people must be ensured equally. In other words, the judicial system must be designed to ensure that those without necessary digital skills or means have equal access to such quality judicial services. Reference in this regard is made in the draft of the conceptual framework for ODR, currently being prepared by the OECD group. To address this issue, one approach is to ensure access to justice through channels both digital and non-digital. For this reason, while it is mandatory for counsel, including attorneys, to submit documents, including pleadings and evidence online, self-represented individuals may opt to submit documents online or in the conventional paper form. Considering that there are many pro se litigants in Japan that file a lawsuit without securing representative to act on their behalf, the e-filing system is designed in a way that accommodates the interest of those most digitally vulnerable. Japan's approach regarding e-filing, which leaves open for some litigants the possibility of submitting documents in paper form, is the source of the problem, which we call the gap between e-filing and e-court, e-case management. For the effective functioning of e-case management, digitizing of all court documents is considered essential. It is not hard to imagine that there will be complexities when electronic and paper-based documents coexist. The question is, how do we address this issue? In Japanese court proceedings, court clerks are required to convert paper submissions into electronic form free of charge to enable the smooth functioning of e-case management, though this is very costly at the present. I have an optimistic outlook that such costs should decrease over time and finally be eliminated as digitalization prevails in society. Next, I'd like to proceed to discussing what e-court is. Recently, Japan amended the law to ease requirements for online hearings. The amendment enabled courts to leverage video conferencing for oral pleadings, preparatory meetings, and witness examination in a broad range of cases. The concept of e-court significantly changes civil court proceedings, and thus it is essential to contemplate how e-court proceedings may best be conducted and accepted in practice. It can be overstated that the judicial system is unable to duly perform its function, lacking the trust of the people and the users. A prudent approach in promoting e-court would be proceed step by step and begin by actively applying it to proceedings of certain types of disputes that are categorically observed to be well suited for e-court. By fostering trust through the administering of e-court proceedings for certain cases, it is expected that e-court may then be gradually extended to other types of disputes over time. Speaking of which of the cases are best suited for e-court proceedings, it should be noted that there is generally a strong demand for using technological means in proceedings of business-related cases. For businesses, as speed in concluding transactions and decision-making has become ever so important, it follows naturally that reaching swift and legitimate settlement of disputes is equally essential. A special courthouse dedicated for business-related disputes has been newly established in Tokyo and will be opened next month. Equipment and devices are installed to conduct proceedings online to the extent possible. If you have a chance to travel to Tokyo, you are most welcome to visit the new facility. The concept of e-court is not just about enabling conventional proceedings to be performed online. DX of court proceedings has the potential to strengthen the function of the courts. For example, in corporate cases, the judges and parties are taking advantage of functions of a video conferencing platform, including the chat function and the screen share function, to discuss the issues in dispute and present arguments. As the judges listen to the parties' arguments and engage in the discussion with the parties, such functions facilitate the performance of the judge's case management responsibilities by identifying the key disputed issues and compiling a list of the main arguments presented by both sides on the spot. The judges will regularly share the list of issues and arguments with the parties, and the list serves as a good basis in further narrowing down and clarifying the disputed issues through communication amongst the judges and parties. Multifaceted communication and increased transparency of the communication amongst the judges and the parties assist the judges greatly in identifying the core issues in the dispute at an early stage and contribute to expediting court proceedings. Enhanced communication will also serve to encourage parties to reach settlement agreements, which will further lead to increasing the trust of the judicial system. This is only one such example of a novel method adopted in court proceedings by using technological means, but it does seem to demonstrate the potentials of DX in further strengthening the delivery of justice. Before I pass the floor to my colleague from the Supreme Court, I wish to give some background as to why I have refrained from touching on the digitalization of ADRs. With a robust judiciary, the use of ADRs by private institutions remains sluggish. For this reason, we have yet to see much progress being made in terms of ODRs administered by private institutions. I wish to nonetheless add that government is currently working together with the private sector to build up a new ODR system that may even enable disputes to be solved with a single smartphone. With this, I pass the floor to my colleague from the Supreme Court. Thank you.
Thank you. My name is Hashizume, a judge from Japan. As Mr. Kikawa explained, in Japan, digitalization of civil litigation proceedings is currently underway. I'd like to explain 3 points about the recent efforts in courts of Japan. First, we began operating a new system for allowing some litigation documents to be submitted in electronic form in some pilot courts this April. Each party can submit a document via the internet and receive the document which is submitted by other party at any time, 24 hours, 7 days. This is an attempt to implement e-filing in advance before the amended act is enforced and full-fledged digitalization is realized. Since all attorneys will be required to submit a document online in 2026, we believe we should operate this system as soon as possible for both attorneys and courts to become familiar with the way to file online and prepare for future electronic records. Secondly, regarding the e-courts, a web conferencing system, which is Microsoft software Teams, is widely used in the proceedings to arrange issues and evidence in the courts of Japan. We started web conferencing system in 2020 in some courts, and now this system is available at all district courts, including branch offices. The number of proceedings using web conferencing system has increased dramatically, mainly because of the situation caused by COVID-19 pandemic. As Mr. Kikawa mentioned earlier, we judges are trying to use the opportunity of digitalization to make better communication with attorneys by using chat function, sharing document online, and editing it collaboratively, and to expedite court proceedings. Thirdly, the business court was established as the first court complex in Japan which intensively handles business-related cases, such as intellectual property disputes, commercial and economic disputes, and restructuring and bankruptcy cases. And it will start operations in Tokyo next month. At the business court, a division of courts in charge of business-related cases are brought together to ensure mutual cooperation among these divisions. In addition, by actively promoting efficiency through digitalization and further enhancing and strengthening its expertise and international characteristics, the business court aims to serve as a new type of court that can meet users' expectations. For example, in the business court, special facilities which is appropriate for web conference, shown as the pictures, has been set up. In conclusion, digitalization of civil litigation proceedings not only contributes to improve access to justice, but also is a good opportunity to change the court proceedings better and to make the resolution of disputes more speedy and more convincing to the parties. As we will make more use of technology in the near future, we will aim to further enhance trust in the judiciary. Thank you very much.
So thank you very much on this number of interesting developments. And the question is very interesting on how to encourage to use, you mentioned that there still coexists the paper work, paper documents coming to the courts, and also the claims submitted online. And so it's always the challenge to encourage the parties to use more the online way to submit the claim. And maybe you have some also particular initiatives how to encourage the parties to use this online way, and for you to make it simple also to ensure this way to transform to online procedure fully. So maybe you could share a bit more.
Yes, that's right. Mr. Kikawa explained, now we are going on paper-based. So even though the e-filing, the data is coming to the court via the internet, the court clerk has to print out this data and make the document record.
Just to add to my colleague's comment, yes, we're on I think, the beginning stage to encourage people to use the online system. It's moving very fast, and I think in a couple of years, maybe we'll be able to, maybe the online system will be more popular among the people, and it will be much more easy for the users to claim their lawsuits to the court. Thank you.
So thank you very much for sharing. And now I would like to give the floor to Manuel Olmedo Palacio, Secretary General on Innovation and Quality of the Public Services of Justice and the Ministry of Justice of Spain.
Good morning. Good morning everywhere. I am Aitor Cubo Contreras. I am Director General of Digital Transformation. Manuel Olmedo is over there. First of all, I want to thank and congratulate the OECD and the Latvian government and the Ministry of Justice for organizing this event. I will use a presentation in which I will only highlight a few points, but it will be available for consultation in full stage, so you can use it later. First, about us, the General Directorate of Digital Transformation provides ICT services to the ministry, but in Spain, justice services are provided mainly for autonomous regions. It's like states, in federal states, more or less. Well, not all the autonomous regions has justice competences. So, Ministry of Justice provide ICT services also in 5 autonomous regions. So, there are 10 autonomous regions that have a different case management system. And one thing that I want to highlight is that we provide common service of justice administration. As I told you, there are several case management systems, so it's important, these common services. Why is this so important? For example, communication services of lawyers with any court in the country, including the territory that the justice service is provided for autonomous region. Practical example, a lawyer of civil communicates to a civil court in the same way with the same system that it could communicate with Barcelona, Madrid, or Seville using the same electronic system. This is quite people-centric technology because you abstract all the complexity of the state and the different systems, and you provide a service focused on the people. This is important. This is the most important thing. There are another several advantages, like we're reducing cost because we can share and reuse the technology. And one thing that is quite important is safer, is faster to deploy, and we can share the system and deploy it quite quickly in the whole country. This is quite important in this process of digital transformation. This digital transformation is framed in a strategic plan. It's not a digital transformation, it's a whole justice system transformation. We transform the process, we transform the organization, and we are doing a digital transformation in justice. This is quite important because process and organization is most important. More important than digital transformation. So if the 3 main focus is doing in the same time, same way, and with all the synergies among them, the process is much more better. We would like to thank the European Commission for the efficiency of justice, CEPEJ, and the European Commission also for the collaboration in helping with this digital transformation. We are working together. We have also European funds to develop the digital transformation process. And this organizing event, I think is quite good to share experience and learn from another practice that are the best practice and transfer to Spain. We can see here the main chapters of the new law of digital transformation in justice. We would like to highlight only some of them that are specifically people-centric. First of all, reducing digital divide and elimination of gender, economic, territorial, age, and educational divide thanks to digital transformation. We have a lot of examples. If you think about these divides and how the digital transformation can solve them, you find a lot of very interesting projects. For example, the digital identification and digital signature. First of all, we say that we will use in the justice system the same system as all citizen, professionals, and companies use with the task agency. That is the system that use everybody. So it's easier to the people because already has that system. But we don't need in justice use a smartphone and an app for that system. You can use it. But we send an SMS, so we break the digital divide for people that doesn't have a smartphone, like older people or poor people, because SMS is available in all kinds of phones. That kind of people-centric project we are doing here in the digital transformation of justice. Another thing that is quite important is data-driven justice, with two main focus. First of all, to know what the citizen really needs and to allocate resources effectively. The justice data trust space is a reality with data for the General Council of the Judiciary, prosecutor offices, ministry, and autonomous regions. We would like to show it because it's seeing all the data of the justice in one place, and you can see in real time that data directly from the case management system and other system is quite impressive. We can show you all later in network time or coffee time. The second focus is data-driven justice management. We already in Spain has electronic justice, but it was based in documents, in PDF or Word or whatever. Right now, we are focused in data. So justice, digital transformation of justice in Spain is focused in data, not documents. It's a little bit different, tricky, because obviously the judge needs later a document to read, but in technological terms is quite different. Rights and duties of citizens and professionals. For example, the daily certified electronic communication between the justice sector and professional is full electronic, and it's mandatory, and everybody are happy with that. I will give you only one piece of information. Around 500,000 communications with the justice sector are made daily in this certification way, that you can prove that it's okay, the sender communication, the receiver receive the communication. That is quite impressive. Citizens file, citizen folder. When you have a case management system and all the file for the court is in a digital way, you can offer that system to the citizen in omni-channel way. He can ask for something by phone. He can go to face-to-face interaction in a municipality, because everything is connected and the file is online. And obviously, he can do things through the web. And that is quite impressive, because citizens have access to the information, and obviously professionals and all the courts, in that way that is quite useful, because it's people-centric. You don't have to go to another place, or you can use phone or web to have this citizen file. Another thing that we think that is quite important to people-centered digital transformation of justice is automatic proceedings and use of artificial intelligence. Why? For example, we doing the cancellation of criminal record through a robotic process automation. The law establishes a series of conditions and times by which a criminal record can be erased, can be cancelled. Well, this right now is done automatically through a rule-based robotic process. More than 240,000 citizens were benefited last year since we started the automatic process. They don't have to request the cancellation. It's a perfect example of citizen-centered administration, because they don't have to do anything. They don't have to do the request. The cancellation or the administration proactively work and solve and ensure citizen rights, because many times the vulnerable people doesn't know that they have that right. So only know how to ask for a cancellation that who has the knowledge of that, and sometimes the lawyer to ask for that service. If the service is provided proactively, an automatic way to the citizen, all citizens are equal, because the law say 5 years after a most minimum penalty, the cancel is automatic. Everybody has the same rights, and that is quite important. Electronic court file is a reality in all jurisdictions, including the most complex criminal justice cases in the Superior Tribunal in Spain for criminal cases. It allows not only teleworking on officials, absolutely essential during COVID pandemic, because they can work from home with the whole case management system. Right now, this is quite important because facilitates family conciliation and fuel savings. You don't have to go to another place. You don't have to go to the court. This is important because the justice services can be provided or managed from any municipality since everything is digitalized. It isn't necessary to go to the court. That's quite important. Of course, like our Japan said before, safe access points and places and telematic public hearings. But not only for trials. Digital presence is a reality. More than 1 million telematic trials have already been held, but justice is not just trials. With the implementation system that we already use, the digital presence is guaranteed and allows multiple judicial and extrajudicial procedures, like litigation resolution, divorce, with legal certainty. This is quite important, and without need to go to the court. We will see just a video, a short video, but you have a lot of more initiative. We have a YouTube channel in the ministry. You can see most of the project in real time with real solution, but we can see just one small video of this project of digital presence. There are more information about this project with real-time simulation, because we don't want to use real data for data protection in the web. And we want to learn in these forums for the best practice of digital transformation to transfer to Spain, and we want to also share our experience, good and bad. We are not focused in the bad experience, but we have several ones. So together we can improve justice and service for citizens. So we are here to your disposal, to be able to see in deep way any commented project and to share any information with you. Thank you. Thank you very much.
Thank you very much indeed, and all the particular initiatives are very interesting, but the most important, I guess, that you put all the initiatives in very synergical ways, so you put it all in one picture. And as it was mentioned at the beginning, so for the digital transformation, it's maybe makes it more easy when you see the full picture.
That is so important because if you only talk with a computer engineer like me, maybe they digitalize a process, but you can realize that if you see the whole picture, you can digitalize a process precisely to do a face-to-face paper-based interaction in a local municipality of 100 people in the middle of the mountain of Spain. Because as you can have everything in digital form in this office, you can interact more easily with these old people that don't want to travel 100 kilometers to go to the court. So it's important to have the whole picture because, and the whole stakeholders. If you talk to everybody, companies and professionals, autonomous regions, citizens, you can make a common project, a country project. And it's quite impressive because everybody are in the same, with the same focus.
It makes it more adaptive, as you mentioned, for sending SMEs in couple of cases. It's more adaptive than using the other means of the communication. So thank you very much for sharing all of it. I would like to now give the floor to our next speaker, Judge, and your head of department and the General Directorate for the Strategy and Development, Seçkin Koçer, in Turkey.
Paldies, labrit visiem. Good morning to everyone. I'm Seçkin Koçer. First of all, before starting my presentation, I would like to extend my thanks, special thanks to Latvian Minister of Justice for this organization, of course to the OECD for this amazing organization, and especially for yesterday's dinner. Thank you so much for your hospitality, and I'm very happy to sit next to you, so thank you so much for your moderation. Let me introduce myself. I am Seçkin Koçer. I am a judge in Turkey. I have 15 years of experience as a judge. At first, I was appointed as a public prosecutor in different cities of Turkey. And after that, I worked as a judge at Turkish Court of Cassation. Now, I'm responsible for the preparation and implementation of judicial reform strategy in Turkey. I'm also a lecturer at the Turkish Justice Academy. My presentation is about, the digital justice in Turkey. As many of you know that we have a long history, 20 years of experience in the use of technology called UYAP. It is National Judicial Database System in Turkey. It was established in 2001. In my presentation, I will give some brief information about the UYAP system, and in the second part of my presentation, I will give some additional information, especially the measures taken during the COVID pandemic, and I will try to be short in my presentation. So, UYAP was established in 2001. At that time, it was used by the Minister of Justice to deal with some, official proceedings among its departments, and over the course of the time, UYAP was improved to use among the courts, public prosecution offices, and lawyers. So in 2005, Turkey started to use the UYAP system all across Turkey. The main purpose of the UYAP is to enhance access to justice for all citizens and also it facilitates the work of judges and prosecutors because regardless of wherever you are, you can easily reach to the system because in Turkey, judges and prosecutors are, given laptops and with special electronic signature token. During the pandemic, we have seen the benefits of that. They weren't required to come to their courthouses to deal with their cases. So it was quite important to have that feature from our side. So one of the most significant features of the UYAP is that it really facilitates our job in terms of collecting statistics because, the UYAP center is in Ankara and instantaneously the data, the statistics could be collected by the IT department of the Ministry of Justice. And we also share these data day by day on our websites. It's open to the public to make it more transparent. And we also publish some annual reports regarding the statistics of the UYAP system. The system has been awarded many times by national and international organizations. I will not give some details regarding that. And UYAP, I will share some numbers about the UYAP system. 800 million documents are produced via the UYAP annually. It's quite a huge number for our country, like any other country. And 3,600,000 documents are uploaded per day. The documents submitted to the courthouses or lawyers, if they are at home, they can easily reach to the system and submit any kind of petitions to the courthouse, to the judge. That kind of documents are, already counted in that number. 13 million documents are read by users per day. This is also quite a huge number to understand the capacity of the UYAP system in Turkey. And the integration is quite important. We invested in the integration of the UYAP with other institutions in Turkey recently because, in justice sector, you are doing something to enhance access to justice and to accelerate to judicial proceedings. But if you don't have any support from other stakeholders outside of the judiciary, it sometimes turns out that all the efforts will be in vain. So we have integrations with 50 institutions and 155 integrations in different fields. General Directorate of Land Registry, Social Security Institution, BARS, Turkish Telecom, General Directorate of Turkish Police, Turkish Central Bank, General Directorate of Civil Registration, banks are the institutions that we have the integration. We have also portals, we have portals, which means that if you are a lawyer in Turkey, you could use a lawyer portal. If you are a citizen, you could use a citizen portal. If you are an expert, court expert, you could use that one. If you are interested in some procedures of sailing, e-sail portal is quite important portal. Mediator portal and police portal are important. Everybody, lawyers and experts have some benefits from these portals. For instance, if you are an expert, you can easily submit your report without going to the court, without seeing the judge from your home. You can see all the details of the court that you have been appointed as a court expert. We have mobile applications that we made improvements recently, especially during the COVID pandemic. Due to the limited time, I will not delve into details about that. The system is based on the needs of each users. For instance, GSM Mobile for lawyers in Turkey, they can easily download these applications on their mobile phones, and they can take actions, they can submit their documents, they can, submit their objections via this system without any need to go to court. E-Justice Citizen is quite important as well. I had an experience about that before coming here 2 or 3 weeks ago. My neighbor knocked on my door and, he had an official notification from a police force in Turkey. It was about misdemeanor fine. He parked his car in a wrong lane or something like that. He wanted to go to the courthouse and he demanded help from me as I am a judge. And I said, just download that program, and I showed, what kind of process he has to follow, and he submitted his objection to that decision directly to the court on this program. It was also an experience we faced actually. Expert Mobile and Mediation Mobile are also another examples of our mobile application system. We have another important implementation of technology in judicial system is hearings. These are like in other countries, Japan and Spain. It's quite, at the top of our agenda of our judicial reform strategy. It's time-saving, it has swift proceedings, but currently in Turkey we use that system in civil courts, civil proceedings. We have 3,557 civil courts have been equipped with that hearings tools. It is closed-circuit system in our country. We created that system with our own resources. We didn't buy any kind of resources outside of the judiciary. So it's now being used by just lawyers, but we are aiming to expand the use of e-hearings for all citizens in the coming future. And almost 300,000 hearings have been performed via e-hearing system so far in Turkey. So yesterday we were talking about the AI system with the colleagues from the UK, and I always ask that question myself, that where are we and where will we be? And it was like, for me, a miracle bird that everybody is talking about, but nobody is able to catch it. AI system, the use of the AI system in judicial sector. Maybe it is much more easier to talk about the use of AI if you are working in the health sector, but it's quite difficult when you are working in our sector, especially for me as a judge. Sometimes it's quite difficult to understand if that system is AI or not. In the Ministry of Justice, we have established, and we already had an IT department, but under the IT department, we established a special and specialized unit dedicated to enhance the AI system in the judicial sector. Before coming here, I asked them where we are, what we are doing, and they said, Um, we have a special AI program, which we are already using in law enforcement proceedings. According to this program, if a document has already been submitted in a physical way in law enforcement proceedings, thanks to the AI system with the specific algorithms, that system upload and save the document into the relevant file of the law enforcement proceedings. So this is an AI system that we are using in Turkey currently in law enforcement proceedings. Besides, the AI unit has been working on the detection procedure of the decision of the inconsistencies of the decisions of public prosecutors. If there is any inconsistencies of the decisions of prosecutors' indictments, the AI system will detect and alert the public prosecutor to correct that inconsistencies. It's not actively used, but my colleagues in Turkey have already been working over it. We see the AI system to assist judges and prosecutors and court clerks. We don't expect that it will replace judges and prosecutors. In this regard, I think to my way, yes, we are using technology. There is no escape from technology, and it seems that there is no escape from the use of AI systems, but we should protect the rights of people. We have digital files, but paper files also coexist, because in rural areas of the country, people may not know the use of technology. So we have that kind of reality like in other countries. So we are trying to enhance the awareness in the society in terms of the use of technology on our websites, but at the same time, you know, we are very well aware of the fact that people shouldn't be deprived of their fundamental rights. Thank you so much.
Thank you very much indeed, Sachkin, and also thank you very much for touching then upon the artificial intelligence and usage of artificial intelligence. And indeed, it's not always clear where is the border between automatization, robotization, and AI. And maybe it's not so important also to understand, but what was important for it also from you to mention that the judicial work should be assisted by all these tools, not talking about the substituting the decision-making function as such. Now I would like to give the floor to our speaker who is in a remote mood connected to the roundtable, and Betty Haberman is director on legal aid information systems in the Ministry of Justice in France. So thank you very much, Betty. The floor is yours.
Bonjour à tous. Merci donc pour l'organisation de ce séminaire. Donc je suis effectivement Betty Berman, directeur du projet de la dématérialisation de l'aide juridictionnelle.
Thank you. I'm indeed Betty Hiberman, and I work with the important project for the Ministry of Justice in France. And I will tell you how we have attempted to solve this question in France. We have a special project intended for citizens who have insufficient funds to address the court, to go to the court. There is a special tool, which is legal aid tool, meaning that they can receive coverage of these services. We have provided last year, in almost 2 million cases, we provided such assistance. However, there is a queue. You have to be waiting for approximately 50 days to receive this service. And prior to the person is able to use it, it is being reviewed whether the person can receive this assistance. And if you don't undergo this process, then you cannot submit and go to the court. We have also seen a dramatic situation and a really large gap between those who have money for going to court and those who don't. There are many people who are able to pay the lawyer and start right away the litigation, but there are some who can't. And when we speak about the budget devoted to this aim, then in total almost 600 million euros are assigned for this. We also work for there to be as few as possible paper used. And when the assistance is provided, then we also want the people to do everything through the internet. And a new program, new software was created with which you can process the claims, the case claims. And we want to concentrate on the person who wants to apply with a claim, submit a claim, and we wanted to create a revolution in this. We want a person to submit a claim, if possible, then electronically. And of course, if this claim is submitted in paper form, then there are many places where the person has to tick or cross something that corresponds to their needs. Then they have to turn over the pages and ignore the pages that are not related to their claim. However, if you do it on the internet, then filling in the application is very easy. And also online, the software selects the corresponding questions. If you, for example, put in your date of birth, then the program itself knows whether you're a person of 18 years of age or more. And also, there are things you must fill in once only, and also things that are filled in automatically. For example, if you put in the address, then there's a street. If you enter the postal code, then they know what is the city, and thus it all saves time. We work also on having and ensuring exchange of documents also electronically, not just claims. And we want for these documents to be available 24/7. And the person has applied, submitted the claim. He can have a look at any time what is going on with these documents. And also the function is developed when the person can receive an SMS if their case is being supplemented with some documents. And finally, the person can find out on the internet what is the court ruling, the decision. And this is also crucial because oftentimes the person has to go to the court physically and retrieve and receive the documents they have submitted. In this case, this is not necessary to be done. Also very beneficial to people to whom it is convenient to use digital platforms, and especially I'm talking about youth who are well versed with technologies, for them it is difficult, for example, to fill in the paper forms. However, the electronic solution is definitely very important to women who suffer from violence. They don't have to go to court or physically anywhere. They simply go online and seek for help. When we're talking about the electronic side of things, it doesn't mean that there's no human interaction and that there isn't this human touch device being given. We followed this procedure, and even though all the documents are electronically submitted, then we want a human assistance throughout all the process. We also work towards we would like the payment to be received also quicker, and no, not the payment, sorry, but the assistance is provided quicker than within those 50 days. And also when, and talking about the electronics, then in the court we have, and it has changed, that you don't have to send anymore to the court or submit in paper format the verification that the materials have been received. If you submit them electronically, then automatically the verification is received. And here I would like to also talk about human-centric justice. We have several strategies available. We want to experience, to work on this project together with the users. We don't know the people, we don't know them. We're not familiar with these people who are using. We don't know what their devices are, because the people connect, and there are different kinds of people, associations, attorneys, lawyers, and we have developed an opportunity, the possibility to take a picture of your ID and send it through the app on the phone to verify the identity. Also, we want to know after the fact what is the satisfaction level of the client with this software. Similarly, we understand that most of the people addressing the court, going to court, is a unique experience. It maybe occurs once in their lifetime. There are people, of course, who go to court several times, of course, too. But it is thus very important that in case when the person has already the problems, because if they didn't have the problems, they wouldn't go to court, naturally, then it is very important then that this unique and once-in-a-lifetime experience in a problematic case in your life, then it would be still, this experience would be, well, pleasant as much as it can be. And if we are offering some kind of improvements in our electronic system, then we are performing some changes, and we are also offering to test them to a limited amount of users. There's also a tool available. In short, it's called, so it's quote-unquote, Finally Tell It. The tool is called like that, and for this tool, it is necessary to avoid that the people are contacting several officials several times. So it is enough to tell once, to submit the data, for example, identity data once. You only claim for financial support once, and this is how we are trying to focus on an individual. Thank you very much.
Experiences on keeping these two tracks and the other tracks as the court and not going radically to only digital way to how to contact the judiciary and judicial system. And thank you very much also for mentioning that it's important also to keep this possibility to go to the court and to solve your important problem, because in some stages it's important also to go personally and to access. And also the time-saving elements are very important. So now I would like to give the floor to our last speaker in the panel, Daiga Zivtiņa, and Daiga is attorney and also member of Foreign Investment Council in Latvia, and representing the Foreign Investment Council of Latvia. And I would like also to mention that together with Daiga and with the support of OECD, we are working now on online dispute resolution concept in Latvia, and looking for the different categories of the cases to be developed in the framework of the online dispute resolution. And it's not easy task for us also, but I know that Daiga will share some observations from the business perspective also on usage of the technology. So please.
Good morning, all participants and their colleagues. Thank you for the organizers, the Ministry of Justice and OECD for inviting me to participate in this roundtable discussion devoted to access to justice. And as Anna mentioned, my main role is a role of the lawyer and disputes partner at the law firm. And here today I represent the Foreign Investors Council in Latvia as a member of the work group in FISIL, and also to work on an online dispute resolution project that could be implemented in Latvia. And I would like to talk more from the business perspective, what is needed for the businesses, for the investors. Court efficiency and investment protection climate are very often asked questions by the investors when they plan to start their business in a foreign country, also in Latvia. And then we can ask, what is the desired result? And it's very simple, but difficult to achieve. Reasonably fast, fair, and understandable solutions for investment protection and development of their business in a specific country. During the last few years, FISIL has observed considerable progress in the Latvian courts that involves introduction of e-case, new related procedural regulations, and continuous work to use online hearings whenever it's practically possible. These initiatives should be continued, and new technical tools and regulations could be introduced to develop dispute resolution as a simple, fast, and cost-effective dispute resolution mechanism for small and uniform cases, and to use effective court examination for more complex cases. The latest changes in format and more frequent use of digital tools involves also improvements in quality of the court rulings. Business community constantly introduces various technological innovations in its daily work. That can be called digital lifestyle, when more and more steps are performed digitally, and the same is expected from the public sector. The companies invest in education and training of their employees, and these are the same people. They are part of our society who are able and willing to use the same skills also in their private cases. they often have their difficulties or need to contact state institutions or settle some minor cases, practical issues. And then it's important that this part of society is provided these opportunities to use their skills and to use digital tools. And we see that the part of society this part of society has tendency to grow, and it leads to increased use of technologies. As successful examples, I would like to mention e-signature, that is very widely used by the individuals, companies, and also public sector. And the next change, which will be effective starting from the next year, when e-address will be mandatory for each company registered within the commercial register of Latvia, is the next step, which will make easier for the Latvian courts to send notifications, procedural documents to the companies, parties of legal proceedings. And we assume that it will be faster, less costly, and also more effective. Considering that, the state institutions should continue their work to ensure use of digital tools and introduce new digital solutions in all court proceedings and all stages of dispute resolution. It is important that the state institutions and courts have relevant capacity to use digital solutions for the management of court cases. That involves use and formation of digital databases, platforms, introducing of simplified procedures that would allow resolving of the cases or its part in written procedure, leaving the most complicated issues for adjudication by the judge. Legal community in Latvia is familiar with various alternative dispute resolution mechanisms to solve disputes without court involvement, but they are not used as practical alternative in Latvia. Digitalization could be helpful to introduce alternative dispute resolution in practice and to motivate the interested parties to solve their disputes without involvement of the state courts. Again, here we see potential development of new platforms or mechanisms, how the parties could do their best to reach a mutually acceptable solution before the case is assigned to the judge or when the case is already initiated to reach a settlement. Use of digital tools show that remote hearings tend to be shorter, better prepared by the parties and judges, and parties have to plan more when to submit evidence. It is a valuable development to strengthen discipline of the parties in courtroom, to avoid too lengthy hearings and ungrounded postponing of the hearings. Often the submission of evidence made in the last minute or during the court hearing in a courtroom to make a surprise to the other party leads to an unequal situation and dilemma, whether to ask to postpone the hearing, what could take additional 2 months, for example, or to do the best to be able to respond to the last-minute arguments properly. It raises a question about the equality of the parties and use of their rights in good faith. The relevant regulations are adopted to organize examination of the cases in line with high standards, but often we see too flexible approaches from the part of judges. Remote hearings and electronic submissions, e-case and newly introduced tools shape the way how judges approach the cases and the described behavior of the parties. It leads to the conclusion that a stricter discipline is needed for the parties in line with the existing regulation or the new regulation to prevent intentional prolongation of the court proceedings and underprepared cases could be adopted. Time to time, we can observe that part of society has a feeling of impunity. Lengthening of the examination of hearings and flexibility of courts support this part of society. One of the objectives of FISTIL is combat a shadow economy, and it goes in line with the effective court system and clear rules for each individual and business. Failure to pay taxes, undeclared employment, unrecorded transactions, and similar activities influence considerably the other part of business community that performs its obligations properly. Introducing of digital tools could be an additional way to promote transparency and fair results in legal proceedings, and at the same time to reduce various ways how to avoid legal requirements. In conclusion, I would like to add that more or less the laws and regulations are adopted and are enforced, but it's a very important part is its application, especially in light of digital transformation. Thank you very much.
Thank you very much, Dijk, and thank you very much for mentioning also another obstacle in implementation of digital solutions as e-signature. And in relation to the businesses, it's more easy to go for the technological solutions as businesses are more broadly using digital identities, e-addresses, and e-signatures as such. And once we discussed also in the framework of ODR, the uncontested money claims, for example, there is a huge, not really the backlog, but huge resources of the courts are not wasted, but the time of the courts is wasted on the production of the documents which are afterwards not really served because there is no e-addresses and it also helps to support the serving of the documents if we would have the e-addresses, e-signatures used and e-identities as such.
Yeah, I completely agree. And these small steps, it makes our lives and work for the courts easier. It's step by step.
Indeed, because we started to discuss the transformation to ODR and we stuck with the small issues which we need to solve, the technical issues to make the bigger progress. So at this stage, maybe I would like to open the floor for the questions, comments, and yes, please.
Thank you very much for some very interesting presentations and some really great work going on across the countries represented there. My question is around the application of technologies described in encouraging earlier intervention in people's legal problems. Have any of the measures described by any of the panel members led to improvements in the ability to intervene earlier in the development of individuals' legal problems and thus lead to better outcomes for the individuals concerned?
Well, I can start with an example. If you are, as I told you before, the thing of interconnection, interoperability, see the whole picture is important. You start a procedure in a court that maybe end in an eviction. So you can, if you have the data, only some of the cases has this data that can end in an eviction. Just when the procedure starts in the court, we have connection with all local authorities in Spain that are that manage the social services for people vulnerable in these cities. We can send an alert to these social security services, social services in the municipality to see if they can do anything. And if they can do anything, it's perfect because you protect private property. The case may solve, in some cases, a percentage, not all the cases, but some cases, the citizens that are in a poor position have rights or helps with anything. So you can do the most important thing, that is help people and solve people problems. And you stop a procedure in court. So you free resources to other things. So yes, technology and digital transformation can do a lot of things for a lot of people.
In fact, you are absolutely right about early intervention, because if you are a person in a society that you feel that you are a victim of a crime, you want to be satisfied with a conclusion, regardless of that conclusion made by a judge or not. You want to be seen as a right position after that proceedings. That's why early intervention is quite important in this regard, because some says going directly to the court makes people much more satisfied, but some says regardless of going to the court, seeing judge face to face, having some concrete conclusion is quite important. In Turkey, we have a special measure about early intervention in terms of violence against women. We have call centers, 24/7 call centers, and if a woman feels that she is subjected to a violence, she could call that call center, and in that call center she could be given some legal advice, and that call center have some directions or links with Turkish police to help the victims of violence against women. But I totally agree with you. We have to, all countries, we have to improve the early intervention system in our countries. Yeah, thank you.
I have a question about integration of ODR and ADR. Solutions for people, we see in legal needs surveys that they mostly come from agreements between people, settlements in the shadow of the law. And we see also online dispute resolution is kind of a marriage between mediation and online court services. We all read maybe Richard Susskind's book on online courts, where he argues for systems with informing people, then facilitation of agreements, and then court decisions. I don't see that yet so much in the projects from judiciaries and ministries. You must have considered integrating ADR and mediation. What makes it difficult to follow the Richard Susskind model?
In fact, in Turkey, we have we have alternative dispute resolution methods like another country, especially in terms of consumer issues. We have online dispute resolution in our country. But as I said, we have an approach about that. If people are informed very well, and if they want to choose that way, that pathway, then it is their choices. But if they want to go to the court and present at the court, face-to-face judgment, if he or she would like to prefer that pathway, it's also their choice. In Turkey, you know, it's a kind of optional pathways for us. So we shouldn't, you know, have people be deprived of their right to be present at the courthouse. I'm not sure if it is an answer to your question.
And maybe to add from our perspective, because as we are now discussing on online dispute resolution, and at first it was also important for us to understand whether we understand with online dispute resolution only private initiatives, as I guess by Richard Susskind, it's more in the direction of the pre-court solutions. We wanted to make it really integrated with the court, so because we see that mediation is not still very broadly used, because people would like to have a court decision. It's more trust to the court decision and that you have this enforceable solution, not the decision between the parties. And we see that it will have more potential, for example, in Latvia for our jurisdiction, that it will be promoted by the government and it will make the solution enforceable as a court decision. So we see it as a continuation of the online court as such in a broader dimension.
To continue this topic, Latvian society and businesses have a very good memory, like not very good memories about too many arbitration institutions in Latvia. Yesterday we heard that my colleague Mars Vanovskis mentioned around 300 arbitration institutions in such a small country as Latvia. It was years ago. The situation is much better. It's around 50 only left after registration. But anyway, it's too many. And these memories about arbitration, it somehow urges the parties, the businesses, to solve their disputes by out-of-court settlements by themselves or go to court, and to obtain this court resolution that is enforceable. And as I mentioned in my remarks, it's very important to change thinking of society, habits of society, and that would require also some kind of regulation to set the rules that can be followed by the businesses, that they could be braver to start this kind of dispute solution, and after these services could be used by individuals.
Thank you for the questions. We totally agree with the question that has been raised right now. In Japan, the public generally trusts the judicial system, so the people are more keen to have a court decision rather to go into the mediation process. But we see the importance with enhancing the mediation through digital transformation. In the past, we've been very successful with certain cases like family cases in using the mediation, but we see that this needs to be expanded, and we cannot foresee how this will develop in the near future, but we think we're at the early stage in trying to integrate all the systems so that the users are more satisfied throughout the procedures. Thank you.
So, Jeff, thank you.
Thank you. And can I just say, congratulate all the presentations. I thought it really is excellent to see what's happening. Although I wouldn't understand the language, I'd love to see some of these apps. I'd love to see that app that you used with your neighbour in Turkey. It would be fabulous if we could all have an app that we could actually address problems. My question is a bit different though, and to say that it's wonderful to see all this work happening and developing, turning courts and tribunals and these processes into robust mechanisms that are going to be easier to use. But at the same time, what's happened in the last 10 years, of course, is that whole range of commercial and private apps, eBay, Amazon, you name it. And it seems to be that people do what people do. People don't always act the way lawyers want them to. And what's happening, of course, is that I think a couple of years ago, eBay resolved 60 million disputes online. Amazon and others do it as well, and the evidence now is even suggesting that people are complaining and complaining to their apps for even quite serious criminal offences. And some of it makes sense. If I ordered a product from Latvia and it arrived, or it never arrived, or it arrived broken, or didn't do what it was meant to do, does it make sense for me who live in Sydney to talk to the legal system in Sydney about it? No, I'm probably going to talk to the app and maybe get something out of this. So I guess it seems to me that parallel to the developments that you're all doing, which is wonderful, the problem is that we've also got this almost unregulated commercial private approach, which people are using and will continue to use because it's happening quite quickly. How are we going to integrate that online dispute resolution, which seems to be growing in popularity? How are you going to how are we going to incorporate that into our systems of justice, access to justice?
Take one more question, Trevor.
Maybe while you're thinking about Jeff's question, I'll just add, picking up on something that Moritz said in terms of ADR and the shadow of the law, and also, Anna, the idea of private justice, which I think goes to Jeff's point. As we think about state-based online systems, they really work well when you assume there is a shadow of the law. But if we do start to put everything into eBay, and if we do essentially assume that one of the benefits of online dispute resolution is we get rid of it quickly and privately, we're actually pushing away the idea of the shadow of the law. The research does seem to show, or at least I know it shows, that people are actually less concerned about the private part of this and more concerned about control, speed, and cost. So finding ways to do this work while at the same time somehow reporting on it so we don't lose the benefit of what's happening to all those cases as they get eaten up by the ADR part of the online system. And I'm just hoping that the state-based part of that, are we thinking about that privatization of the actual outcome?
Thank you very much. The question is very difficult to answer, and I'm sorry I can't provide any very substantial answers to this. It's an ongoing issue. We understand that there are many international disputes on e-commerce, and we are trying hard to solve these issues on a rule-based scheme with our colleagues from all over the world. Currently, we're working more on the domestic side of these issues in Japan to settle down commercial issues. But in the future, we would try hard with our partners to make a rule to be able to solve these issues including through mediation. I'm sorry I cannot provide a good answer to your difficult question, but thank you very much.
Thank you so much for these questions. At first, I will give an example in Turkey. In every cities of Turkey, we have consumer boards, and which is totally separated from the judicial sector, from the Ministry of Justice, and of course from the courts. And that consumer boards are responsible for having some online applications regarding the consumer issues. It's totally, state-based organization under all municipalities in Turkey. But in terms of business part of business-based alternative dispute resolution or online dispute resolution, we don't have any kind of that, method in our country. But you said that, I think, to my view, the satisfaction level of people, both sides, the business part and natural persons, are quite important in this regard. We have to listen to people. If they are satisfied with the outcomes of state-based ODR or ADR, then justice is served, to my view. If they are satisfied with business-based ODR or ADR, justice is also served. So to understand that, I'm talking on behalf of Turkey, we have to have some surveys to measure the satisfaction of not only for consumers, but also the businesses. And as the Minister of Justice, we have some works over that satisfaction surveys, but we haven't completed yet. But without that, without measuring that satisfaction, it is quite challenging to take steps further. Thank you.
Thank you very much. We can take the last question here.
Thank you to the panel. It's been a really thought-provoking and inspiring session. Thank you. I too really like the story from our colleague from Turkey about helping his neighbor with the mobile app. And it got me thinking about the type of support that people are given in order to help them use digital channels, thinking especially about older people, people in our countries that maybe don't speak the majority language, people who don't live next door to very helpful judges. Would anyone on the panel like to talk about the support required or the support that's given to ensure that citizens can remain on the digital channel and hopefully then get better access to justice?
In fact, thank you so much for your words. Yeah, he was lucky. I'm also lucky because he's a good neighbor. This was an exchange of waves, exactly. In fact, in Turkey, at first we have to review our websites, the websites of the courts at first. We are talking about some complicated issues, AI systems and mobile applications. Even people are not aware of their rights. And when they are Googling it, how can I, apply to the court? They are not aware of that kind of things. For instance, one of my friends, who is very elderly, and in his life he hasn't gone to the court, received a notification from the court as a witness. And he immediately came to me and he asked, what will I do? I even don't know how to do in front of a judge. And he was really worried about that. And I gave some information, just be calm down, and there's nothing to be worried about. You will just explain your experience in front of the judge. But he was very worried about that. Just simple things, I think we have to start with. Informing people with the plain language. Yesterday we also talked about that, but maybe when we are talking about complicated things such as AI or ODR, we also miss that kind of basic and important issues. Legal aid is also quite important because many of people living in a society don't know the formal language. And in Turkey, for instance, if you enter in a court and if you say, I don't know Turkish and I don't know how to speak with judge and prosecutor, there is no requirement or precondition to be granted legal aid. Yeah, you can easily get a lawyer besides you, and you can easily get the interpreter because you have to explain yourself. It's free of charge. So we need to start with that kind of basic steps, I think. Thank you.
Thank you very much, and yes.
Yes, just a couple of samples also from Spain. we are working to set all a lot of services in the municipalities. You can go to the Oficina de Justicia en el Municipio, local municipal judicial office. So you can do everything face to face. And the civil servant has a computer, and as everything is electronic, he can give you a notification or answer you how is your process or something like that, because he has the digital media, but you are face-to-face to a person. We also stress the omni-channel. We also have a phone number, because some people prefer a conversation by phone than a website. And about artificial intelligence, we have two projects. One of them, absolutely, we have several running projects in artificial intelligence. One of them is hearing transcription. Most of the hearings are in video, but if you are deaf people, you cannot hear that. So you have automatic transcription, so you can read. Well, it's also useful for people to cut and copy and paste, and so it's better also for a judicial system, but you can cover that problem with the people that cannot hear. We are right now in a project with a university to do the opposite. The sign language of the deaf people, automatic transcript, so the deaf people can speak. So it's quite nice, and we have other services with artificial intelligence, document classification in automatic way is quite interesting. Extraction of and relation of nominal entities. You have the digital file, so you run the artificial intelligence and see people and companies, which relation are between among people and companies, and you can see all the relations in a graph. So it's quite useful for the judge. So that's another interesting project. Document anonymization. You can use artificial intelligence to, once you have the nominal entities in a document, you can blank, you can change the name, so you protect personal data that are sensible. One project that is quite interesting, this is not up and running, is working, we are working on it, is automatic document summary to get the main ideas of a document. That is quite useful also for people, vulnerable people, to translate complex and long documents to plain language is quite useful. So we have several projects in artificial intelligence. We can exchange experience, and if anyone has another project in justice, we can talk to implement it in Spain also.
So thank you very much, and it seems we do have a lot of questions, and apologizes for not taking them all. I would like to invite us to finish our session here and continue the discussion during the coffee break. And I would like to thank all the panelists and to mention that a number of aspects has a potential for also for our further discussions, especially ODR, and there are a lot of questions in the implementation of online dispute resolution, and also the usage of and analyzing of data, as was mentioned also in Spanish example, that you analyze different data from different databases, which is very useful for development of the policies also. So thank you very much one more time, and I would like also to use this possibility to thank also DG Reform for supporting us in in our efforts in Latvia in online dispute resolution, in development of online dispute resolution concept, and some of the documents of the OECD related to the questions we discussed in the framework of our panel, especially framework, ODR framework, and framework for the digital transformation is found also in the room. So please feel free also to take them. And thank you very much. And we have 15 minutes coffee break.
Good morning. Good morning. Welcome back, everyone. So we are about to start our session on measurement and data for people-centered justice. So we continue this discussion on the different implementation dimensions of the OECD framework and good practice principles on people-centered justice. With the focus on improving measurement and data for people-centered justice. And we all know, and this is what we've heard over the past few days, that there is in general an agreement on the benefits of sound measurement and data when it comes to actually measuring justice performance and access to justice. Yet, at the same time, we see that many challenges do remain to improve quality, collection, and use of justice data. For example, when it comes to the collection of data under the new indicator on SDG 16.3 on access to civil justice, to leave no one behind, where the OECD is a co-custodian with our partners from UNDP and UNODC. There are only a few countries that actually managed, member countries of the OECD, that managed to submit data on progress under this indicator. So this shows that the information is either not available or difficult to collect. And of course, there are many great examples of measurement efforts in this space, including those that we will hear about today during this fantastic panel. I feel a bit, lonely at the stage, but of course, yes, we also have a great panel online. So it's really an excellent and distinguished set of experts that we have joining us today, both here in person and remotely. The OECD, of course, has been working with many of you, with many of our partners, the member countries, partner countries, on developing a range of tools. Many of you are familiar with the guide that was published already a few years ago on legal needs survey. But again, just to stress that certainly much more work needs to be done. We know that when it comes to measurement frameworks, when it comes to governance of justice data, many complexities remain. And actually, yesterday we've heard from my colleague from the OECD Health Division on the work that the OECD is doing on improving health data governance. And it feels that there are quite a few interesting lessons that we can be learning from that work stream. And in the session notes that were circulated to everyone just before this meeting, we have started to identify a few elements for a sound data governance framework, but of course we hope to be able to advance this reflection together with you and with our panelists today. Maybe just one point to mention as well, that together with our partners from the International Development Research Center in Canada and the World Bank colleagues, as well as some of the experts present in this room, we will aim to advance the overall work on the global agenda for advancing data collection and overall measurement frameworks when it comes to people-centered justice. And we certainly hope to stay in touch with all of you in this regard. So with this, I'd like to now turn to our panel. So as mentioned, we have 6 fantastic experts and speakers representing both country experiences as well as expert perspectives on what it actually takes to collect, but also the people-centered justice data, but also what are some of the governance aspects that we need to consider, as well as what are some of the elements for effective data use and sharing. So I'd like first to turn to Mr. Luc Altman, who is the head of Insights, an HM Courts and Tribunals service at the United Kingdom, who will talk about the latest initiatives in the United Kingdom to improve access to justice data. Please, Luc.
Thank you, Tatiana. Firstly, I just wanted to say thank you to the OECD for inviting us back to talk about how we in the court service in the UK are measuring and improving access to justice. I attended the last roundtable that was in person back in Lisbon in 2019 when the UK court reform programme had been going for a couple of years. And back then I talked about the ambition of reform and how we were hoping to use data not only to design better services, but to also understand the impact of the reform programme on those services. So as we get to the end of that programme, some of that evaluation work is just about to be published and demonstrates very clearly the improvements that good data and a people-centred approach can deliver. Today, I want to talk about how we are using data to continuously measure and improve access to justice and what this means for the OECD. So by way of introduction, I wanted to say a couple of things about my team, but also the Justice Department's data strategy in general and the court services use of data more specifically. So I lead a research team, and that team is part of a wider group responsible for improving the user experience and access to justice. And our purpose is to support and enable the courts to design and deliver services that meet user needs, promote access to justice, and to continually improve the user experience. Alongside that, our wider department's data strategy supports our purpose by improving justice outcomes through data-driven insight and innovation, ensuring data meets user needs, and building a data culture to value data as a strategic asset. And finally, the approach that HMCTS takes to data is critical to how we measure and improve access to justice. So we have a core set of data included in all of our services. So there are about 90 data requirements covering parties to the case, details to the case, process and outcomes. And we collect protected characteristics such as gender, ethnicity, and disability data in each service at the earliest possible opportunity in the user journey. And in fact, we've recently published that data. And finally, we're committed to sharing that data with academics and third parties. And all of this is important because in order to improve justice outcomes and increase access to justice, we need both this top-down and bottom-up approach to data. So how do we use this data to measure and improve access to justice? I think the slides have got stuck. Okay, working on. So the first point to be clear on that diagram on the left side is the scope of what we are measuring. So we all know that only a very small proportion of legal problems are resolved through the courts, perhaps as little as 2 or 3%. And so this definition in this work refers specifically to those 2 or 3% of cases that at least enter the court system as a case that we can identify in our data systems, although we do try and understand any people who may not be able to access the court systems but want to. This kind of brings us on to the definition. So at the 2019 roundtable, Dr. Natalie Byram, also from the UK, presented a paper on defining access to justice, and she produced that while working with us at HMCTS. And that definition is based on UK case law and covers 4 elements. So access to the formal legal system, access to a fair and effective hearing or process, access to a decision in accordance with the law, and access to a remedy. So I'm not going to describe those in detail, but assume that they make sort of sense to you already, but happy to discuss them more and share a link to that published work. So before I describe how we measure access to justice, it's important to make the point that we have attempted to design existing access to justice barriers out of the services. And this slide simply illustrates what those barriers are that we have tried to design out. So for example, on support, we have introduced and tested the content and guidance provided in each service with service users. On digital skills, we have created a digital support service to enable more people to interact with us digitally. On finance, we have made clear links to support organisations for those who might struggle to pay for our services. And on understanding what is happening, we have tried to design services that keep users updated with where they are in the process of their case. So from our definition, we developed a series of research questions related to each of the 4 parts of the definition. But this isn't a complete list, but it gives you some idea of the kind of questions we wanted to answer and therefore the data we would need. So for example, in access to the formal legal system, there are 5 key questions we want to answer for every service. Is the volume and profile of users what we would expect? Are certain users being excluded? Is the service completed accurately? What is the cost and effort involved in accessing the service? And what difficulties do users face? And across all of those questions, we want to be able to answer that central question: how does access to justice vary by the type of user? So their ethnicity, their gender, their disability, and their age, and also by the type of case. So if we can answer some of these questions, then we can make a good assessment of how the service is performing in terms of access to justice, identify the access to justice issues that we need to improve, and understand the data we need to measure to see if the solutions we design have the desired impact of improving access to justice. In terms of how we do the assessments, we follow a process that first identifies access to justice barriers through analysis of existing data, and critical to this is having the right data and having the resources and skills to analyze it. We then create solutions to improve access to justice. We implement those solutions, and then we monitor the data to see if the change has had the desired impact. And I just want to touch on the data that we have to explore as part of that analysis. So the 2 most critical bits for access to justice are the management information data we collect as part of the service itself. So this tells us, among other things, how many people are using the service, who they are, how long it takes, the outcomes they get, whether they use a legal professional, and whether they apply digitally or on paper. And secondly, the protected characteristics that tell us the user's gender, their ethnicity, disability status, age, and in total 9 other key bits of data about that user that enables us to see how the data varies by these characteristics. And in addition to that, are really powerful sources of data, including contact data, complaints, digital data and Google Analytics, alongside external data like academic studies that can help provide hypotheses for what the access to justice issues might be in particular services. Now, I'd like to actually just share a few examples from these assessments of the data and what we've learned about access to justice. So very simply, just starting with some age data. This summary shows some clear differences between users' ages of different services. You can clearly see probate applicants are heavily skewed to older age groups, and this is expected, as the applicants are often the husband or the wife or the child of the person who has died. And by contrast, the age of divorce petitioners and respondents is far younger. And this age data allows us to design our services around the needs of those specific users. But the age information for probate applicants also demonstrates differences between users of paper and digital channels, with a larger proportion of people sending us paper applications being aged over 65. And this emphasizes the importance of keeping the paper channel and ensuring it performs as well as the digital channel in order to maintain access to justice and ensure that we don't discriminate by the age of our users. The data then becomes more powerful when we link the protected characteristics to other case-level data, like the outcome of the case and how long cases take to complete. So just focusing on that first row of 3 boxes, this approach has allowed us to identify a difference in how long it takes users with different protected characteristics to get a resolution to their probate cases. We then use this finding to carry out further analysis that identified the underlying cause of that difference, and we're now introducing changes to our processes to reduce this difference, and then we'll continue to monitor the data to ensure that that issue is fully resolved. Because we've not published this finding in any more detail, I can't share more of the statistics behind it, but again, we'd be happy to talk to people about that specific example. Finally, I just wanted to share an example, which is in that second row of boxes, of how a more directly people-centered approach to data and analysis can help us to improve access to justice. So sticking with our probate service example, we identified that an important need people had of the service was to be able to apply for probate without needing expensive professional help. In other words, they wanted to be able to do it themselves without needing a lawyer. But the data showed a high proportion of people using lawyers, even in the cases where they were inheriting a relatively small amount of money and their cases were very simple. So following this finding, changes to guidance about when professional help might be needed, changes to the cost of the service, and changes to policy resulted in an improvement to access to justice. And we've measured that by the increase in the percentage of users making applications in person. In other words, more people were able to meet their own needs and do it themselves without a lawyer. Despite all this data and these findings, we do, of course, have evidence gaps on access to justice, so most critically in understanding perceptions of fairness and understanding the trust, motivation and confidence in the justice system. And we're in the process of designing an end case survey that will ask a statistically representative sample of users of the services those exact questions. So just before I describe what I think this means for the OECD, I wanted to finally just link this specific access to justice work to the wider use of data to understand and improve service performance more generally in HMCTS. So my team and I have also developed a framework for improving service performance that takes into account the full extent of the data sources available. So down the left side are those examples of the data we use, and on the right side, the process we use. So similar to the access to justice work, we follow the same pattern of using data to understand and prioritize issues, identify the causes, design solutions, and finally measure the impact. And access to justice is both a separate component of that work, where we aim to report on differences in data by the type of user or type of case. But access to justice is also embedded in that other data. For example, data on time, digital take-up, and contact can also tell us about access to justice. So finally, I just wanted to try and bring this all together and share what I think it means for other justice departments and some of the lessons learned. The first is data strategy. So it's critical that there's an organizational-wide commitment to using data to make decisions, to using data to improve justice outcomes, and to invest in the data culture so that you have the right people with the right skills to exploit that data, including at the most senior levels of the organization. The second is data requirements. So genuinely understanding access to justice and wider service performance is incredibly complex and requires very specific sets of data. So ensuring that you have that right data available in a way that it can be used for analysis is critical. And court data systems collect data primarily for the purpose of progressing cases, and digital services collect only data required for the user to make an application to court. So between those limitations, it can be difficult to access the data you need to improve justice outcomes, and that needs to be considered in the design of the service and the management information systems, and it needs to be done as early as possible in the process. The third is the framework for using the data. So we've developed a successful measurement framework for understanding and improving access to justice, and we've developed a successful framework for understanding and improving performance of justice services more generally. And these approaches that are replicable for other institutions, and we'd be happy to share and discuss more about what we've done and how we've done it. And then the very final point is just about having the will, the capacity, and the skills to act on the data, to make the improvements and measure the changes. And if we can do all of those things, we can improve access to justice. So thank you, and of course I'd be interested to hear your thoughts on all of this, but also to hear about how others are improving access to justice in their court systems. Thank you.
Thank you so much, Luke. From the OECD perspective, this is actually a fascinating example of how to use a combination of different sources of data, digital data, administrative data, to also improve citizen experiences with access to justice. And of course, yes, particularly the last slide where you mentioned the various elements from data strategy to data collection and availability. Then, of course, the importance of a robust measurement framework and the continuous improvement strategy. Those seem to be the core elements of an effective use of data and evidence to actually improve user experiences. So big thanks for that contribution. And now let me turn to our Australian speaker, Ms. Christina Field, who is the Assistant Director at the National Center for Crime and Justice Statistics, who will talk about the efforts in Australia to improve collection of data on legal aid and legal assistance. Please, Christina.
Lovely. Thank you so much. You can hear me okay?
Yes, please.
Oh, good. I'll have to apologise in advance. I'm actually in country Victoria at the moment, and the coverage isn't bad, but you know I'll do my best. And if I drop out, I apologise. Country Victoria is not always fabulous with Wi-Fi access. Um, so firstly, yeah, thank you so much for the invitation to talk and present today. I'm very excited and also, to be honest, very honoured to be a part of this group and these discussions. I'm hoping that what I have to add today will be useful for the overall discussions about improving access to justice. So my approach to, or my thinking about what would be most useful for this discussion is just reflecting on the experiences I've had with actually working with data from across the criminal justice and the civil justice system over quite a number of years. And what are the key things, what are the key building blocks for building quality data? So it's a bit of a broader approach than sort of just courts or any other specific part of the sector, but I'll also sort of reflect upon the experiences in the current project I'm working on, which is the development of a statistical evidence base for the legal assistance sector in Australia. So next slide, please. Thank you. The National Centre for Crime and Justice Statistics, the NCCJS, is a branch within the Australian Bureau of Statistics based in Melbourne. And I guess our purpose statement, if you would like to call it that, is the leaders in the production and promotion of national crime and safety statistics to inform policy and services and ultimately aim for a safer Australian community. That's it. They're the big fancy words. So what does that actually mean? So next slide, please. I've only got 4 slides, so I won't be having to change them too often. So yeah, the previous slide, if you can, that would be great. So the NCCJS, let me refer back to my notes. So our core business really is production of, we have administrative and survey data collections, and they're all national collections. So we have statistical collections for police, criminal courts, and corrective services, all based on administrative data. But you also have national surveys on personal safety survey and crime victimisation survey. The personal safety survey is used heavily in regards to family domestic violence related experiences, and it's used widely across Australian government departments and researchers and the like. And our collections that we have, they're pretty fair. I consider them fairly mature. So some of them have been running for over 20 years. And we've learned a lot in that time about what it means to have good, reliable, fit for purpose data. And time series data is obviously very important. Are things going up or down? Are they changing? Where are they changing? That kind of thing. And we're also obviously review and evaluate and expand on those collections regularly and make sure they're relevant. If they're not useful for people, there's sort of no point. So other work we do in the NCCJS, so we do, in addition to the sort of key annual collections that we release on our website, we are more and more over recent years doing sort of special project work, data consultancies, assisting other departments in helping to develop collections, such as the legal assistance sector. There's some really exciting work happening at the moment with data integration and the development of a justice spine. So the holy grail sort of 20 years ago when I started was, can we measure and can we flow, like watch what happens with people through the system, not individuals, of course, but just, you know, what are the trends and the sort of the populations and who is more likely to, you know, go back into the justice system after being released from prison and all that kind of thing. So that's still a work in project, but it's a project in the works, but it's very exciting. We do data requests for academics and researchers and the like, and the likes. Where are we next? Another thing as well, and I'm going through all this background because I think it leads into where the areas I think are most important for building statistics are. So building and maintaining standards and frameworks is a huge part of what we do. So some examples, we have a data collection reporting framework for family, domestic and sexual violence. So that's a publicly available document designed to help whoever it is that wants to build statistics or information around a particular or around family violence, how to start, what data items they need, what parts of the sector, that kind of thing. So it's a framework that is a publicly usable document for anyone who might want to do that sort of work. Another example would be our offence classification. So Australia and New Zealand standard offence classification. And not only do we use it, but researchers, courts, police, a whole range of areas that are interested in understanding offences use this standard classification. And that's being brought into it more and more as time goes on. And that this allows comparisons of data and those sorts of cross-source comparisons easier when it's all based on the same classification. So we do data gaps and availability assessments. We've done lots of that kind of thing. So we'll have a client come and say, we just need to know what data is out there. Is it sufficient quality? What do we need? What are the key things we need to find or add to a particular collection to be able to make it more useful and more user-friendly? So family domestic violence is a big one, and also violence against persons with a disability. So the area of disability is one that we're increasingly doing a lot of work around as well. And we're also members on various data working groups and boards and forums and all that kind of thing. So we're often invited to talk about our experiences. Myself, I've been lucky enough to be involved in a whole stack of sort of special projects. So legal assistance is one I'm working on at the moment. I'll talk a bit more about that. Civil justice, so I undertook a data availability gaps assessment for the civil justice sector a few years ago, based on identified sort of information needs and policy priority policy areas at the time. Identity crime. So I was looking at ways to improve police data recording on identity crimes and various projects relating, again, to family violence, which is very topical, I imagine, in all countries, and obviously in Australia also. A lot of money, a lot of time and energy is going towards understanding all the aspects of family violence and how, from a justice perspective, we can help people better. So we do a lot of that sort of thing. All right, so I'll jump into what are the key lessons that I've learned over these years doing this work. And I think that a lot of these things that I'm going to talk about it's not just for justice data. They're pretty transferable. These sort of guidelines or tips or hints or whatever you want to call them, in terms of building statistics or building up a database for many different topics. So the first one I have there is what information is needed. It sounds obvious, but it's one that time and time again I've sort of come across. We need to collect data. We need this data. And like, well, what questions do you need to answer? What are your specific needs? Is it service planning? Is it a particular policy? What is it? And it's often the case that it's you get a bit of a blank look, like, we're not really sure. And so we really need to know what you want to know before you can start designing the data to answer those particular questions. Obviously, consulting relevant stakeholders across the board in whatever sort of area that is obviously really important, because they'll have different views and different ideas of what they need in their particular service area or policy area or funding or whatever it might be. Can the information actually be collected? That's another big one. So there's been many examples where it's, there's been a desire to measure, have people's perceptions changed over time about family violence? Something like that is really hard to measure and understand. Would be great to know it. It's just really hard to do it. So sometimes there's things that would be great to know, but feasibly challenging. And another one that the previous speaker alluded to is about the disability data in the courts. And I'd love to know more about how you've captured that information and what it looks like. In the example of legal assistance, so specific information about individuals can be really hard to get. It depends on what the service is. So something like a disability, someone is going in to request legal assistance of some kind. Lawyers are busy, there's lots going on. You can't just ask someone, do you have, mental health issues? It's, you know what I mean? So you can't necessarily just capture that information as much as it'd be great. Can you get the information you want within that particular setting and context is another one that needs to be kept in mind. Access, can you actually access the data? So certainly in Australia, and I imagine it's the same in other countries, is there can be legislation or regulations or whatever it is in place that actually block access to information. So you might go, that'd be great. We want the data that these guys have got, But if they can't provide it for, privacy reasons or protecting client confidentiality and the likes, that could be an issue. So that should be known up front. Sorry, I know I'm speaking quickly, but there's a lot here to talk about. So I wanted to try and cover these key things. What data items do you need to answer the question? And obviously that comes with the frameworks and the standards. You need to know, you know what your questions are, what individual data items are needed to inform those, and then prioritizing those. You can't get everything to start with. There's a lot of things that won't be available. So do you want to start, you're starting, building a foundation, or you're existing, adding to existing collections, like what is it that you want to do, and availability of the data. Okay, second point. So what sort of data, what's the source of the data? What sort of data do you think can answer those questions? Is it survey data? Is it administrative data? Is it a combination of both? Obviously, both sources have pros and cons. An example from the work that we do at the ABS is we have our police statistics. That's recorded crimes. So they're obviously people who've gone to the police and had their particular matter or crime recorded. But there's obviously a whole stack of people that, for whatever reason, don't report crimes, and we try and capture those in our crime victimisation survey. So they basically complement each other in most cases. And there's pros and cons for both, but I won't go into that now. You're probably aware of a lot of those anyway. But again, I can provide more information. There's plenty of links and there's heaps of information out there about the pros and cons of both. Third point, governance. I know it's an obvious one, but again, I think most of us in the room would know that governance is important, but it really is, and it needs to be something where statistics are concerned. It's something that's in place and part of the process throughout. At the ABS, we have sort of a 3-tiered governance structure. We have boards of management that sort of help high-level direction setting, understanding, high-level sort of policy priorities and the like. We have advisory groups that are more sort of conceptual subject matter experts that can help shape what sort of data, what sort of information would help inform that. And then we have our data practitioners and specialists who are the people that get their hands dirty and can know the systems, know what data can be, made available and put into a spreadsheet or whatever it is that you need. So we have multiple levels. They need to all talk to each other. Need to be clear of the roles and responsibilities, and obviously review. It's another obvious one, but a review and evaluation of the data that's being produced and the process. Is it working? If it's not, you got to change it. Pretty obvious. Okay, I'm just conscious of time here. 10 minutes. Okay. So my fourth key point: standards, frameworks, and classifications. Again, you build a house, you're not just going to kind of chuck bricks in and hope the roof's going to stay on. You got to have a good framework to get up and running. And that's essential for good quality data. So that can involve a range of different documents or bits of the framework. So at the ABS, we've done a lot of work with all these sorts of things. So manuals, so that can be standards, definitions, counting rules, technical processes. That we'll have a manual for each collection that we send to our data providers and gives them strict, if you provide data, do it this, and this way. We have manuals at our end so that whoever it is that, if I win the Tats Lotto and lottery and I can run away to Fiji forever, there's a process, a manual there that someone can sort of pick up and take the running with whatever sort of statistical work I was undertaking at the time. So it's internal and external manuals. Dictionaries, you want to promote common terminologies and different definitions. Really important. Frameworks, obviously, models and structures for what data to collect for a given purpose. Classifications, as I referred to before, the example of the offence classification. You need the right people to plan and design these things. There is currently a data standards manual in place for the legal assistance sector in Australia. It's a really great document. It's very comprehensive. It covers all the key areas that a legal service and the clients and all the data items associated with that. It was developed largely from a legal perspective, and so it would have benefited definitely from having some sort of statistical or data knowledge incorporated into those. You know, the design of what sounds great doesn't necessarily translate in the real data world. And yeah, I've got ideally centrally managed. If you have a national statistical centre or someone who takes the running with that kind of thing, rather than a sort of being a disparate process all over the place, that's always a good thing. So a really good example of, in terms of the frameworks and how to come about understanding information needs and the like, the ABS undertook over a few years. Family domestic sexual violence was emerging 10 years ago or so as a really key area. Everyone needs to know more about it. What do we do? How do we provide the services, etc.? We undertook a massive project. Defining the data challenge was the first bit. Developing concepts, understanding, identifying sources. What are the priorities? What do stakeholders need? The second part of that was bridging the data gaps. So that was looking at where the gaps are, what the available information is, and also providing strategies to help fill those gaps. And then there's the National Data Collection Reporting Framework, which, like I mentioned earlier, just provides the key sort of items and reporting formats. But if you want to build some family violence data, this is a really good place to start. I can provide links later on for all these if anyone's interested. It's all on our website. Okay, this is the next one that again.
Christina, my apologies. Just maybe if you could conclude in about 1 minute.
Yes.
So thank you so much.
No worries. I know. I'm so sorry. I'm trying to get through it. I'll wrap it up. All right. Next one was the defining quality. What does data look like? What is quality data? Different for different purposes, different data sets. Depends on what you need. Fit for purpose is the term that we use. Is it fit for purpose? So it doesn't have to be 100% accurate. What is sufficient quality for you to be able to answer the questions you need to answer? 6 point, start small and develop over time. You're not going to have it all to start with. Manage expectations. You've got to start at the bottom and work your way up. Understand your priorities, data availability, etc. System capacities and capabilities. Build it over time. It's not going to happen overnight. And the last one, data champions. You need people who are going to go in and promote across the board. Data is important. We all need it. If you start properly from the from the beginning, the earlier you build in these frameworks and systems, the better your data is going to be. Okay, done. Thank you so much.
Thank you so much for this really useful overview of the key building blocks, but also lessons learned when it comes to the establishment of a sound data ecosystem, particularly from the statistical perspective. I know many countries are currently reflecting on what actually does it take to ensure that you have the right elements to have the right data. So all of your reflections are extremely relevant. And now we continue in the same vein. So we continue reflection from the statistical office perspective. So I'd like to turn over to Mr. Adrian Franco, who is a great colleague and an old friend of the OECD. Adrian is a director at the National Institute for Statistics and Geography in Mexico. And actually Mexico is a country that has one of the most advanced statistical systems when it comes to justice. So Adrian, please, over to you.
Diana, thank you very much. I hope you can hear me very well. I don't know. You can listen me? I guess. Thank you. First of all, good afternoon, everyone. It's a pleasure for me to be here with you. Hello to my colleagues in the panel. Thank you, Tatiana and OECD and your team for the invitation and all your considerations and your support. I will approach to the topic, to this very, very important topic. Of course, as you said, Tatiana, and thank you very much for your words. From a perspective from the National Statistical Office, I will approach to this topic based on the 5 questions that you already sent to us. So I will share some ideas and some experiences from a National Statistical Office from Mexico. First of all, If we want to build a data ecosystem related to access to justice or to justice in general, of course, data strategies for institutions is so very important. But I would like to see this strategy in twofold. First, internal and then external. Internally, of course, it is very important, and our experience is clear on that, justice institutions need to construct or to build internal data units in order to not just to collect their own data, but also to spread the knowledge about the data internally in the justice institutions. Sometimes justice institutions, they are very worried just about the legal services, about the services they provide, but they need to collect by themselves the data and to spread internally. And externally, of course, justice institutions needs to connect with national statistical offices, very important, I will argue about it, but also with other institutions, for example, health institutions, commerce institutions, institutions related to prosecution, to police, on prison institutions, in order to create and to connect all the data, but also to create a data ecosystem. So in this process, there are several opportunities, of course, to create these data ecosystems based on open source data, the use of technology in order to interchange or exchange data and information, and of course to use the power of the national statistical offices in order to produce national official statistics. That this is very, very important for everyone. And the challenge, of course, budget is always a challenge. No, there are some restrictions related to the budgets in order to create these units, or to create the systems, or to create several specialized units and people. Leadership is very important. Who is the leadership when we talk about data related to justice? It is just the institution that is responsible for justice, or it is together with the national statistical offices, or is all the institutions? Who is responsible? So we have to develop this leadership related to the production of justice data and institutions. And the other challenge is the time to adjust process, because finally we have to adjust process in order to build this data ecosystem. Of course, when we talk about data requirements, we have to respond to several questions. What is the people who is presenting a legal need? What is the perception? What is their experiences when they enter in contact with the institutions related to justice? Their experience, how they trust in justice institutions, and how this works, how the process works inside these sometimes black boxes of justice institutions, how they work. So we have to respond to this kind of question. And how we can respond, of course, with several sources of data. First of all, administrative data. The justice institutions produce a lot of data, sometimes in a very good manner. Sometimes we don't have so much order, but we have a lot of data. So we have to put all the data together, but we have administrative data, not just from justice institutions, but other institutions. Surveys are very, very important, because it's the perspective of other people about the work that is produced by the justice institutions. Surveys are very important. And of course, administrative data and some sources that we call censuses of justice, for example. In the case of Mexico, we have this kind of census in which we collect data from all the justice institutions at federal level, state level, and also local or municipal level. And we capture data related to the institutional capabilities and the performance of the institution, but it comes from the administrative data and also from the institutions itself. And about methodology, of course, this is very important to develop the idea and the processes and the regulation in order to create and to generate high quality data with some characteristics of accuracy, completeness, opportunity, data that is comparable between institutions and among and in the time. And we have to create some baselines in order to evaluate and to monitor And very important is to disaggregate the data, because disaggregation is so important in order to know how the data, how the performance of the justice institutions behave across the territories, the different territories, among population groups, different population groups, and of course, socioeconomic characteristics of population, in order to know how justice perform in these kind of different populations. What about minorities? What about vulnerable populations? Or specifically, for example, what about the young people or women people who is a user of legal needs? The data must be ready in this methodology, ready for use. Sometimes we usually think about how to put the data in order to the external people, to the external users, or to the external viewers like academicians, experts, mass media, other institutions who are responsible for the accountability or checking the accountability of the justice institution, and this is very important. But also we have to think about to have a lot of data for internal use in order to make decisions. As the UK example, for instance, is also very important in order to connect the data for decision making, in order to foresight, to forecast, to monitor, to evaluate, in order to improve the services. And when we talk about measurement framework, of course, the measurement framework must be based on not just on data operations, but also in the origin of legal conflicts, in order to understand what is the reason why we have these legal conflicts or legal needs. And we have to explore, of course, the service delivery and the justice sector performance, for example, but not just the performance. For example, in some countries, this is very important to monitor problems in the justice sector, for example, corruption or delays in the administration of the justice. This is very important, as the same case of trust. For example, in the case of INEGI, the National Statistical Office in Mexico, we have all this data, and we put all this data together, and we build indicators that we construct together with the justice institutions in order to perform, in order to monitor or to evaluate. They evaluate, we monitor the access to justice, the level of trust, the workload of judges, for example, or the courts in the states or in the federal level, or the performance itself. So there are several dimensions in which we can build these indicators. The data governance, of course, it starts by a solid legal framework, but not just legal framework, but also protocols, classifications, manuals, dictionaries, etc., that helps in order to understand who is responsible for what in the process of building data and the construction of the data. For example, who coordinates the ecosystem, who is responsible for communicate, who is responsible for methodologies, who is responsible for concentrate data or the interchange of data. Of course, statistical offices, we are expert because we develop these kind of frameworks, not legal, but these kind of protocols in order to put the data all together. And another thing is very important is people. We have to develop people with develop capabilities in people who is responsible for these things. And challenges, of course, the challenges we talk about data governance is the lack of legal frameworks. So we have to build the legal frameworks to build the protocols, the catalogs, these methodologies, etc. And when we talk about communications, it's so important. Externally, when we talk about communications, we have to use a plain language in order to everyone outside of institutions understand what we are talking about. People usually they don't understand the process, the legal terms, the legal concepts, so they don't understand these things. So we have to use a plain language in order to explain the people in a very easy way how the legal institutions works, how the process works. And this is very important. And again, internally, we have to use the data to communicate data in order to to improve decisions or to use in the decision-making process in order to improve justice systems. And finally, what are some of the lessons that we have learned in this process in Mexico and we have seen in other parts of the world? Well, three things. First, to have a very high quality, to have very high quality data about justice and legal needs is not easy. It's a complex task. It implies a lot of time and a lot of resources. Second thing, even if you have very good information and very good data, it is not enough. And the third thing is that if you have very good data and you connect with decision making, you make a change. So this is the lessons that that we have learned in order to change situation related to access to justice and justice in general. Thank you very much, Tatiana, and thank you very much, everyone.
Thank you, Adrian, also for this complementary perspective, in addition to what Christina has shared, because of course, indeed, all of the elements that you've touched upon, including joint leadership of different institutions, of course, the statistical offices, but then also the justice ministries, the judiciaries, other justice players, importance of coordination with other bodies, the data quality standards, appropriate governance, indicators, capabilities. So all of those are indeed key pillars of what actually it takes to develop a robust ecosystem for access to justice and people-centered justice data. And also thanks for reminding us that while data is important, it actually is not enough. So we do need to connect it to the decision makers in order to actually make the change for people in access to justice. So now, after these two perspectives coming from the statistical offices, I'd like to turn to our Colombian speaker, who will be representing a perspective from the Center of Government, National Planning Department of Colombia. So we have Luis Carlos Guevara, who is leading access to justice team in Colombia, in the Justice Directorate in the National Statistical Planning Department. And indeed, Colombia has been a long-standing leader when it comes to measurement of legal needs, but then also using this data to inform national planning and to inform service delivery. So please, Luis Carlos, it's over to you now, please.
Thanks, Tatiana. Is the audio good? Is that working?
Yes, yes, we hear you well.
Perfect.
Thanks.
Thanks a lot. I will share my screen for a bit. Let me just do that quickly. I believe that should be it. I hope that's okay. And let me just swap this really quickly. Amazing. Thanks a lot for the invitation. It's really a pleasure being here. Thanks to the OECD and the colleagues and panel. As you mentioned, I would like to bring a different perspective, not disconnected, but from the center of planning, using these, I will set sources of data and justice and access to justice. To do that, I would like to highlight needs of when developing access to justice policies, and maybe there are there are a lot more, but I would like to highlight three main points that are relevant for us when doing these kind of initiatives. The first one is we need data to design, deliver, and actually implement justice interventions. This point lands in the idea of having a sound diagnosis of the problem people are facing, the challenges they are and the barriers they are facing when trying to access justice, but just not staying at that point, but also trying to assess the causes and effects of those challenges. So that's really important for us, and that's one of the first needs of data when planning. The second one is really echoing the point that our colleagues from the UK mentioned, and is to understand the service capabilities and attributes. That's really connected with efficiency, efficacy, and the way to better allocate and understand the needs of users
The third one is really, I would say, transversal to all of the first two, and is relating to evaluation and monitoring of those initiatives. So here we are pretty concerned about understanding outcomes that might be outside actual justice terms, so not necessarily resolution, but also impact, well-being, and even cost effectiveness and case building for the initiatives. So that's kind of why we need data when we are trying to plan these kind of instruments. I would like to now focus on the first one because I'm coming from the National Planning Department, so we have does have more to tell on the second and the third. Focusing on the first one, the main idea for us is that we have plenty sources of information, and they are often useful for some certain steps of the need, but not for others. So here, the main idea is that a data ecosystem sound to guide decision making needs to recognize the shortcomings and the strengths of different sources of data. For us, it's really important to recognize both information with people at the center, like the legal need surveys, qualitative experiment and behavioral experiments. So that's mixing this overview of the legal need questionnaires with also more on the ground, on the field measurements, like the initiatives developed, for instance, by the USA in the justice program in Chocó and the Pacific in Colombia. On the other hand, we also need to recognize other administrative records stemming from the actual service provision. Here we have service delivery, cases, budget, also normative frameworks guiding those deliveries. And for us, it's really important to just avoid being locked within the justice system, as Adrian just mentioned, and trying to connect these outcomes with wider world measurements and outcomes. Here it's really important for us to understand census data and poverty indexes, as well as other records regarding, for instance, health access, pensions, housing. So this kind of three main points constitutes our data ecosystem, and the challenge for us is to actually identify where and at which stage of planning the justice initiative we can use them. And just to be very conceptual, this is not the actual way we assess a program. We tend to focus on causes using wider world data and legal needs surveys, as well as different complements regarding, for instance, experimental approaches. This is really important because, for instance, legal needs surveys are really useful for understanding paths and incidents of legal needs, but not really good at assessing causes of those needs. So that's when bringing more of an outsider view helps a lot, for instance, using poverty indexes. We also then focus on assessing the problem within the administrative services that are responding to that need, and was in a complete mix of the three areas. Nonetheless, and while this sounds really enticing, we have some challenges when doing so. And I would like to highlight four of them. The first one is that often these data sources have different units of measurements and aggregation. So we can have municipal information from the administrative records, but we from the surveys only can have information about national dynamics, given the probabilistic factor and all the statistical design behind it. So it's really hard for us to start merging those inputs. We also have to recognize that not all inputs are in the same time frame or availability. So maybe we have a legal need that's happening every 2 years, but we have administrative data that's coming daily. So trying to assess those is really important for us. And also quality and recollection, as mentioned by Adrian a moment ago, justice institutions have their own dynamics. And in Colombia, this is really challenging because we have different dynamics in different regions of the country with different capabilities of the institution gathering the data. So that's really another point to take into account. And at the end is the interoperability of these sources. So how can we actually reliably minimize error when merging those sources when assessing and designing a policy? Just to give you an example of how we're doing this, I built this kind of convoluted table on some ideas on that for each of the problems. But just to mention a few, regarding observation and aggregation, we're trying to actually
move further the inputs we already have. And I want to mention our initiatives on using legal needs surveys that are kind of core for us in the National Planning Department, using statistical tools. Our colleagues from the Canada Statistical Office have inspired us to use small area estimation actually to break that aggregation issue, moving from national data to actual municipal data. That's overcoming the limits of our probabilistic framework of the survey and actually being able to assess information regarding municipalities and legal needs. We are doing this alongside our statistics office and support from United Nations and in the ECLAC office in Chile. So this is really a way to overcome these first issues. The second one, and I believe this is echoing again and the points made by our colleagues in Australia, is how we can make this reliable within a governance framework. So the main idea is that we need to have these inputs reliably and avoid one-shots. And the idea here is that we can encompass planning instruments and international planning instruments to guarantee that not only is a commitment of the government, but of the state as a whole. An example of this is our plan within the OECD post-accession report and the work we're doing with the Political Governance Committee to actually institutionalize the legal needs survey measurement in Colombia, bringing multi-stakeholder approaches. So we're not just talking with the National Planning Department, we're talking with the Minister of Justice and Law, we're bringing in the judiciary and even non-governmental organizations. So that's really kind of building the case for the need of having this stable framework of policy that is linked to budget to actually have this over time and avoid one-shot measurements. The second part about quality and recollection, I'm going to be really quick about this, is bringing in our more important institution, and that is DANE, our statistical office, which is actually giving us guidance on how we should develop these statistical initiatives. And we're focusing on many principles, but I want to mention that the statistical office within the statistical national framework is actually giving us a set of tools that are normative binding to actually how to provide statistical records. So this is really important because now we have an accounts where deal. And lastly, ability organization, we need to make these different sources. We have some really interests that are stemming from the ability with legal. So, international law, bringing conciliation records that are going to merge with supply and demand record offer in territories, and we'll try to whole system this map to overcome having spare inputs and just bringing the whole of it into a single system of information. So that's kind of how we're trying to tackle these points that are relevant for us.
Luis Carlos, we unfortunately lost you. Let's just maybe wait for a second. All right, so then maybe we proceed with another speaker and then hoping that Luis Carlos will be able to join us for the discussion period. So thank you so much for sharing Colombian experiences and initiatives on collecting data on legal services and legal assistance. Now I'd like to turn to Pascal Pleasance, who is also a long-standing partner of the OECD, who is a professor at the Empirical Legal Studies, Faculty of Laws, University College London. He's been working with many of the countries present here today, with many of our partners, but then also with the OECD on a series of tools. So Pascal, you are one of the world-famous experts on measurement frameworks and on ways to measure legal needs and experiences with access to justice. Would you be able to share your reflections on what actually needs to be measured when we are thinking about the holistic approach to people-centered justice?
Thank you, Tatiana, and hello, good afternoon, Riga, good morning from London. Yes, I will be happy to share my reflections. I feel I'm running a risk of trying to address everything, and maybe through doing that ending up addressing nothing. But rather than doing a deep dive, I wanted to sort of do more of a skydive and think about some of the broad issues and the broad frameworks that are involved in a data ecosystem. So I'm just going to share my screen. So hopefully that is working. So to start with, I think it's worth reflecting for a moment just on access to justice and what a broad concept it is, how many dimensions and sub-dimensions there are. So this slide is a table taken from the UN Prior City Group's Handbook on Governance Statistics and sets out broad sub-dimensions of access to justice and examples, as you can see in the right-hand column of the table. But it really encompasses everything from structural issues, some of which are not unique to the justice sector, such as the availability of IT, but everything from legal needs, legal capability, through into processes, so availability, the geography, caseload, the cost, and then through into outcomes, individual case outcomes, quality of outcomes, perception of outcomes, and also impact, and that can be at the individual, the systemic, or the broader community level, such as community empowerment. So a huge number of dimensions of access to justice. And likewise, there are many stakeholders to access to justice, many players within the broad justice system. There are many different forms of justiciable problems, a justice issue in the OECD, OSJI guidance on legal needs surveys. There are over 100 in the taxonomy of justiciable issues. There are over 100 listed across 11 very different and distinct categories. And of course, there are very many different paths that people take to justice. There are state processes, there are community processes, there are religious processes, and then there are forms of negotiation, mediation, arbitration, conciliation. So we're looking at an incredibly diverse concept involving a broad range of people, issues, and pathways. And of course, the data needs in terms of understanding this broad concept of access to justice, they vary across these different dimensions and different stakeholders and different problems and different paths. And they also vary across the different stages of policy, service, or institutional development. So here I'm borrowing from the Law and Justice Foundation of New South Wales. Here is an illustration really of, again, a temporal dimension of complexity to add on to that complexity I've already talked about. But you have different needs at different stages of processes. So you have different data needs when you're thinking about planning services, when you're establishing those services, when you're trying to monitor those services, and of course, looking at the outcomes. And this is something of a cycle because, of course, the world never stands still. Things change, people change, systems change, political frameworks change. And so this is a never-ending process of inventing and reinventing over time. So how do we start to think about this? Well, colleagues have already pointed to the various different types of data that exist, and in the prior Citigroup handbook in the Access to Justice chapter, we set out the main sources of data that exist and looked at the types of dimensions, subdimension to which they're particularly suited at providing a picture, and looked also at their strengths and their weaknesses. So this is not a complete list. This is an incomplete list of data sources, and they're important emerging forms of data that are not here, such as data scraping and big data. But administrative data, obviously, is extremely important. It is collected for management purposes, as a record to establish performance and to fulfill accountability, regulatory and reporting requirements. And administrative data can relate to many subdivisions, subdimensions of access to justice, particularly suited to three types of justice measure: the operations of justice systems, the people who are in contact with them, and the availability and distribution of resources. And if demographics are available, then administrative data can also be used to establish whether particular groups are under or overrepresented in different parts of the system. And Luke demonstrated an example of that at the outset of this session. And administrative data from non-justice sectors can also be informative. It can indicate, for example, the levels of issues out there. So accidents in the workplace, exclusions from school, these are all types of things that can be reported within administrative data. But administrative data, evidently, and we all understand this, are limited in their reach. They're poor at looking beyond the horizon of the services that they relate to, and they tend to be, it's not a complete limitation, but they tend to be management rather than people focused. But obviously they can be developed mindful of the, oops, I just accidentally gone forward. So they tend to be limited, and there are also limits to what we can reasonably expect systems to be collecting on a routine basis. It's important not to overwhelm systems with data requirements. One of the first lessons I learned when working within a policy framework and operational framework was that you might have a great big wish list of all the things that you want to know, but what tends to happen if you try to incorporate that into data systems is that people cut corners. And the most important thing is that the data that you do have, you can trust and is reliable. So sometimes less is more. Moving on, user surveys, I won't say much about these, but similar limitations in their reach, and also limitations in terms of technical aspects. But of course, that can add into the service context a much greater degree of person focus. So population surveys, well, population surveys are really filling the gap. And when I was talking about not wanting to do a deep dive and wanting to do a skydive, I think population surveys are the picture that we get when we jump out of the airplane. Maybe that's not a great way of thinking about it, but we get the big picture. And one of the themes that's really coming through from what all colleagues have talked about today really is that in an ideal data ecosystem, you would be able to change your scale of reference. You would be able to go up to 10,000 meters and look down and have a very broad view of the terrain. And then you would be able to deep dive into specific aspects of service delivery. And that's why I wanted to start with that complexity at the outset, because in order to be able to do that, that requires a huge degree of strategic vision and cooperation and slow development of forms of data that can enable us to move around, if you like, in a map, a little bit like sort of Google Earth, I suppose, where we can zoom out and zoom in. But population surveys, they give us this broad perspective, bottom up rather than top down, and they are, of course, at the moment also the key tool to provide the monitoring for the SDG 60.33. Downside, well, there are many. There are lots of technical limitations. They're relatively expensive, although, as I put on this slide, maybe not so very expensive if you think of them in system terms, but as individual items, they are incredibly technically complex. So it's important to develop the tools as are being developed, and the guidance that's available from the OECD, OSGI, UNDP, UNODC, UNECE, as just a few examples, vitally important to progressing. So finally, and this is really, it's not as colourful as Christina's slide, but and it's not the same, but it's similar, and I think we've seen across a number of speakers the sort of similar sort of themes arising. Key issues that we need to bear in mind when thinking about how to develop the data ecosystem. And the first is the purpose. What's the purpose for which data is collected? Why is it being collected? There's cost issues, obviously. There's quality issues, compatibility issues, as we were hearing about, and hopefully we'll hear about again in the context of Colombia, where really world-leading work is being done in this area. There's the reach of data, and these last three kind of come as a little group, and maybe we think of this as being something to do with governance, but there's responsibility. Who's responsible for producing the data? Who's responsible for the data ownership and authority? There are obviously data protection issues, data access issues, and so you sort of implicit within these is that at the system level, there is a real need to have a data strategy. And this isn't going to magically happen on its own. And that's why I started with the complexity. This is evidently a hugely complex environment. And so to think about an appropriate data ecosystem requires that it is led, and that there is strategic direction to it. Anyway, I know that we're very, very tight on time, so that is where I'll finish.
Thank you, Pascal, for, of course, providing us with this strategic overview, both of what actually needs to be measured. So what do countries need to think about kind of as a key measurement elements when it comes to access to justice and people-centered justice, but also that indeed there is a wide range of data sources that are available to the countries, and maybe some of the key issues that you've mentioned at the end, they seem to be also cross-cutting in all of the presentations. And I guess one big question is data governance. Who is responsible for having a big picture? Who is responsible for actually, looking at the different data sources? Because of course we know that data is generated by different stakeholders, and then how to bring it all together. This remains an important question for the justice systems. Now, Now I'd like to turn to last but not least, Ben Polk, who is the Global Policy Director at the International Legal Foundation, who will talk a bit about the criminal justice system and in particular about the measurement of fair trial standards and the work that you're doing in this regard. Please, Ben.
Thank you so much, Tatiana. It is such an honor to be here among such distinguished guests, and I will only register one complaint, which is that Tatiana has assigned me the most unpopular role of being the final speaker before your lunch. So I apologize, and I will be as quick as I possibly can. So, as Tatiana said, I'm the Global Policy Director for the International Legal Foundation. We are a civil society organization that exists to confront the global crisis in access to justice for indigent people who are accused of crimes. I think that gives us a little bit of a distinctive perspective in two senses. And one, let me say that the countries that we are currently operating in are Afghanistan, Myanmar, Nepal, Indonesia, Palestine, and Tunisia and Trinidad and Tobago. So I think we both can speak from a very practical, hands-on perspective, and also, you know, in contrast to the incredibly impressive presentations of some of my colleagues, I think we are interacting with governments that have fewer resources to deal with in collecting their data. Before I jump into how we use data in our work, let me say a very, very quick word about criminal legal aid. We've talked a lot during this conference about the importance of civil legal aid and the need to look at justiciable problems that most people have. But I want to make the case that criminal issues can play a really, essential and important role in access to justice, which I know nobody would disagree with. But I wanted to say that they are unique in particular in relation to something that was raised in our first session, which is the trust in government. They play a very particular role in that trust issues. And this is in part because they historically can play such a key mechanism in systemic discrimination. An example from my country, the United States, where very few people have actually had contact with the criminal justice system. And yet, the studies show that Black Americans, up to 70% of Black Americans report having experienced prejudice in their results in the criminal justice system. And in particular, over half of those say that they feared for their lives during those interactions. And so it's things like that. It impacts a very small proportion of our population, but has huge impacts and resonance on the trust that's felt by most Americans towards our criminal justice system. Similarly, another related thing is that one of the things we're increasingly seeing in the countries that we work in is that people asserting their rights through protest or activism or things like that are being criminalized. So that's another area where criminal legal aid is central to this sense of, does government play by the rules even against the most disfavored elements of society, and do they structurally ensure that fairness is going to be respected? So how does ILF use data? So our approach with the countries we work in is twofold. One, we work from the ground up, which is that we hire and train local lawyers to actually be legal aid lawyers. And two, we partner with the governments to develop their systems and structures for operating a successful legal aid system. So let me talk about the role that data plays in each of these. So first, in regards to the provision of legal aid, one of the first things that we noticed when we started 20 years ago is the difference between what we think of as the nobody problem, in that a criminal defendant is sitting in court and they have no lawyer by their side. That's a huge problem. But there's also the warm body problem, which is that they are in court and they have a lawyer next to them, but the lawyer is not a high quality lawyer. Sometimes the lawyer is just on paper and it's not actually there, but even if they're there, they're not taking the actions to zealously represent that client. So we, in our publication called Measuring Justice, have developed a set of performance standards and indicators that we use to track quality. And I'd really encourage you to take a look at this, because this focuses both on as was discussed earlier, the inputs that have to do with the lawyer's actions, but also the outcomes on people's legal needs and on their perceptions of the services that they've received.
We're currently in the process of expanding that to measure holistic legal aid needs, where legal aid providers are addressing both the root causes as well as the criminal cases that they're facing. But I want to talk more today about our work with governments. So, as you know, the work that I described with measuring quality is mostly used in our work with legal aid agencies or legal aid direct service providers. But there's a difference between that kind of data measurement and the data measurement that governments need to do. Everybody that worked on the SDGs, which is many of the people here, know that very well. And one of the places that we start from is that the SDGs identified, to its tremendous credit, but there's only one criminal justice related indicator, which, as you know, is the percentage of pretrial detainees. And actually, unlike the civil justice indicator, that one's actually not super difficult to track, and people have had some success in tracking that data. But of course, what it does is it says very little in isolation. It's a critical data point, but it says very, very little in isolation. In contrast, and Professor Pleasance pointed this out, there are, all kinds of instruments that identify this huge menu of indicators that could and should be tracked for criminal justice. The United States International Development Agency has a rule of law indicator set that has 512 indicators, which frankly, for many of the countries that we work with, is just unrealistic on so many levels. And one of my other colleagues spoke to the need to just start small and build from there. So that's what we're working on right now, is we're trying to take the step beyond the single SDG indicator, but a very small step, another measurable set of indicators that can be measured, that is attainable by most, if not all, countries that we can compare. So we've launched this initiative with our partners, the Clooney Foundation for Justice and Fair Trials, which are unfortunately unable to be here today. But what we're seeking to do is to develop a global consensus around a core set of indicators for measuring fair trials and access to justice in criminal justice systems. There is already widespread agreement, as many of you know, on what the underlying principles are of fair trials. This comes from the ICCPR. We're relying heavily on a fantastic textbook for any of the international lawyers among you from Amal Clooney that identifies the core principles of fair trials. And what we hope to do is identify a very sort of small set, maybe 1 to 2 to 3 indicators for each of these 13 fair trial principles. The first meeting we held was attended by 49 experts from 33 organizations. The next one, where we dove deeply into the right to legal counsel, the right to legal aid, was attended by 57 experts from 44 organizations. And we're currently in the process of finalizing what we would like to propose to our colleagues and seek your input on as the core indicators for the right to legal assistance, which unsurprisingly will deal essentially with quantity. What percentage of people who are entitled to legal aid face the criminal justice system without a lawyer by their side, and then quality, which we, are choosing to go with the user survey idea of essentially, do legal aid recipients view that their lawyers were of high quality? I want to make one sort of final observation about the difference between criminal and civil legal aid, and this has to do with the idea of demand or the need for legal services. So many people in this group have driven critical work in quantifying the need for civil legal aid, quantifying justiciable legal needs. Actually, surveys aren't really essential to criminal legal aid because for a key reason, which is nobody needs a criminal legal aid lawyer unless the government has taken action against them, unless the police have arrested them, unless a prosecutor has charged them. So it's not a question of surveys, it's a question almost solely due to administrative data. This, by the way, puts aside the question of victims and witnesses, which is important and for which surveys can be very useful, but this is a little bit separate. And so in a sense, the need for legal aid should be actually fairly easy to assess and to quantify. It's really a matter of counting the number of cases, identifying
the caseloads that a lawyer can be expected to carry out and costing out what that is. That's actually a very useful thing, and it's worth considering why that is actually not done very often. There's some work in particular areas we're doing that. But I want to say that I think it could be something that's really incredibly useful for the international community, because often we look at countries that have fewer resources and we say, you know, what does their legal aid say about their commitment to fair trials? But there's a key predicate question, which is, do they have the resources that they need to build the institutions to provide those fair trials? So in conclusion, I just want to say, you know, I would love to enlist the help of as many people in this room as possible in pushing this effort forward. Governments, I would love to hear how you currently track criminal legal aid and what challenges you have with that. The legal aid providers, it's the same thing. And then for researchers, I would love to have your opinions on some of these core, sort of simple, basic indicators that, as you might imagine, and as Tatiana would know from the SDG process, will nevertheless, you know, arouse all kinds of differing opinions and views on this stuff. So with that, let me just say thank you for the opportunity to participate in this important conversation.
Wonderful, thank you. Thank you so much, Ben. I realize that we are officially half an hour late for lunch, but just to see if there are any questions, burning questions that cannot be discussed during lunch or over coffee. Jeff, you look like you wanted to ask a question, so that's...
No, I was just going to make a shameless advertisement that, and I'm no longer at the Law and Justice Foundation, but if you go to the Law and Justice Foundation of New South Wales website, you will see a tool which is about the last 15 years of criminal court data, and there's a dashboard, and you can choose by Aboriginal, Torres Strait Islander group, or other people, by age, by court. You can look at all the criminal prosecutions by a couple of clicks of a mouse. You can look at all that information. That's a good model for that sort of information. So,
thank you. Any other questions? This has been really a fantastic and such a rich set of presentations. So big thanks to the panel. We've heard from kind of the statistical experts, the central agency experts, international experts, legal services and judicial services experts. So it's a really kind of a multidimensional and wide range of perspectives on what actually takes to develop an effective ecosystem. I hope that these reflections will be useful to all of the countries that are currently thinking about or already building sound well, data systems, ecosystems, and certainly on the side of the OECD, we will continue developing this work. Again, many of you should have received the session notes where there are quite a few elements that have been included already, also building on some of the presentations. For instance, what Pasco presented, the overall measurement framework. You can find this both in the chapter on access to justice and the prior city handbook on governance statistics, but also in the session notes, some elements on the justice data infrastructure and governance are also in the session notes. And just to say that this work is being developed and also in the future in collaboration with colleagues from IDRC, International Development Research Center from Canada and the World Bank. So I'd like to thank again a fantastic panel that we've had, all of you for patience, and now would like to invite you to go for lunch and ask you to be back here in 45 minutes. Thank you.
I'm going to ask everyone to please take their seats. We're going to start momentarily. Welcome back from lunch, and welcome to our next panel, the What Works in People-Centered Justice panel. My name is Trevor Farrow. I'm from Canada. I'm a professor at Osgoode Hall Law School and the chair of the Canadian Forum on Civil Justice. Before we get started, a quick programming note. Anna asked me to remind you that after this session, so in an hour, our next session is going to be a parallel session. You'll have seen that from the agenda. So there's an option that you can choose. And I understand that the rooms for those parallel sessions are on the first floor in this building. Don't ask me any questions about any more details because I'll probably get it wrong. But I'm sure we'll figure out afterwards. So, what's happening in this panel? The idea is to, I think, pick up on some of the details and themes that we've heard about over the past day and a half, and to look at essentially the questions of what we've learned, what we know, what we don't know about the ideas about what works. And the panel description is in your agenda. The detailed questions that are animated by the OECD framework on people-centered justice are also in the agenda. The panel that I'll introduce in a moment has been asked to focus on questions around good practice, questions around systemic approaches, and then in particular, country support and country examples that we will see. When preparing for this panel, the question I had in my mind are, what are we really talking about? Are we talking about what works from a retail perspective, meaning clinics, frontline service, the kinds of things that you might get in terms of self-help or community services? Or are we talking about more wholesale kind of questions, culture, systems, data, and rules? And I think the answer is probably both, but that's something that we may want to reflect on. In terms of our panelists, their bios are in the materials as well. We have Chris Coxon, who's going to go first from the Access to Justice Evaluation Data Analysis Ministry of Justice in the UK. Joining us remotely from Canada is Adrian Diagiovanni, Senior Program Specialist from IDRC. And third, Christopher Griffin, the Director of Empirical and Policy Research and Research Professor at the James E. Rogers College of Law in Arizona. Our approach, which if we succeed, hopefully will work well, we have just under an hour. What we've talked about ahead of time is for our panel to try and use up about half the time, and which will then ideally leave us half the time as a group to try and workshop, discuss, and exchange amongst ourselves. So that's our goal if we can. So my job is to keep the panelists on time. Their job is to shut me up, which I'm going to do now, and turn it over to Chris to get us started.
There we go. Thanks, Trevor. Yeah, don't worry, I'll be talking for no more than 45 minutes. I have some slides, if possible.
Chris has some slides that we'll just get up momentarily.
Yeah, thank you, Trevor. And thank you to OECD and our Latvian host for another great conference so far. It's really appreciated. In terms of what works, I'm an analyst, so I'll be approaching it from that perspective, and I'm going to focus on good practice from a fairly sort of practical point of view, I suppose, rather than offering anything too sort of profound in terms of insights on what works as a concept. But what I will do is give a little bit of context on the meaning and the access to justice sort of situation. I want to talk about some new hubs that we've got on at the Ministry of Justice, specifically dedicated to the what works question. A few tips, really, I suppose, from my own experience on embedding the what works culture into policy work, communicating what works effectively, and then I've just got some links to things that we're doing and some resources as well. I would say that there's a fair bit of information on the slides. Don't necessarily try and absorb it all. It's hopefully useful for reference if circulated later on. I mean, just to touch quickly on these next two slides, it's worth pointing out what works is a complex, multi-dimensional topic. We come back to it quite a lot. It can be quite circular sometimes in terms of the discussion, but all I'll say here is that it does have many different dimensions and perspectives. I've just put some of those down in terms of the kind of dimensions to what works that people quite often think are important, and some of the different points of view on what their relative priorities might be. But the what works and what doesn't, for whom, why, and then you could probably add a when to that ladder as well, tend to be the kind of key sort of sub-questions. In terms of the access to justice context, I did want to say, you know, we quite often discuss what doesn't work or what we don't know about what works and where the gaps are. Important to note, we do know quite a lot about what does work. You know, there's a whole body, and Rebecca took us through some of that at a fairly sort of high level yesterday, you know, on what we know from things like legal needs surveys, the importance of early intervention, etc., etc. And it's just important to have those in mind, really. But what we do certainly lack, and I think most people kind of have an understanding of this, is that we're not very good on impact data, you know, on the specifics and the scale. We tend to have quite a lot of process evaluations, descriptive data, and one thing that we do find when we're doing things like rapid evidence assessments and collating data together is there's perhaps a danger of kind of repeating quite a lot of the same basic findings and reaching a bit of sort of saturation point on what we know, and potentially not taking the discussion on as far as it can go. There's lots of challenges associated with measuring what works. Most of these are reasonably well known, but you know, things like agreeing measurable outcomes, the ability to track user journeys, quality and availability of data, and extra pressures on just getting things done, really, that have been caused by COVID-19. But you know, I did want to say these are not, you know, we quite often talk about how hard this is in terms of access to justice. These are sort of complex interventions, and they're not unique to that topic, and they shouldn't really be seen as insurmountable issues. So with that in mind, we do have a function within the Ministry of Justice, a relatively new What Works hub. It's an analytical function. I've got sort of slightly kind of whizzy visual here, but you know, we're certainly not kind of putting it across as some sort of magic wand, and it's not really here to kind of come up with some single definition or even answer to the what works question. It's really about offering practical support to improve the quality of policy making. It's split into two main teams. You have the evidence and partnerships team, the top two discs there, and then evaluation and prototyping are the bottom ones. Don't worry about reading everything on this slide, but I've got a little bit of a dive into a little bit more of the detail of what the teams do. The evidence and partnerships team is about enhancing the use of evidence and expert collaborations. The sort of issues that it's there to address is we're really not very good on things like corporate memory and knowledge retention. Evidence gathering stages at the start can be quite squeezed, especially with rushes on, you know, need to deliver quickly and a general shortening, I think, of the policy cycle. And we do need ways to access evidence and experts quickly. So the evidence team make better use and accessibility of evidence, producing products, things like an internal evidence strategy, which discusses how evidence should drive decision-making, an evidence library of sources, guidance and other resources on use of evidence. The partnerships team, that establishes experts and academic connections. That's underpinned by its own strategy, and we have a published areas of research interest document which outlines the sort of things we're interested in and evidence gaps to help externals connect to us. Data first on the bottom there, I've put a bit more information about that in the annex, and you could probably give a whole presentation on this, but it's quite a large data linking program that we've put in place, and it's there to kind of, it maps, links, and shares internal and external data so that we can improve our capability and infrastructure on that front. The evaluation and prototyping team is there to help test ideas and evaluate robustly. It's certainly true that robust evaluation is quite lacking and inconsistent across government. There's a statistic from a National Audit Office survey over a one-year period quite recently. I think it was 8% of major government policies had a robust evaluation plan. But it is increasingly required as part of business cases to secure Treasury funding specifics about what we're going to do about evaluation. And we have this thing called the Evaluation Task Force, which is a central government function recently established to improve policy and practice and standards in that area. The evaluation team does work on advising, supporting and challenging on evaluation design. It doesn't do evaluations itself, it's there to support other people to deliver and build capability. The prototyping team is about rapidly testing ideas, identifying assumptions and understanding whether things are scalable, and doing that in a way that keeps pace and kind of a level of realism in terms of what policy need to do and when they need to deliver. These are fairly new functions, to be fair, and they're still setting up. One thing that has been done is this internal review on the bottom of evaluation practice. So that emphasised that evaluation is not just about analysts. It can't be done in isolation, and it needs to be integrated into policy work. And that brings me on to embedding a what works culture and approach. This is something that that my teams think about a lot because part of their function is working directly with policy on delivery. I mean, we found basically, this is not a surprise, I suppose, but early planning is really critical at the project level. Getting in there and working collaboratively on design, and it can be quite helpful to have policy and analytical teams embedded together. Not necessarily essential, but we use quite a lot of systems thinking methodology, soft systems workshops, and we start at an early stage with policy on things like the problem definition, mapping the policy logic, mapping a theory of change, and getting all that kind of foundation stuff in place that everything else can be based on after that. And it's certainly the case. This all sounds quite neat and easy. The reality is that it's quite a messy process. There's lots of unknowns. You have quite a lot of gaps at that stage, and that's okay. But what we do find, and if other people do similar work, I'm sure they find the same sort of thing. It's really surprising how often quite fundamental sort of differences of opinion exist with people that need to deliver a policy or major piece of work about core principles, objectives, outcomes, etc. And just getting some sort of consensus on the basics and understanding where those differences of opinions come from is a really important part of. I think it's one of these sort of. It's part of the analytical toolkit that's a little bit sort of underappreciated. But for me, that early sort of stage work is really where analysts. It's a major part of where analysts can add value. And it should be more standardized, I think, in our professional codes. Communicating what works. Just to make the point that, there's no point, there's absolutely no point kind of having nice evaluations in place if, and doing sophisticated what works analysis if you can't express or understand that in a clear way. If the message doesn't land, it doesn't really work. Making use of different ways of presenting, modern ways of presenting information can be quite handy. Social media, different channels, things like that. I think this can be my last slide. The narrative at the end of my presentation, just to make the point that there's various aspects to kind of packaging things up as a what works narrative. You've got your impact evaluation, but not to ignore process evaluation, things that are driving the impacts. Financial and economic savings are an important aspect of it, becoming probably increasingly important with things like financial crisis where a lot of us are going through, and cost of living issues, personal insights and experiences too. The last slide is really just some projects and resources to maybe come back to afterwards, some links to projects that we're working on that use more novel experimental designs, and there's a few guides there. We've got a couple of animations that are quite useful, one that explains more on the What Works hubs themselves, and one that's a more general animation on access to justice core principles. So I'd skip through a little bit of that at the end, but hopefully that's reasonably to time. Thanks, Trevor.
Thanks, Chris. And starting where Chris ended, I really encourage you to visit those resources. I found them extremely clear and helpful, which goes to that idea of systems design, because I actually think a lot of this stuff is quite transferable and really useful. So I commend those materials to everyone after the session. Now what I think we'll do is we'll move directly to our second panelist, Adrian, who I'm hoping can hear us, and we have him there. Hello, Adrian. Nice to see you. Can you hear us?
I can hear you perfectly. Can you hear me?
We can. Excellent.
Okay.
So we're going to keep everyone moving, and I'm going to turn it over to you.
Thanks, everyone. I'm going to use this time just to say thank you very much to the organizers for having me here. I'm trying to share my screen. Can you see my slides now?
We're just getting them now.
Okay. There you go. Does that look okay?
They're just going to come up momentarily. I'll let you know. Yes, we have them.
Okay. Hopefully there's not too much of a lag. If not, I can switch to a different version. So thank you, everyone. My name is Adrian DiGiovanni. I work with the International Development Research Center here in Ottawa, Canada. Our practice in recent years has been to recognize that we're on unceded, unsurrendered territories of Indigenous peoples. And in this case, the Algonquin and Anishinaabe people. And it's an interesting moment this week. We mourned our queen and celebrated our new king on Monday. And next week, we're celebrating what's our second National Day of Truth and Reconciliation. So there's an interesting juxtaposition of our colonial experience that I think it has resonance if only embedded in some of the remarks I'll make today. So we're part of Canada's International Development Assistance, or official assistance. And we've been funding for over 50 years researchers and research in the Global South. And so today my remarks are going to be to just give some very high level and brief messages on what we've learned about what works for people-centered justice in the Global South. And so I'm going to do it in 3 takes. And I think, like Trevor and Chris before me, when I got the invitation about what works, that was sort of my reaction, well, what works for what? And so my 3 takes will be on justice for everyday civil and administrative legal problems, what works for justice for collective or structural problems of democratic justice, democratic governance, and some ideas of what works for linking evidence to policy change. And I think I'm trying to anchor some of my comments in the OECD's framework and good practice for principles of people-centered justice. And I just want to say it's a wonderful document. It's a rich document. My one reflection in going through it is that there seems to be a bit of a gloss, if I can put that gently, and that's between sort of this point 1 and 2. There seems to be now a nice framing, and we do the same thing at IDRC, that justice is very much part of democratic governance and trust and legitimacy institutions, but then also seeming to say that sometimes justice services will get us there. And I'm not sure whether services on the civil side around employment disputes, family disputes, you name it, quite get us to larger questions of structural problems of democratic justice, which often do intersect democratic governance, which often do intersect with justice. So just food for thought. We tend to make that distinction in the research we support, because what works as a research question and then as evidence, in a sense, looks quite different. And so take one, what works for people-centered justice really is community-based justice. And you've probably heard already in your last day or so quite a bit on this, so I won't belabor the point. But really, here I have in mind community level, locally based, some sort of community advice office. There may be a lawyer, maybe paralegals, very much sort of what we call less than formal judge-client legal services. And every study that I've seen over a number of years, some of them we funded, others we have found that they're effective and they're also cost effective. On the right side are two studies that have just come out. We've recently supported, one from Sierra Leone, one from Kenya. We've presented on this past roundtables. And without a doubt, what you put in is less than what comes out. It's cost effective. There's great cost benefit to it. And that, if you look around under pillar one, under the OECD framework on inclusiveness of services, appropriately, culturally appropriate, legitimate, availability, they just seem to work quite well and they're resonant. People want those services when asked. What we're lacking though is a lacquer set of deeper experiences and also contextualize that of what you need to go to stay out. So lots of very interesting contextual data about when people go to which services, but what it takes to really do national level or regional level coverage is quite hard. And here I have in mind better unit cost, being able to compare relative efficacy and trade-offs between different services, especially for women's legal needs and empowerment, which is predominant, and where you can get economy of scales. And you can run it through different legal problems. And I think that resonates with some of the points Chris was just also making about availability of data. So my one plea would why don't we just proceed now with the assumption globally that community-based services is the way to go for access to justice. There's nothing that disproved it, and the more evidence we get really validates that. And so I think we're on increasingly firm ground to make that claim. Take two, though, there's an interesting pillar within the OECD framework on people empowerment. We've been funding a lot of work on what we call legal empowerment. Again, it's paralegal models, less than lawyers, but really where village level, community level, local level justice guides, workers, work with communities, groups, especially disadvantaged, marginalized, around collective struggles, and usually intersect with larger human rights struggles within countries. And here are two really groundbreaking examples, fairly recent. On the left side, some of our partners at Namati in Sierra Leone, based on their very localized level experiences with paralegals and village justice workers supporting communities around community land rights, were able to then basically embed a lot of their findings about what works within two new national legislations around environmental protection and land rights. It's quite groundbreaking. But there's a lot of experimentations where they could find, well, here's what works better for shifting gender norms so women show up to land governance meetings at a community level. Here's what works for resolving disputes between communities. And that they were then able to embed. And now that's potentially getting national level coverage on some what started as very local solutions and strategies. On the right side is some work we've supported over many years from Mukuru, which is an informal settlement in Nairobi on the road from the airport. Here's a group that started with literally helping people protect themselves from eviction, quite forceful and violent, to now the whole community and the hundreds of thousands of people helping redevelop whole communities with the government in partnership. And you have a whole intersection of legal and justice problems around housing, sanitation, whatnot. I can say a bit more about that. These models work, and we have great examples. What we don't have is well-documented evidence around it. And so what we've been doing at IDRC in the last couple of years, we've launched in partnership with Namati and a series of non-governmental organizations around the world, a learning agenda that's really framed into what works, trying to capture larger lessons, comparative across sectors, instead of going sector by sector, what works on a series of large questions that are really about democratic governance, about what makes public institutions work well to be accountable in upholding various laws and policies that protect people's rights, guarantee them access to justice, but also strengthen the empowerment and leadership of marginalized groups, women, people living in poverty, both so that they can enjoy justice, respect for their rights, but also increase their participation in decision-making around crucial issues of development, public goods, public policy that really have an impact on day-to-day lives. It looks much different than going into a legal advice office and trying to understand case data. It's really about going to how can more individualized support then scale up to larger shifts in policy implementation of existing policy. It's in 3 regions: Southeast Asia, Sub-Saharan Africa, it's more than 1 region, and Latin America in about 18 countries more now, and we're at early stages. And so please, we'd be happy to share more information as interested. I'm conscious of time. And then the last point, and this really resonates with the points I think Chris made at the end, his remarks is that, you know, it's not enough just to have good evidence and research. And our experience, and you don't have to worry about this text here, is really a couple of quotes from a couple of recent larger level evaluations or evidence reviews. When research from the beginning is framed with a policy orientation, when researchers and the research problem are embedded in policy context, they tend to have more likely to have policy uptake, impact. And so we tend to score quite well on our own evaluations, external evaluations, because from the beginning we really map out, and in the spirit the way Chris described in his remarks, really trying to understand how can we develop evidence that's ready for use and can guide practice. And so just a plea, not just to think about data in the abstract or kind of on the side of the change and policy processes, really to embed it in. And often researchers who are already part of the debates do well, and they score well, even if methodologically sometimes a bit of back support is helpful. And just the final thing, this is what works well then, going from evidence to policy embedded in an advocacy process. This is the example from the informal settlement I mentioned a few minutes ago in Nairobi, in Nakuru. Don't worry about all the text. It's really to show a bit the complexity, even the messiness. This is a simplified, cleaned up version. And what we've been doing with the teams in the larger legal empowerment learning agenda I just mentioned is really to start by mapping out theories of change, how to develop evidence, what works in supporting communities to get these higher level systemic and structural change we're hoping to help contribute to. So I'll end there. Thank you, everyone. Happy to answer questions, or please follow up to feed many resources.
Thank you, Adrian. And you know, one of the things that I think is so powerful about the work that Tatiana and the OECD have brought us together is this idea of collective thinking. And your presentation, the idea of thinking about individual projects. One way to think about individual projects is that they're individual projects, which are important on their own, but we don't always see the value of it collectively. But then in your presentation, also thinking about it in a global agenda, and then we start to piece the puzzles together. And that way we're going to really leverage not only what works, but also the power of the comparative data and the comparative experiences that will very much quickly get us on track in terms of moving us forward. Jumping right into our third speaker, Christopher, I'm going to pass it over to you.
Thank you, Trevor. And I want to add to the chorus of thanks my own, both to the Latvian government for sponsoring and hosting this event, and to my friends at OECD for the many years that we've worked together on pushing really rigorous research in the access to justice space. What I'm going to do, because I don't represent any government, whether federal or state, but instead I'm a law professor conducting research in the area, is take you down to a very, very micro level, at the level of studies that I have conducted recently with my colleagues back in Arizona, with the hope that the methods used and the objectives behind them are scalable up to a broader level. I should note that all of this work was done in collaboration with my colleagues at the Innovation for Justice Lab, or I4J, that is located within the College of Law at the University of Arizona. They are a self-described disruptive lab that seeks ways to overturn old antiquated methods and look to better solutions to address the justice gap. The first study was one that I'll talk about with you, commissioned by the state courts in the state of Utah. They were interested in really improving the state of their ODR platform. Their ODR platform is used for small claims and other debt collection cases where no lawyers are present. There is a non-lawyer facilitator who works with the litigants on both sides to try to reach an agreement. If they don't, they go to trial. And what we did was take first this existing platform And I want to stress numbers 3 and 5 here. The PAR workshop is a participant, an active participant from the community workshop where we took the existing Utah ODR platform and asked them what makes sense about this and what is deeply confusing. And as you can imagine, with no offense to the state of Utah, when you have lawyers create the ODR platform, it is rife with legalese. It is rife with the same formality and lack of functionality that we would expect primarily lawyers to create. And we learned directly from the community what was impenetrable about the language used, what aspects did work, but really where the pressure points were that we needed to address. And after designing a prototype, we took it back to members of the community who are not lawyers. Unfortunately, number 3 took place right before the pandemic started, and number 5 took place right after it started. So we weren't able to use the same type of participants, but still non-lawyers who could see themselves in a medical debt or a consumer debt situation. We tested the prototype with them and asked them to rate their satisfaction with the new prototype. Again, very importantly, number 3 did involve people who were most likely to use the platform because of their present or prior experience with consumer debt. What we see here are the original Utah platform on the left and our prototype on the right. You can see that on the left, it's a decent job of getting homepage information to the user, but what it doesn't do is tell you as the litigant, especially the person who is experiencing debt, what will happen if you don't join the ODR platform within a certain amount of time, namely that you will default. We thought it very important to incentivize users to actually engage with the platform by giving them that direct advice that, as was the case, without joining within 14 days, you would default. And we tried to make the color scheme more uniform, more pleasing to the eye, rather than having the busy design as on the left. This one was one of the most important to me, is that if the existing ODR platform asked the user to provide their case number, all of us in this room would be able to locate it on the complaint that was sent to the person experiencing debt. Most of our people experiencing debt had no clue where to begin, and so people would probably be sifted out of ODR simply because they couldn't get the program to align with their case. What we did was provide light boxes using the question icons so that you could see directly in that highlighted portion, I know it's difficult to see even in the room, where the case number is so that there would be fewer faults and errors in trying to get yourself into the platform. And here we see the dual approaches to the chat function. The chat function on the left looks like your typical iMessage or WhatsApp messaging, color-coded by the stakeholder in the conversation. We tried to make it even clearer whose message is which, with bigger avatars with the litigant labels next to them, and more of a focus again on who is speaking as much as what is being discussed. And what we learned from all of this is that the satisfaction ratings with the existing Utah platform were moderate at best. Lots of instances where people felt frustrated with their ability to engage in the chat, to upload relevant evidence and other documents to the platform, but with people-centered design at the core, with the UX experience being paramount rather than the legal principles, we received much higher satisfaction ratings from our laboratory participants. The second study that I want to share with you is also involving non-lawyers, and I think from my research's perspective, the frontiers in solving the justice gap are getting approval from state courts especially to authorize non-lawyers to provide moderate scale, limited scope legal advice. And what we tested here in the lab again was a non-lawyer providing advice to people experiencing medical debt. What we had people through Amazon's mTurk service do is work through a simulated experience of medical debt. You have that individual on the left with the glasses. On the right is Taylor, our non-lawyer medical debt advocate. And we kept the scenario very simple to let them know, and we got reactions where people actually felt stress. Even though they weren't experiencing medical debt, they felt the stress of what it's like to go through that. And we asked, what would people do in response to the offer of assistance from a non-lawyer medical debt advocate? Most people in the survey thought that a lawyer would be most helpful. But after working with, again, a simulated, non-existing legal advocate, they found that they would be willing to listen to and take advice from someone such as Taylor. We give them directed advice like a non-lawyer advocate would about how to engage in negotiations, for example, with a creditor on the medical debt. And the interesting thing about this study is that it's a randomized laboratory experiment. Half of the participants went through their medical debt negotiation on their own, and the other half randomly did it with Taylor's advice if they wanted it. We found that the overwhelming majority of people who could work with Taylor decided to take Taylor's advice, listen to it, and act on it. And therefore, what they offered initially was more to settle the debt and not allow more arrears to accrue and interest on that. So what we are doing in collaboration with the I4J Lab is to lead a pilot of actual non-lawyer medical debt advocates in the state of Utah where they have been approved. That's all I have for now. I look forward to your questions during the conversation.
Thank you, Christopher. And you know, the keeping with the theme of what works and actually demonstrating through those studies, I think is incredibly powerful. So we now are making fairly good on our promise, thanks to our panelists, to have stimulated some ideas, and it's now the opportunity over to you. Questions, comments, concerns. Things that you would like more information on. But we've got about 25 minutes. The floor is open. This is where you earn your lunch. Paul.
Thanks. Look, I mean, when we're talking about what works, you know, there's always the follow-on of what works for whom, when, why, and how. And, you know, as we're developing more and more data and knowledge about what works, you know, I hope we're slowly pushing towards these different scenarios. But the question I have is, and it's something we wrestle with quite a lot at the bank, is, you know, what works for whom? And, you know, our target audience is, you know, poverty, vulnerability, exclusion. So I would be interested to hear, and maybe it's mostly for Chris from the UK, how you balance this kind of bigger data that feeds into policy with this more micro data that really helps you understand what's working for more vulnerable or whatever type of targeted populations. And, you know, and also I think you mentioned this too, but one of the big lacks is data on impact of access to justice or lack of access to justice, particularly at the household level. And this is something that we're launching a little bit of research and meta-analysis to try to get a better understanding of what it means when people are denied access to justice, what it means for the household and longer-term development objectives. Thanks.
Yeah, thanks for the question. I mean, I guess this comes down to you know, I was saying during my presentation about the problem definition, you know, and starting at an early stage. And I think when it comes to different groups, you know, you're really into, you know, outcomes. What are the outcomes that you're trying to achieve? You know, figuring those out right at the start and the logic of what you're doing. And we quite often find a lot of our policies, they're aimed at, you know, groups of people who they're not experiencing kind of, you know, one intervention that we're doing. It's very much, it's a whole system approach, and we need lots of data at different points in the journey. And we've got this sort of opportunity at the moment, it feels like, with being able to collect, you know, lots of new types of data, big data, using, you know, new data sets in more innovative ways, IT systems, you know, we're more connected than we ever were, to, you know, get that sort of infrastructure in place. And on one sense, we've got capabilities, I mean, hopefully this What Works Centre, is partly a nod to that, you need to be doing stuff that is focused on delivery and actually kind of implementing policies, while at the same time kind of having some resource carved out to focus on infrastructure projects and that kind of bigger picture data collection. The risk I think that we've got moving forward on the data side is that with a lot of resource cuts coming our way potentially, and a squeeze on public sector resourcing generally, it does make government departments and other services a bit more insular, and they tend to sort of focus on core business. And some of these kind of wider capability projects do kind of fall away. So I think we're into sort of on the data side, kind of maximising the opportunity, minimising the risk. But at the same time, kind of paying heed to the fact that we are looking at whole system approaches here, and that where we kind of, we need data that kind of track journeys, not just kind of bits of the system. When we put, it's a sort of, the whole sort of access to justice system is a big sort of, the ecosystem is the word that's used quite a lot, but it's a big pond, isn't it? And if you throw something in one bit of it, it has a ripple effect, and you need data that allows you to kind of to track that over time. Was there I may have kind of gone off on a little bit of a tangent there, but was that kind of getting at your question?
And Paul, just one of the things, and then Jeff, I'll come to you, you make me think about is, we heard from our health colleagues yesterday, and we do not need to reinvent the wheel. Imagine going in for a procedure and the physician saying, well, we don't really know how this will go, but let's try it out. Of course, we don't do that in health or early childhood education or other places. But in law, we have not really asked that question, does getting this intervention improve your life? And I do think that that's kind of the next goal of systematic research that we need to think about. And one of the projects that we're doing at the Canadian Forum on Civil Justice is following people who receive a service 6 to 12 months later and trying to understand the impact of that service to see whether it's worth it, whether we might tweak it, whether we go in a different direction. Because I think we need to be thinking about that. Are we making people's lives better question? Jeff.
Thank you for the 3 very good presentations. If I could just bring a couple of things together and ask 2 questions, if I may. Paul's point about what works for who, in where, and in what context, and so forth, is a good one. If we link that to Rebecca's presentation yesterday about legal need is not equally distributed, certain disadvantaged people and so forth have a great number of legal problems and so forth. And you could break up actually meeting the needs by a range of different, reaching them. Actually, how do you get in contact with people? And we've learnt over the last 2 years, I guess there must be a whole lot of lessons learnt through the pandemic about how governments have reached different communities with information, vaccinations and so forth. So we might have learned a whole lot more about how to reach different communities. So I guess the 2 questions I would have would be, first of all, is what have we learnt, the panellists, particularly from the pandemic, that might be transferable to access to justice, what works, maybe at the micro level. But secondly, how can we share the various lessons everyone's got here? Is there a role for the OECD here in some sort of what works sharing potential? Anyway.
Christopher, do you want to take up Jeff's first question?
Sure. I think pandemic lesson number 1, and probably the most important overall, was that there is still really valuable research to be done even in a remote setting. In fact, arguably the ODR platform research was well designed for remote conduct, because the whole purpose of ODR is to be remote from the courthouse when dealing with your civil litigation need. We have become much more creative about how to use remote technology in order to reach the communities, and I really wanted to speak to the what works for whom. We can drill in very precisely to the demographic communities that we want to reach. For example, those based on income, those based on employment status, those based sometimes on race or ethnicity. Amazon MTurk allows us to do that with high reliability. We can go into our local community and offer modest incentives to those community members to participate in the research. And I always look at this as a question of, if you want to know whether this innovative idea works, you usually have in mind a community that would make best use of it. And that's for whom it will either work or not. Other grander, even more scalable solutions might reach across communities, but the work that I do tends to already provide the answer. And in these two studies, it was very much households earning less than 70,000 US dollars, which is not very much in 2022, and those who have been through some of these litigation experiences, meaning that they experienced debt, whether commercial or medical in the past. So I think that the technological advances that we've made during the pandemic have made this research even easier to reach the communities that we want to help through these innovations.
Moritz, I'll come to you in 1 second. I think, just, and also connecting the dots between even just different presentations over the course of the day, like Luke's session before the break about outcomes. We need to see those not in isolation, but actually starting to understand, so what can we take from that and build it into what I'm working on or what Christopher's working on or whatever. So I very much think, Jeff, that it'll be a success out of this conference if we do start to share. It will not be a success if we all run home and ignore each other. Moritz.
Yeah, it's great to see how evidence-based working is progressing and entering the field so forcefully. If you look at the example of the healthcare sector, you mentioned this as well, but also corrections and youth care, what works is often shared through treatment guidelines. You could think of treatment guidelines for land problems, for family problems, etc., based on international research and best practices. And you see that these treatment guidelines are independent of the delivery model and the location. So you don't have what works for prosecuting domestic violence in Wales, but you have a guideline for preventing and resolving domestic violence issues. And yeah, in my sense, it's also less connected to policy. It's for the professionals to apply what works in the settings where they work. So my question to the panel is following that example on your mind, what could take us to that next level of what works and evidence-based working?
Adrian, I don't know if you can hear and if you heard Moritz's question, but I'm just wondering, you've thought a lot about this, connecting policy with on-the-ground work. Do you want to just jump in for a second?
Happy to, and I'll clean up a bit by starting to answer Jeff's question before, because they're kind of all interrelated in some way. So, what works to reach communities and different communities is starting with organizations that already have those links. And we tend to work with organizations like that tend to be in civil society. What we found in the pandemic is right away they were playing predominantly humanitarian assistance role in the beginning, either actually helping to provide aid and get aid to different groups, whether even PPE, but also in delivering basic public health messages. And so you begin to see a slightly deformalized, not purely lawyer-based model. It becomes much more embedded in a social ecosystem and justice ecosystem, to take Chris's words. And now about sharing this out, our models are based on sharing for policy and practice use in many different ways. And so I pulled up a chart with a map, and hopefully that got you with all these dots of people in different countries. What we've done is ensure as a first stage, the sharing takes place among practitioners within regions and globally. So it's not just one project, one group learning in their own context, but then trying to distill different lessons that are more general application, whether regionally or even globally. And within that, then it's always about, it's the same way, and I think British Chris, as the way he described, we think about the outcomes right at the beginning. What changes do you want to contribute to? It's difficult to predict But from there, I was thinking about how to get different lessons fit for use, packaging up different findings. And that's a lot about already trying to be in important policy spaces like this one. So we very much have on mind, how can we help to support larger framings and sharing of lessons within not just at national level, but also multilateral levels. And so we're definitely interested in helping feed those discussions. I think having a basic set of common questions is maybe a first step. We're not quite there, but we'll have a shared analytical comparative framework where we can just turn in data. That's maybe a few years off.
Chris, you wanted to jump in as well.
Yeah, thanks for that question. I mean, there's just so much research and work going on out there and on the ground. You know, it's incredible, and we find, especially when we're intervening in things that aren't kind of part of the MOJ system, the early advice space, there is just, you know, the question that we have is, we've got some money to spend. You know, is it a grant? Is it a particular intervention? You know, where do we put it, and what things do we kind of lend to support on as a government department that kind of isn't going to do things in the field, but we can fund and we can support in lots of different ways. And landing on the right thing, you know, is a really big question, and it can be quite uncertain. And the danger is sometimes, I think, that you know, you have a few examples of things that have either kind of been highlighted, or they're the big thing, or they're seen as successful. And it's quite easy to sort of land on those and say, oh, let's expand them, let's kind of make those bigger. But I think we do risk, you know, kind of either missing out perhaps important groups that aren't being targeted by those, or kind of putting all our sort of stock in things that, you know, they may not necessarily be the most effective. So having those sort of landscape assessments at the start of policies and at the start of programs even, you know, that's a really important step. And another thing that I think we're at risk a little bit of losing, you know, when resources get squeezed or we need to deliver quickly. So it is something that, I mean, this is maybe not an OECD thing, but it's a kind of wider evidence gathering thing, that compiling that evidence, although it's a bit sort of boring and it's not as interesting as inventing kind of fancy new methodologies, that stuff is just about compiling what we know, examples of practice. It doesn't necessarily have to be extensive, but just things that you can go and find out more about and prod a bit. You know, there's a lot of value in doing that work, I think.
One of the things that, as we're getting to the close of our session, one of the good news stories, I think, is we have a good example of international cooperation that has made a big difference. And what I'm thinking about is the shift from, the culture shift from provider to user, and more specifically, the legal needs research, right? Over the past decade or so, we've seen from the kind of paths to justice idea, a couple of legal needs studies, to now a collection of international projects, a shared framework through the OECD. You heard from Pasco, others involved, Becky, others who, you know, we've done this work, and now we can sit here today, 10 years later, and tell a story that we actually know how people experience justice to some degree of certainty. It's not perfect, as Becky said yesterday, but it's pretty good. So we can do this. And so what's the next shared agenda? And seeing ourselves in this collective moment. I actually hope that when we look back in 50 years, we can say, wow, that was a really interesting moment in time, and we actually sorted out how to ask that question and move us forward. Because I think unless we do that, we're going to continue to sort of circle around in the dark. And we need to have this moment now. Actually, we needed it before now. And so, for example, taking back from Adrian's presentation or others, where we think of this not in isolation, but in a collective agenda, as though we're putting puzzle pieces together, and we need to start to see that picture. That, to me, is the big success of the OECD lately, and hopefully we can get that energy coming out of this room, because I think it's within our grasp. We've seen it work, but we need to move there. Yeah.
Thank you, and a really interesting discussion. Karthik Sharma, I'm from the International Development Law Organization. And I think it's quite clear there's an emerging body of what works, and there are several successful models that put that into action. My question is around scalability and transplantation. Is there an existing body of research or evidence that kind of indicates why, if something is successful in one context, what are its chances of being successful in a different context. And I say this largely from a selfish perspective because we work in about 30 different countries, very different legal systems, very different constitutions, and often one of the hardest parts is applying the principles into practice. So perhaps that is something for the next part of the research agenda, but if there's something that already exists, I'd be very interested in knowing about it. Thank you.
No, thank you for that. And as I'm just keeping an eye on the clock. We've got 4.5 minutes left in our session, so I think we've got time to take this up. Perfect timing. Christopher, do you want to jump in on that one?
Sure. My view may not be the majority approach, but it is what it is, that scaling up should only be done if the original research behind the results drew from a wide population, a very representative population of that which you're trying to serve. For a lot of reasons related to resource constraints and time constraints, my colleagues and I work with well-defined communities, whether they be based in a particular jurisdiction or types of people. And we, for example, colleagues back at Harvard Law School at the Access to Justice Lab, we have been evaluating pretrial criminal risk assessment instruments that judges can use to help make better objective decisions about how much bail to impose for release. And we've done 4 of these across 3 different states so that the creator of the tool would know if the results are consistent across all those jurisdictions. Now that's pretty good evidence to scale up to the rest of the country. If it's not, then you either need to reform the instrument or keep doing research and analyzing it in other jurisdictions. For me, it's all about how broad the research base is jurisdictionally. And if it's broad enough, then I think it should be invested in and scaled up. Without that broad basis in research, then either more research is needed or it's time to try a different innovation.
And the only other comment I would think about is, you know, speaking as a researcher, one of the things I hear so often is why we cannot do something, why that is not a perfect solution, how we might do something slightly better. And I always agree with that, and yet what we often then end up with is not much. And we often let the perfect be the enemy of the good. And I think we are so far from the perfect right now that I think we do need to explore even the terrible until we get actually to the good and to start doing some of that. So I totally agree that sample size, direction, demographics, all of that stuff is going to be dramatically important. And then thinking that through as we experiment, but starting to experiment and doing more of it so that we can have those studies that we don't have at the moment. With that, what I'm going to do is give 2 minutes back to our next session and thank our panelists, thank the OECD, and thank all of you for an engaging session. Well done.
And we have to mention that the session on towards child-centered justice will take place on the first floor. So, and we stay here for the session on minority communities. So I guess we have a very short break to go to another session, and we continue in a couple of minutes here, not more than 1.
water.
So, good afternoon, everyone. So I hope this is the session for sorry, the exact name. This is a session on indigenous and minority communities and people with disabilities. The next door is the session on child-friendly justice. So I hope you are not mistaken, and I do hope that you are all staying here. So many thanks for joining us in person and online for this discussion. So this is a very broad topic. I mean, it's rather ambitious. So we are going to look at 3 different groups. While many of them share similar vulnerable characteristics when it comes to accessing justice, they do experience their own specific challenges, and within the group themselves, the situation may be diverse. It's also a topic that is challenging. We only have 1 hour, and we will certainly only scratch the surface of these issues and the potential solution that we can bring all together to these challenges. Indeed, each of these groups certainly deserve their own specific session, but also their own dedicated event. And also, importantly, it needs also to include more representativity of such groups around the table. But it's also very meaningful to all regions of the world. For instance, one estimate from the World Bank mentioned that 1 billion people, that is 50% of the world population, experience some form of disability. Indigenous people represent 5% of the population, according to a UN study. That is, in 14 of the OECD member countries, around 40 million people. In many countries, members of ethnic groups face discrimination in accessing justice, either as victims or offenders, and/or are overrepresented in the criminal justice system because of biased social and economic disadvantage, leading to increased distrust in the justice system, and of course, a darker figure of crime and victims. For these 3 groups, access to justice can be significantly hampered by intersectional vulnerability, whether it's gender, social, etc., misunderstanding of their specific legal needs, discrimination, and paternalistic or negative attitude, lack of physical or digital access to justice services or transportation to such facilities. So it is clear that a better and more coherent understanding of their legal needs and of indicator of justice vulnerability is needed to tailor a people-centered justice system. This is especially true with regards to current and future global challenge, whether they are environmental related, pollution, climate change, or health related, of course, where there are significant higher risk of infection or job loss for these groups. So what does a people-centered justice system looks like in the face of these challenges? That is a system that is considerate and responsive to the different vulnerabilities experienced by this group. And I'm here I'm happy to also be tackling this question with a very distinguished panel and to get the conversation started with Mrs. Swati Mehta, Program Director for Pathfinder for Peaceful, Just and Inclusive Society.
Good afternoon, everyone. And thank you, Chloe, Ministry of Justice Latvia and OECD for organizing this event. It has been amazing to meet and hear from all the wonderful people. Before I begin, let me ask a quick question. What group or category of people stay longest in detention without a trial? And I mean legally. Come on. Okay.
I would say indigenous people.
No, actually it is people who have intellectual and psychosocial disabilities, which in the eyes of law renders them unfit to stand trial in criminal cases. And so they are diverted from the criminal justice system, judiciary, so to say, but then are put either in detention or in involuntary kind of detention, and they stay there sometimes throughout their lives. I remember visiting in India one of the prisons in Calcutta, a woman who was there for 26 years without a trial because she was unfit to stand trial. So here is a big injustice in our face, being denied due process guarantees that everyone else enjoys. And that's because of a legal interpretation of whether you should and can stand trial. Let me also start by explicitly acknowledging 2 points that everyone knows but must be said. First, the cause of social exclusion of these groups is not because of their personal impairment, including in the case of people with disabilities. It is a result of social barriers and policies which can be removed and must be removed. Second, as Chloe has already mentioned, indigenous people, minorities, and people with disabilities are a disparate group. Their needs, issues, and challenges are very different and require targeted responses. And women and children within these groups will also have their own unique needs and challenges which must be equally acknowledged and addressed. Having said this, let me quickly look at some of the commonly known challenges that which these very different groups face, and OECD has listed some of these in the sessions note. So indigenous people are overly represented in criminal justice systems, as are minority communities. Indigenous women, like men, face discrimination or racism in the formal system, but are equally vulnerable when they approach indigenous justice systems with entrenched patriarchal norms and prejudices. Not to say that they are not present in the formal system, but somehow informal systems tend to have prejudices against women which are much stronger. Those living with disabilities find it equally difficult to navigate and participate in justice systems. Yesterday we heard at the high-level dialogue Malta's Ministry of Justice raising the pertinent issue of how this immediate COVID-19 induced transition to online court proceedings had an adverse impact on people with hearing and visual disabilities. We've already touched upon those who have intellectual or psychosocial disabilities. In addition to difficulties faced in accessing justice through courts, indigenous people often face greater difficulty to access food and drinking water because of policies which have historically denied their right to control over their natural resources, pushing them further into poverty. They find it more difficult to access public services like health, education, or affordable housing. A 2016 EU Minorities and Discrimination Survey showed that 23% respondents face discrimination in access to housing on the basis of their ethnic group or national origin in the last 5 years. In 2020, a Spanish survey found housing as the area with highest discrimination of all the areas examined. Women in general, but particularly women from indigenous and minority communities, are more likely to be employed in the informal sector, be underpaid, and be overlooked for promotions. They have limited access to social security, healthcare, and education. Only 1 in 10 indigenous girls, for example, complete high school in Latin America, it seems. This is equally true about people who live with disabilities. They find it very difficult to access basic services. So what or how, what will or what has actually worked to address some of these challenges? And these are things that we've been discussing since yesterday. So it's about collecting disaggregated data on justice needs and justice journeys. We've heard enough since yesterday about the importance of justice systems, policies, and services being data-driven and evidence-led. Again, we've heard countries are increasingly conducting legal needs surveys. OECD has provided guidance and tools, as have others. The data collection and analysis must, of course, be disaggregated by gender, disability, ethnicity, age, etc. Second, developing evidence-led policies and systems. So once we have data on people's justice needs and justice journeys, we must use it to formulate evidence-based policies, systems, and services to address those needs and improve justice journeys. For example, we must ensure sign language experts to support people with hearing disability who are unable to participate effectively in court proceedings. We need to ensure diverse methods of communication or other procedural accommodations to ensure that people with disabilities can participate effectively in hearings. And this includes, the latest guidance is that people who have psychosocial and intellectual disabilities, they should be able to participate in trial with specific and special accommodations. Or if data shows that a huge majority of people are not going to courts, as is the case in most contexts, to resolve their problems, we need to engage with and strengthen existing alternate justice systems, which might be indigenous or informal justice systems. Third, we need to innovate and partner to reach all people. Clearly, and we've heard this enough, justice budgets are limited. And the demand for data collection, analysis, and targeted solutions can be expensive. But what is needed is a more effective and efficient use of existing resources, again, based on data and evidence. Instead of conducting standalone surveys, we could add relevant questions to existing surveys which other departments might be undertaking. You can innovate. How do we best prevent or resolve problems? And we heard about strategies in the previous session. We know by now that one-stop service centers work, paralegals work, community dispute resolutions can be rolled out to better support people in accessing justice. Partnering, again, this is something we've been hearing since yesterday. Justice ministries or judiciaries alone cannot prevent and resolve all justice problems. We need to partner with other sectors, learn from them, and work with them to provide effective solutions. Justice actors must partner with health, education, welfare sector, and with ombudsman offices, as well as with civil society. Prevention. Justice sector by its nature is proactive, reactive rather. Someone comes to us with a problem, we say, okay, let's try and solve it. Can we do more on prevention? Excuse me. Can we examine our existing administrative data to find most common grievances or problems in accessing justice? The data may not only lie with courts and ministries of justice, but with ombudsmen's offices or grievance redressal cells in other government departments. We can find trends and patterns to prevent commonly occurring problems. Empower people and be outcome-oriented. Looking beyond processes is very important. Again, as lawyers, we are very process-oriented. it's not only about ensuring appropriate laws, legal awareness, independence of judiciary, providing legal aid or training. Of course, all of that is very important. We must, for example, change laws where needed. It's amazing to note that about 75.9% countries now have laws on domestic violence, or 86.5% of them have laws on sexual harassment. Countries like Jordan have enacted laws to prohibit discrimination and incorporate duty to provide reasonable accommodation for people living with disabilities. They've also made efforts to include people with disabilities in education settings. Sierra Leone this year passed a law requiring free prior informed consent from communities in cases where companies are going to perform any mining, industrial, or farming activities. The law also provides women with equal rights in a context where often women lose rights upon divorce or death. We know about the Latin American Escazú Agreement, which is the first regional environmental treaty which guarantees full and effective implementation of the right of access to environmental information, public participation in environmental decision-making process, and access to justice in environmental matters. Yet, important as legislation is for signaling change, it is often not enough. This is equally true about training, providing legal aid, etc. We must continue to monitor and see whether all of this is leading to fair outcomes for people. If not, something needs to change. And often people know best what this change should look like. And that was a point which was made by the professor from Arizona. Partner with people and listen to them. To conclude, I would like to emphasize and highlight and draw attention to discrimination faced by these groups of people, both explicit and implicit in our laws and in our interpretation and application of laws. And there are by now many ways known of addressing bias, whether it's training, it's representation in justice sector. But what still does not get sufficient attention by policymakers is divisive narratives, and how this age of social media is playing a role in magnifying these narratives of the other. Others who are lazy, drug addicts, criminals, dependent on government doles, living off taxes paid by hardworking ordinary people and taking away our jobs and opportunities. As the UN Secretary General notes in his common agenda, building trust and countering mistrust between people and institutions, but also between people and groups within societies is our defining challenge. One of the key challenges for those implementing policies to reduce inequality, exclusion, and injustice is building a strong narrative and communicating progress in ways which resonate with people and bring them together rather than pit them against each other. These narratives are key to counter increasingly popular discourses of division and prejudice that not only divide people, but also hinder progress on laws such as those which allow positive discrimination, or policies which call for greater investment in affordable housing or debt forgiveness, or mandate higher taxes for the rich. I will end here. Thank you.
Thank you very much, Swati. Thank you also for spelling out some of the issues and also some of the potential solution looking forward. Next, I would like also to invite Mrs. Lara de Rame, if she's online. She's the Policy and Program Specialist, Rule of Law, Security and Human Rights at UNDP. And we're looking forward to hear about the UNDP approach to leave no one behind when it comes to access to justice.
Thank you very much, Chloe. Can you hear me well?
Yes, we can.
Thank you. Thank you so much for inviting UNDP. I really appreciate the opportunity. So thanks to the organizers, the OECD, and of course the Ministry of Justice of Latvia. Thank you also, Swati, for your initial presentation that's kicking us off very, very well in this very important conversation about inclusion and the central pledge of Agenda 2030 to leave no one behind. For UNDP, the principle of leaving no one behind is at the heart of everything we do. In the UNDP newly adopted strategic plan, inclusive rule of law systems and access to justice remain a key area of work. To close the justice gap and address inequalities inhibiting sustainable development, we apply human rights-based approaches and we mainstream gender consideration through all our policy and programming efforts. For us, we have the global program for strengthening the rule of law and human rights, where access to justice is part of an integrated offer on rule of law, human rights, and security that we believe are all essential components for a strong social contract. So some recent developments include the new phases of the new phases of our global program that embeds most of the work that we do in this area of access to justice, especially for crisis settings and fragile contexts. We have explicitly adopted people-centered approaches as one of our guiding principles, along with, of course, human rights and gender equality. And we also decided to put a stronger investment on monitoring, evaluation, and learning for these new phases. We also created the Justice Collab. Some of you already heard about it. We launched it at the World Justice Forum. And the objective is really to try and better address the complex justice issues of today. We've heard about another collab earlier, and I think maybe we should join forces, but there is so much to think about. We listening to other presentations, I think we can all agree that access to justice is a really complex challenge. What we'd like to do with the Justice Collab is become better at understanding and learning, and better at developing innovative solutions and strategies that work, and then after we test them, produce and diffuse knowledge and inform quality programming and policy making for UNDP, but also beyond. So we have some specific initiatives that were launched with this Justice Collab. We have the e-justice initiative that I'm not going to talk in detail, but how can we also use technology as a potential to advance inclusion and accessibility, with some examples in some countries targeting specifically people with disabilities. We developed the environmental justice strategy, where justice for indigenous people and local communities is really a key priority. I also would like to mention the Gender Justice Platform that was launched in partnership with UN Women, and that will help us address the gender justice gap. About that, I'd like to give this example of a study that is ongoing, but I think almost ready to be published, about women in the judiciary in Africa, that will come up with some recommendations to make justice systems more inclusive. It's just an example of a recent work. But at UNDP, and I think it echoes also what Swati was saying before, we believe that a broader vision of access to justice is needed. It is, of course, absolutely critical to ensure indiscriminate access to courts, but access to justice is not only about bringing people to the court. It's about promoting the rights of those most at risk of being marginalized, those in the most vulnerable situations, and try to meet their unique specific needs with every development initiative. So I absolutely agree that it's critical to look at prevention. And I'll give you an example for UNDP, because you know that UNDP is a development agency, so we work on justice and the rule of law, but we have a broader framework of intervention. And we have, for example, a guidance note on disability and inclusion that is meant for the whole organization, and that is meant to guide the work in all areas. And of course, there's a chapter dedicated to access to justice and human rights. So I just want to quickly touch on the different strategies that we use. So some were already mentioned, like building the capacities of formal and informal justice actors and institutions. Focus on legal empowerment, of course. It's really important to recognize people as agents of change with valuable knowledge and experiences, and thinking of people with disabilities, some experiences where they are, because they are the best placed to explain what can work or not work for them when it comes to accessibility, for example. So really important to ensure that they are part of the solutions that we design. Other strategies is support national human rights institutions. UNDP supports national human rights institutions in over 100 countries to implement their mandate to protect and promote human rights for all. And of course, support law and policy reform in alignment with international human rights standards and principles to strengthen the protections and to prevent or address discrimination practices. So I have some concrete examples very quickly because we don't have time, but we can come back to some of them if interest. So in the Kyrgyz Republic, we have supported national efforts to improve access to justice, the quality of state-funded legal aid, by opening additional legal aid centers to promote legal empowerment across marginalized groups, and that included women and people with disabilities. In Argentina, we have been supporting indigenous women to empower themselves so as to become environmental monitors, and that so that they could raise their voice in the governance of lithium mining, which is a critical mineral for the low carbon transition. And I just want to mention here, we had really a strong statement by indigenous women telling us that they really need support. They need more support because sometimes they, so what, if we want them to participate and to meaningfully participate in those processes, they also need to be equipped. It's not only about bringing them to those platforms, it's also important to make sure that we equip them with the necessary information and capacities and skills to be able to represent themselves and their communities. Another example is support to the Human Rights Commissions in Zimbabwe, where to support them to carry out human rights monitoring in prisons, and to support persons with disabilities, and also take them to districts with high levels of people with displaced people, and then come up with concrete recommendations for the government. And one last example, the support to undertake legal environment assessments in more than 30 countries to review how the law and policies help or hinder the response to HIV and other health issues, and develop recommendations. And this work, for example, has contributed to repeal a law criminalizing unintentional transmission of HIV in Mozambique. It also has helped decriminalize consensual same-sex conduct in the Seychelles. So these are just, you know, a little bit of examples to show that the variety of interventions that can be conducted to support in prevention of exclusion and discrimination. I'm happy to provide more information on some of these examples. As a conclusion, I just, of course, want to say that access to justice is indispensable for combating inequality and exclusion, and delivering on the promises of the 2030 agenda, and that still a lot needs to be done. As we all know, we need to continue to collectively invest, and especially in this critical current context. So I'll stop here, but looking forward to the conversation. Thank you.
Many thanks, Lara. And indeed, it's important to have the conversation after, and I really want to thank you and Swati for already setting the scene and sharing this broader and practical initiative. But now it's important to dig in country experience. And for that, I also invite Mr. Antonio Ruiz Balón from Peru. He's the advisor in the cabinet of the Vice Minister of Justice. Can you hear us?
Okay, thank you. Thank you, everybody. And to begin with, I want to thank the organizers of this event, both from OECD and the Ministry of Justice of Latvia, for inviting Peru to participate in this activity of such importance. It's an honor for the Peruvian state to participate, learn, and bet together with all of you to improve access to justice. And I'm here in representation of Jimmy Quispe, the Vice Minister of Justice in Peru. Just to give you a little context before my presentation, as you know, Peru is a post-colonial reality, and at the same time, it's a republic responsible for its destiny, which struggles to take seriously the pragmatic establishment of democracy and the rule of law. But the context in which the ideals of Peruvian state are based can be understood only if one takes into account its geography. That is, let me share my presentation. Sorry.
Is it coming up? Perfect. Thanks you.
Now, is there?
Yes, it is.
Okay. So at the end. So this is a country that some historians call a crumpled paper because of its geography. And it's for sure also a country with a diverse cultural situation where you have almost 25% of Peruvians are considered itself like indigenous people. In global terms of speakers, we are 83% Spanish speakers, 30% Quechua speakers, 1.7% Aymara, and 0.18% use Amazonian languages. Naturally, in this geographical and cultural diversity implies a serious challenge for access to justice in our country, where the Service of Public Defense or free legal representation for citizens in courts is in charge of the Ministry of Human Rights, of Justice and Human Rights. This services is not only for people of limited resources who have been denounced or accused in criminal proceedings, but it extends to victims of family violence, sexual violence, human trafficking, immigrant trafficking, food claims, among others. In a state ideologically forged and historically forged as monocultural, the barriers to access to justice for indigenous citizens are greater than for the Spanish-speaking majority, 83%, and are accentuated in case of women. For indigenous people in general, we can say that barriers to access are associated with economic, geographical difficulties, and linguistic and cultural difference with the official system. Although the state recognized the diversity of languages since 1979, Constitution materially, the efforts to reflect the recognition have become relevant in the last 20 years. The public defense services, since the end of the first decade of this century, developed efforts to have lawyers who could give attention in native languages. It was only in November of 2020 that the formation of teams of public defenders in indigenous affairs has been officially arranged, which serve in 10 regions of the country. As in other parts of the world, many indigenous territories in Peru are located in areas where mining or oil extraction takes place, a context in which various social conflicts are generated. Traditionally, these conflicts were understood to be resolved from a repressive point of view with a return of extractive activity. However, with the passage of time, it has become evident that demands of the population usually go beyond the problem itself to cover demands for basic social care like drinking water, electricity, roads, or judicial offices. Also, collateral issues are related to social peace as emblematic judicial processes or even humanitarian judicial attention or legal attention. We have 60 public defenders in indigenous affairs distributed in 10 localities, as I told you. And to carry its function, in June of 2021, the norm that regulates the attention with an intercultural approach of the public defense services was approved. The importance of this instrument is that it has allowed the incorporation of the ethnic variables of indigenous original people and indigenous original language. In this way, 3 data sheets were established: registration of cases, referral of cases, and attention to the user. In this way, users who self-identify with the aforementioned peoples and or their languages can be identified, making them visible and strengthening their citizenship. Likewise, in the Central Jungle region, we also have a forensic anthropologist in charge of carrying out anthropological surveys that contribute to defense of indigenous citizens, and we know that's not enough like a service. Finally, as many of you may also know, Peru is one of the countries where indigenous leaders who defend human rights and environmental rights in their localities have been allegedly being murdered by organized crime mafias linked to drug trafficking, illegal lodging, illegal mining, or some organized crime forms. Faced with this situation, in April 2021, a protection instrument was approved with a different intervention of the pieces of the state, and includes legal assistance services provided by public defenders. And I want to talk about Reviesfo. Reviesfo is a register of victims of forced sterilizations. This is an interesting experience in Peru, I think, and I want to share with you. As is known, the barriers to access to justice are especially intense when it comes to indigenous women who suffer family or sexual violence. In many cases, they have nowhere to turn, or it's very difficult to get there, and when they arrive, officials tend to believe that the violence is their fault, or even they deserve the violence they suffer. One of the most notable cases in this regard has been that of the forced sterilizations that were carried out between 1996 and 2000. In this period, the demographic control campaign was implemented in Peru, and in order to reproduce poverty levels for which between 200,000 and 300,000 women, mostly indigenous and poor, would have been sterilized by force or against their will. The demands for justice for these facts date back to approximately 1997. However, they were never welcomed into the justice system. But in 2015, under a new political context, the executive branch ordered the creation of Reviesfo, an administrative registry for those who reported being victims of these events, to make available services of public defenders to file the corresponding lawsuits. In some way, this registry, which seeks to identify a universe of victims along this time, has served as an instrument of public advocacy and promotion of the right of access to justice in favor of victims, as far as the executive branch is responsible, and has brought fruits. The registry has offices in 18 locations of the country. Since January of 2016, it has 6,958 people registered. We have 137 public defenders participate in this in this organization, and of these, 125 are skilled in Quechua and 8 in Aymara. They are distributed through all the territory, and they are representing around 2,150 people in tribunals. They are representing all that number of people in front of tribunals. And the most important, for the first time in March of this year, a judge has decided to open an oral trial in this case. And in addition, there are 3 investigations open in public ministry. For sure, the investigations in public ministry are old and before and previous from the previous experience. It would be unfair say that this is just the work of the state. It has behind the support of many women organizations from the civil society. But I think it's interesting to consider that the registry persists in 3 different governments of different sign, very different sign. So maybe some valuable awareness is in the functionaries nowadays in Peru. So that's all that I want to share with you, and thank you.
Thank you very much, Antonio. This was very interesting to also hear about how it's going on in Peru, and also the solution that you're bringing, and very recent, and trying to also look back to past issues that are still lingering for the victims. Next, I would like to invite Damaris Vargas Vegas, thank you, from Costa Rica. She is the coordinator at the Subcommittee for Access to Justice for Persons with Disabilities and Indigenous People at the Judiciary of Costa Rica. We will have consecutive interpretation, I understand, so please, I'll leave you the floor.
Adelante. Muchas gracias. Muy buenos días a todos y todas. Gracias a la OCDE por invitar al Poder Judicial de Costa Rica a este importante evento y permitirnos mostrarles las acciones más importantes desarrolladas, la ruta a seguir y sobre todo gracias por aprender de sus buenas prácticas e investigaciones.
Good morning, and thank you. I would like to thank OECD for inviting us to this very important event, the Judiciary Power of Costa Rica, and for allowing us to all share the most important actions developed, the roadmap to follow, and especially thank you for allowing us to all learn from each other the best practices and also the research.
Costa Rica es una república democrática, libre, independiente, multiétnica y pluricultural. Así reza el artículo 1 de nuestra Constitución Política.
Costa Rica is a democratic, free, independent, multi-ethnic, and multicultural republic. This is what Article 1 of our political constitution states.
El Poder Judicial de Costa Rica incluye en su organización la Judicatura, jueces y juezas, la Fiscalía, Defensa Pública, Organismo de Investigación Judicial, que es la Policía Técnica Judicial, y el ámbito administrativo.
Costa Rica's judicial branch includes in its organization the following. Number 1, the judiciary, which are the judges. Number 2, the prosecutor's office. Number 3, the public defense. 4, the judicial investigation agency, which is the judicial technical police. And 5, the administrative scope.
En el marco del Objetivo de Desarrollo Sostenible 16 de la Agenda 2030, el Poder Judicial incluye en el Plan Estratégico Institucional 2019-2024 como eje transversal el acceso a la justicia y la equidad de género, acorde con la visión de una justicia con rostro humano.
Within the framework of SDG 16 of the 2030 Agenda, the judicial branch includes access to justice and gender equality as one of the strategic issues in the Institutional Strategic Plan 2019-2024, in accordance with the vision of justice with a human face.
De igual forma, la jurisprudencia de la Sala Constitucional de la Corte Suprema de Justicia, la cual es vinculante, establece que los convenios internacionales de derechos humanos, entre los que se encuentran los relacionados con los derechos de los pueblos indígenas y las personas con discapacidad, entre otras poblaciones en situación de vulnerabilidad, son supraconstitucionales, en tanto otorguen más derechos que la Constitución política.
Similarly, the jurisprudence of the Constitutional Chamber of the Supreme Court of Justice, which is binding, establishes that international human rights conventions, including those related to the rights of indigenous peoples, persons with disabilities, and other populations in vulnerable situations, are supra-constitutional as long as they grant more rights than the political constitution.
A fin de cumplir con las convenciones internacionales de derechos humanos, el Poder Judicial aprobó el desarrollo de los proyectos Política de Acceso a la Justicia de Pueblos Indígenas y Política de Acceso a la Justicia y Equiparación de Oportunidades de Personas en Situación de Discapacidad en co-construcción con esas poblaciones.
In order to comply with international human rights conventions, in accordance with the model of people-centered justice, the judiciary approved the development of the projects Access to Justice Policy for Indigenous Peoples and Access to Justice Policy and Equal Opportunities for People with Disabilities.
Se parte de la premisa de que el acceso a la justicia no es solo un derecho en sí mismo, sino un derecho habilitante, en el sentido de que permite a las personas hacer valer sus derechos sustantivos y obtener una reparación cuando esos derechos son violados, según lo ha señalado la Agencia de los Derechos Fundamentales de la Unión Europea.
It is based on the premise that access to justice is not only a right in itself, but an enabling right in the sense that it allows people to assert their substantive rights and obtain redress when these rights are violated, as stated by the European Union Agency for Fundamental Rights.
El pilar 1 del modelo Justicia basada en las personas de la OCDE se asocia al diseño y prestación de servicios centrados en las personas. En atención a este, el Poder Judicial ha dispuesto el diseño, establecimiento y mantenimiento de la prestación de servicios de justicia, identificando previamente las necesidades de justicia de estas poblaciones y sus requerimientos a fin de garantizar que los servicios sean accesibles.
In accordance with Pillar 1 of the OECD Justice Model, which is people-centered justice, associated with the designing and delivering people-centered services for the design, establishment, and maintenance of the provision of justice services, the judicial branch has been identifying the justice needs of these populations and their requirements to ensure that services are accessible.
En relación con el pilar 2, facilitadores de la gobernanza e infraestructura, conforme al cual se requiere el establecimiento de sistemas de justicia accesibles que aseguren que las necesidades de justicia de los ciudadanos se aborden de manera efectiva, el Poder Judicial ha emitido lineamientos que garantizan la co-construcción de la política de acceso a la justicia, tanto los pueblos indígenas como las personas con discapacidad, y la implementación del mecanismo de consulta a estas poblaciones.
In relation to Pillar 2, governance enablers and infrastructure, according to which the establishment of accessible justice systems is required to ensure that the justice needs of citizens are effectively addressed, the judiciary has issued guidelines that guarantee the co-construction of the access to justice policy for both indigenous peoples and persons with disabilities and the implementation of the consultation mechanism.
De esta forma se establece su participación en la gobernanza, se fomenta el acceso a la tecnología y los datos y se impulsa la simplificación del sistema de justicia, manteniendo la innovación centrada en las personas.
This will establish their participation in governance, promote access to technology and data, and drive the simplification of the justice system while maintaining people-centered innovation.
El pilar 3, empoderamiento de las personas, se centra en la importancia de fortalecer las capacidades de las personas en ambos lados del sistema de prestación de servicios de justicia. El Poder Judicial ha venido empoderando a los pueblos indígenas y a las personas con discapacidad, aumentando sus conocimientos en el sistema de justicia y en el codiseño de los servicios de justicia para actualizarlos conforme a sus verdaderas necesidades, creando así un clima de confianza y transparencia en la gestión institucional.
Pillar 3, People Empowerment, focuses on the importance of strengthening the capacities of people on both sides of the justice delivery system. The judiciary has been empowering Indigenous peoples and persons with disabilities by increasing their knowledge of the justice system and the co-design of justice services in order to update them according to their real needs, thus creating a climate of trust and transparency in institutional management.
De igual manera, se está incidiendo en fortalecer las competencias de las personas servidoras judiciales sobre la cosmovisión de los pueblos indígenas y la situación y requerimientos especiales de adaptación de las personas en situación de discapacidad.
Likewise, efforts are being made to strengthen the competencies of judicial employees regarding the worldview of Indigenous peoples and the special situation and requirements of persons with disabilities.
Finalmente, el pilar 4, planificación, seguimiento y rendición de cuentas, que gira en torno al papel de los datos de justicia para establecer y mantener mecanismos basados en evidencia para apoyar la toma de decisiones, la prestación y el seguimiento de los servicios de justicia centrados en las personas, ha servido de guía al Poder Judicial de Costa Rica en las actividades de rendición de cuentas a las poblaciones, los mecanismos de control y denuncia y además en la construcción de las bases de datos y gestión documental transparente que contribuye a la toma de decisiones y que esté siempre al alcance de los pueblos indígenas y de las personas con discapacidad, lo mismo que otras poblaciones en situación de vulnerabilidad o vulnerabilizadas.
Finally, Pillar 4, Planning, Monitoring, and Evaluation, which revolves around the role of justice data in establishing and maintaining evidence-based mechanisms to support decision-making, delivery, and monitoring of people-centered justice services, has guided the Costa Rican judicial branch in its accountability activities to the population, control, and complaint mechanisms, and also is in the construction of databases and transparent document management that contributes to decision-making and is always available to Indigenous peoples and persons with disabilities, as well as other vulnerable populations.
Estas son algunas de las buenas prácticas desarrolladas por el Poder Judicial de Costa Rica que promueven un enfoque centrado en las personas para el desempeño del sistema de justicia, a fin de garantizar el acceso equitativo a la justicia para todos y todas y satisfacer las necesidades legales y de justicia de la sociedad, respetando el Estado de Derecho, el trato justo, la protección de los derechos fundamentales, servicios inclusivos y apropiados y la independencia judicial en el marco de los altos estándares internacionales de los derechos humanos de las poblaciones en situación de vulnerabilidad con enfoque de género.
The above are some of the best practices developed by the judiciary of Costa Rica that promote a people-centered approach to the performance of the justice system in order to ensure equal access to justice for all and meet the legal and justice needs of society, respecting the rule of law, fair treatment, protection of fundamental rights, inclusive and appropriate services and judicial independence within the framework of the high international standards of the rights of vulnerable populations, with a gender approach.
¿Cómo se materializa esa justicia centrada en las personas en la población indígena de Costa Rica?
How does this people-centered justice materialize in the indigenous populations of Costa Rica?
De los más de 5 millones de habitantes, Costa Rica cuenta con más de 104,000 personas indígenas pertenecientes a 8 pueblos: Bribris, Cabécares, Malecus, Chorotegas, Huetares, Noves, Runcas y Térrabas. De esos pueblos, 36,000 aproximadamente habitan en 24 territorios indígenas. Cada pueblo tiene su propia cosmovisión y todos contribuyen a la diversidad y riqueza de la civilización y cultura de Costa Rica.
Of the more than 5 million inhabitants, Costa Rica has more than 104,000 indigenous peoples, belonging to 8 different groups: the Bribris, Cabecares, Malecus, Chorotegas, Huetares, Ngaves, Bruncas, and Terrabas. Of these peoples, approximately 36,000 live in 24 indigenous territories. Each group has its own worldview and all contribute to the diversity and richness of Costa Rica's civilization and culture.
No obstante, presentan importantes rezagos en diferentes áreas en comparación con el resto de la población. Solo el 40% de los indígenas tiene acceso a agua potable, mientras el alcance nacional es del 90%. Asimismo, apenas el 67% de la población indígena tiene acceso a la electricidad, pero el 99% de toda la población sí lo tiene, entre otras barreras que deben superarse mediante acciones estatales, entre ellas el fortalecimiento del acceso a la justicia.
However, they lag behind the rest of the population in several areas. Only 40% of indigenous people have access to drinking water, while the national coverage in Costa Rica is 90%. Likewise, only 67% of the indigenous population has access to electricity, but 99% of the entire population does, among other barriers that must be overcome through state actions, including strengthening access to justice.
Por ello, el Poder Judicial ha venido estableciendo lineamientos asociados al acceso a la justicia de los pueblos indígenas en atención al Convenio 169 de la Organización Internacional del Trabajo y demás instrumentos internacionales de derechos humanos, a saber, la asignación de personas defensoras públicas, especialistas en derecho indígena pagadas por el Poder Judicial para atender la defensa de las personas indígenas y sus organizaciones.
For this reason, the judiciary has been establishing guidelines associated with access to justice for indigenous peoples in accordance with ILO Convention 169 and other international human rights instruments, namely the assignment of public defenders specialized in indigenous law paid by the judiciary to defend indigenous people and their organizations.
Además, el pago de traductores a cargo del Poder Judicial y traductoras para las mujeres indígenas, el pago de peritajes culturales antropológicos para determinar la cosmovisión de sus pueblos, la atención prioritaria de los procesos judiciales de esa población, la realización de audiencias en los territorios indígenas con horarios concertados con esas poblaciones, ayudas económicas, uso del lenguaje claro y sencillo, entre otras.
Also, this includes payment for translators for the women, the payment of anthropological cultural expertise to determine the worldview of indigenous peoples, priority attention given to the judicial processes of these populations, the holding of hearings in indigenous territories with agreed upon schedules, economic aid, the use of clear and simple language, among other things.
De manera más reciente se desarrolla bajo mi dirección el proyecto de política de acceso a la justicia de pueblos indígenas, aprobado por Corte Plena, jerarquía máxima del Poder Judicial, con el objetivo de ofrecer a la población indígena una justicia acorde con sus necesidades reales y a su cosmovisión.
More recently, under my leadership, the Indigenous Peoples Access to Justice Policy Project was developed, approved by the plenary court, the highest hierarchy of the judiciary, with the objective of offering the indigenous population a justice system in accordance with the real needs and their worldview.
El proyecto se desarrolla en co-construcción con los pueblos indígenas y el producto que se genere será objeto de consulta a esos pueblos indígenas del país conforme al mecanismo de consulta indígena elaborado por el Poder Ejecutivo, el cual fue consultado previamente a dichos pueblos y será adaptado al Poder Judicial a fin de respetar los principios de separación de poderes y de independencia judicial.
The project is being developed in co-construction with the indigenous peoples, and the output generated will be subject to consultation with the indigenous peoples of the country in accordance with the indigenous consultation mechanism developed by the executive branch, which was previously consulted with them and will be adapted to the judicial branch in order to respect the principles of separation of powers and judicial independence.
El desarrollo de la política cuenta con la cooperación internacional del Sistema de Naciones Unidas mediante el proyecto EPU, con el objetivo de garantizar el desarrollo de manera acorde con los altos estándares internacionales de los derechos humanos de los pueblos indígenas y la atención, entre otras, de las recomendaciones del examen periódico universal y el principio de no dejar a nadie atrás, piedra angular de los objetivos de desarrollo sostenible.
The development of the policy has the international cooperation of the United Nations system through the UPR project, with the aim of ensuring development in accordance with the high international standards of the rights of indigenous peoples and attention, among others, to the recommendations of the Universal Periodic Review and the principle of no one left behind, a cornerstone of the Sustainable Development Goals.
La política se ejecuta con enfoque de género, atendiendo las voces de las mujeres indígenas y sus particularidades en atención con las demás personas integrantes de esa población, tomando en cuenta su cosmovisión y sus mecanismos de resolución de conflictos.
The policy is implemented with a gender approach, taking into consideration the voices of indigenous women and their specific needs in relation to other members of this population, respecting their worldview and their conflict resolution mechanisms.
Pero ¿cómo lo estamos haciendo? Con una metodología participativa en las etapas de diagnóstico, consulta, ejecución y seguimiento. Para la etapa de diagnóstico nos reunimos con las diferentes organizaciones de los 24 territorios, entre ellas las asociaciones de desarrollo indígena, consejos de mayores, consejos de ancianos, asociaciones de mujeres, recuperadores de tierras, asociaciones educativas y culturales, dándoles a conocer los alcances del proyecto e invitándoles a participar. Todos estuvieron de acuerdo.
But how are we doing this? With a participatory methodology in the stages of diagnosis, consultation, implementation, and follow-up. For the diagnosis stage, we met with the different organizations of the 24 territories, including the Indigenous Development Associations, the Councils of Elders, women's associations, land recoverers, educational and cultural associations, informing them of the scope of the project and inviting them to participate. They were all in agreement.
Damaris, sorry, it's just we are running out of time. We still have one presentation, and it would be nice also to open the floor for questions. So if you don't mind, like I have concluding remarks, and then we can go to the next presenter. Because it is fascinating. As mentioned, we are very limited in time as well, and we will continue the conversation at other events. Well, thank you.
Si nos permiten, concluimos en 2 minutos.
Adelante, sí.
Gracias. El enfoque, la situación particular de las mujeres indígenas se ha abordado con encuentros direccionados con esta población en particular, atendiendo las recomendaciones del relator de los derechos humanos de las Naciones Unidas, que enfoca especialmente qué debe hacer el Poder Judicial de Costa Rica.
Okay, so the gender approach that characterizes the actions of the judiciary has led the Indigenous Peoples' Access to Justice Policy project to address the needs of Indigenous women. Likewise, the Rapporteur on Indigenous Human Rights recently issued a report giving recommendations to the state and specifically to the judiciary for the adequate attention for Indigenous women according to their particular circumstances in order to guarantee them access to justice.
En relación con la población en situación de discapacidad, igualmente estamos desarrollando la política de acceso a la justicia de pueblos indígenas.
In order to the population of people with disabilities, we are also working in the project on access to justice and equal opportunities for Indigenous peoples.
Esta política la estamos desarrollando en co-construcción con esa población. Estamos además reservando al menos el 5% de las plazas vacantes para que sean ocupadas por personas en situación de discapacidad mediante concursos especiales.
In compliance with international regulations, we are also every year reserving 5% of the vacant positions to be filled by persons with disabilities through special recruitment processes.
El producto de la política que se genere en los encuentros será consultada con las personas en situación de discapacidad y sus organizaciones.
The output of the policy generated from the meetings will be consulted with the group of the disabled persons and taken into account their considerations.
En síntesis, necesitamos escuchar las voces de los pueblos indígenas en sus territorios, de las personas con discapacidad, según sus propios requerimientos, y de todas las poblaciones en situación de vulnerabilidad para poder seguir el camino correcto, haciéndolas parte de las soluciones.
We need to hear the voices of the people with disabilities and the indigenous peoples in their communities, and we need to make them part of the solutions as well.
Thank you very much. That's very important indeed, and yes, it is what we're missing here, and we hope that we definitely will extend the invitation to such representatives. Finally, I would like to invite Daniel Hirsch, Interim Director of Court Services in the U.S. National Center for State Courts, who will share the latest initiative of the Center to promote justice for minority communities, including both internal and external changes necessary. Thank you very much.
Thank you very much for having me, and I'm so delighted to be included. I'd like to limit my remarks to kind of three topics within the larger topic of minority rights within the United States. The first is to acknowledge an overview of why this is so important in the United States. The second is, as Chloe mentioned, to talk a little bit about the different kinds of strategies that state courts across the United States need to employ. And then I'd like to leave with a number of examples of what courts have done within the United States to begin to tackle this important issue. So first, a few overarching comments. The first is that I work for the National Center for State Courts, which is a nonprofit that is the Secretariat of State Supreme Courts across the United States. We have to recognize our painful history as it relates to Native communities and people of color, especially the Black community and the history of slavery within the United States. Secondly, the importance of acknowledging the differences between equality and equity and striving for equity as much as possible, especially given our history. So the way that I like to think about it is equality is that each person or group of people is given the same resources or opportunities, but equity is really recognizing that people have different circumstances and that we need to give people different resources in order to result in the same outcome. The third thing is to acknowledge that in 2020 and 2021, the United States had a moment of racial reckoning. It was started with the murder of George Floyd, Breonna Taylor, Ahmaud Arbery, and others. But we need to maintain momentum, and that this conversation is difficult, this work is hard, it requires sustained, often very painful conversations, and that across the United States there has been a growing backlash to having some of these difficult conversations, but we must continue to do it. Courts sit at the intersection of society and often experience and enforce societal problems beyond the courts themselves, whether that's policing, poverty, lack of affordable housing, or immigration enforcement, especially in state courts during the Trump administration. And we need to be cognizant of how all of those things affect the court system as well, but that there is a role for state courts as a community partner, and that courts, by their very function, must address public trust and confidence and ensure that they are acting with as limited amount of bias and disparate treatment as possible. So in light of all of that, I'd like to move quickly to talk about some of the strategies that state courts across the United States, and I would argue across the world, need to think about. The first is, as Chloe mentioned, to think about some of the internal things that court systems need to think about to fulfill the mission of racial equity. First is really thinking about who are our leaders, who are our members of the bar, who practices law in a particular state. and also who are our judges, and to ensure a pipeline to attract diverse talent to go to law school, to pass the bar, to practice law, and to become judges. If our judges aren't reflective of the community that they serve, there's a fundamental disconnect, and we can and should do better. As one concrete strategy, the National Center for State Courts has launched a new program, which for those of you who are familiar with the US federal court system is an analog to OSCAR, but a way to make possible and share information about internships, externships, and law clerkships in state courts across the country, to make available all over the country so that it is more transparent how to get engaged with the court system and hopefully to apply for those pipeline jobs into the system. We also desperately need to continue to collect more data about who our members of the profession are, who our judiciary are, in terms of demographic information, as well as actually outcomes of what happens in the court system. And we need to be sharing that information, even if it's painful and uncomfortable. And then the fourth bucket within this internal court-focused lens, I think, is to increase our training for court staff and judges on implicit bias, procedural fairness, and empathy, all of which are vitally important for courts to live up to the public trust and confidence that is so vital to our success. And then as it relates to courts externally in the community, I think there are a whole bunch of strategies that we can and are employing, whether that's listening sessions with people within the community partnerships and engagements, research with academic institutions to talk about the effects of court interventions on people's lives, whether that's relating to failures to appear that lead to driver's license suspensions or bench warrants, criminal justice work or behavioral health or anything else. Peer mentors so that people have trusted adversaries within the community, continued training and safe spaces to discuss complicated topics like this. And I would argue remote hearings also allow for increased engagement in meeting people where they are. Finally, as promised, I wanted to give a couple of really concrete examples of way courts across the United States have begun to implement some of these strategies. So in no particular order, here are 9 examples. The first is in Michigan. The court system worked collaboratively with the legislative branch of government as well as the governor's office to take a hard look at the data of who was in the jails within Michigan and to advocate for driver's license suspension reform and really thinking critically about the pipeline into jail as it relates to court intervention and to do something about it. In a similar vein, in North Carolina, the court system partnered with the Pew Charitable Trust to do really hard work to think again through the jail population, but what are the barriers that people, especially people of color, have in coming to court, and found a huge percentage public transportation was negligible. And so partnering with rideshare groups to make available opportunities for people to come to court when it's purposeful and necessary. In Birmingham, Alabama, the local municipal court has implemented an amnesty program to try to get people to come back into court and to deal with low-level traffic and misdemeanor offenses in a supportive and comfortable way on people's own timelines. In Salt Lake City, the court system has taken court to kayaks and taken truly the ethos of court as a system, not a place, and brought the court to the high-level people who aren't coming to court for various reasons. In New Mexico, they've launched a peer mentoring program in child welfare cases so that parents undergoing child welfare hearings are paired with a family who's gone through a similar situation to try to understand what is happening and to have a support system. In Delaware, the Delaware Supreme Court took a hard look at the racial diversity of its bench and bar and has implemented hard and important reforms looking at everything from what is the admission to the bar process to what kind of pipeline programs need to happen in elementary schools and high schools to make it clear that anyone, regardless of race or ethnicity, belongs as a member of the legal profession and considers that for future schooling. In Cambridge, Massachusetts, The court system partnered with local law enforcement for juvenile justice matters to try to go upstream from criminal interventions and working with youth at risk, especially youth of color at risk, to provide wraparound social services so that hopefully law enforcement intervention will not ultimately be necessary. In Las Vegas, we're partnering with the municipal court there for a massive eviction diversion pilot program where 6 social workers and other wraparound services are being provided to help primarily tenants, the majority of whom represent members of our minority communities with the resources to hopefully find affordable and sustainable housing. And finally, we've seen a trend across the country, but I'll give the example of within Kentucky of a statewide commission on equality led by the Kentucky Supreme Court with the goal of really addressing these tough issues collaboratively and in with partnership. And with that, I thank you again for the opportunity to be here and to present. I'll give the floor back to Chloe.
Thank you so much, Danielle. We are very, again, limited on time, but it is important to open the floor if anyone in the room has any question to all or any of our speakers. Now is the time. Please.
I'll be brief, guys. It's a question for Danielle. Danielle, the Minister of Justice in Canada has been mandated to develop a Black justice strategy. So we're at the stage where we're looking for members of a steering committee as well as some authors to draft a report. It's going to be led by that group in consultation with Black communities. I was just wondering if I can get your coordinates offline to get a sense of those different 9 initiatives that you were talking about. Thank you.
I would be delighted to talk offline and share what we know and some of the thoughts that we have. But in brief, I would encourage thinking about people within your court system who have lived experience, as well as community groups outside of it. And happy to talk about any of these strategies or anything else.
I think even the screens are starting to get tired. But if there is any, we're happy also to put you in contact, Michael, that's no problem, to continue the conversation. Is there anyone who would like to also ask a question, or we can also continue the conversation during the coffee break that is next? And okay, so coffee break it is. Thank you very much to all of our speakers. I recommend them to try to summarize the issue, what are the challenges going ahead. So we are taking all this in, at least at the OECD and also with our partners in our discussion, to really deepen our common understanding of what works. And importantly, your remarks as a next step will help adapt the OECD framework on people-centered justice to the specific needs of these groups. So this is the start of the conversation, and we hope to continue talking with you to go from intent to action on these very specific issues. Thank you very much. Thank you.
Good afternoon. My name is Karthik Sharma. I am with the International Development Law Organization, and it's my pleasure to moderate the final session of this roundtable. Moderating the final session is always a double-edged sword. On the one hand, you are the only thing that's standing between people and the end of 2 long days. But on the other hand, a lot of ground has already been covered, so you can keep things moving along quite quickly. So in that spirit, let us start with this discussion on effective and responsive justice systems for a changing world. We have discussed, and I think it is a point that doesn't need to be re-emphasized, that there is a crisis of confidence in governance and in public institutions. It's been validated by data everywhere. And of course, justice systems have a key role to play in this. We have discussed different ways that this trust in justice systems can be rebuilt. One of the ways is, of course, making them more user-friendly, more efficient, faster, and better. But there is a second element to this, and this is addressing the new types of challenges that the world is facing. In his report, Our Common Agenda, the Secretary General, as part of a package of solutions to address the various challenges being faced by the world, called for a new vision for the rule of law. The reason he called for this new vision is that often the way justice systems are set up and the way they function, they don't address many of the challenges that people face in their lives. This is something, again, that has been covered by other speakers, so I won't dwell on it. But also the types of things that they address may not necessarily be things that people most want addressed. So the definition or the universe of issues concerned with what we think of as justice is, I think, where we will have our discussion today. Because clearly there are things that can be done at the national level to improve justice systems, and we will hear about national experiences from our colleague in Luxembourg, but then there are issues that are to do with new challenges that don't stop at borders, and it's hard to identify any one actor who can address them without cooperation, without new frameworks or laws and institutions. And then there are issues which we may not necessarily think of as justice, issues to do with climate, issues to do with economic development, or many of the challenges that really are what are keeping people up at night and driving the anger and frustration that people feel. So this, in a nutshell, is what we will discuss, how the law can help to address some of these challenges. And we've got a great panel to cover different aspects of this fairly important but complex topic. We will start with Ms. Claudine Kunzbroek, Government Counselor and Director of the Relations with the Judicial Administration and the Legal Profession from the Ministry of Justice of Luxembourg, to share some experiences from her country.
Merci beaucoup, Karthik, pour cette introduction très intéressante. Bonjour à tous. Je voudrais tout d'abord remercier les organisateurs pour l'organisation de cette conférence.
First of all, I would like to to express gratitude to the organizers of the conference for so well-organized conference in such a beautiful venue. And Minister of Justice himself also hosted us, and thanks to Madame Pilichovsky, who also met us, and she now has to go to some important meetings, and she also hoping to see you all in great numbers. In the 8th session today, we're speaking about two legal systems with capability to react, to respond, and I want to touch upon two aspects we need to address, especially with special attention. And we have done this in the Ministry of Justice because it was our Minister of Justice's priority. And the first aspect I'm going to be talking about is access to justice and each citizen's right to go to court and seek justice and receive justice. If we're talking about the rights, we cannot avoid talking about legal fees and court fees. And this is why legal assistance is important. We have understood this in the discussions over the 2 days. And we have also we have provided legal aid to the people. How it works? It works as all or nothing. It means that the citizens who have income, so there's a specific income threshold, and if they do not reach it, then they can receive a free of charge legal aid. Now we have set different threshold, and which means that if it's not reached, then partial compensation of the legal fees can be received in the amount of 50, in the amount of 25%. It means that the range of people who can receive these services broadens. We have also a project where it is stipulated that we can collectively address, and if we accept that there is, for example, a state official whose negligence has caused some harm, then the group of people can also go to court and seek justice. And this is especially important, especially in litigations which are related to environment protection and climate issues. I would like to also note that Luxembourg doesn't have any experience with such litigations related to nature protection so far, but I think that other states do have such experience. And one more problem in litigations is that they are heavy. In order to make the procedure easier, we are going to attempt allowing more submission of the documents electronically, and we have been talking about digitalization over the course of the morning, so this very briefly just will touch upon this. I just wanted to say also that we in Luxembourg have started many new projects by developing which I have a feeling that we will never get to the end and resolve it and be successful. And today I've listened to other states, what they have been facing, and then it encouraged me that we will be successful in the end. We definitely need to be working with people mentality, especially this is related to the judges. They need to allow document exchange also electronically. Also, speaking about oral procedures, trial procedures, we are going to try to broaden authorities of the more things can be then resolved with magistrates, and availability to justice is each person's rights, and that their cases need to be reviewed in reasonable time. We also have currently constitutional reform, within which we are strengthening the independence of judiciary. That, that is a very important principle that is going to be included in our constitution for the first time. And independence of judiciary principle have two aspects. When the judges realize their functions independently, and second is that the state institutions independently apply the law within their functions. And this constitutional reform, is going to be finalized very soon. We are at the final stages already, and we will have also special justice center, rule of law center, which is going to be opened by 2023. It is expected that in this center there will be 9 members working, 6 judges, 3 will not be judges, but from the 3 that are not judges, 1 is going to be attorney and 2 other are going to be civil community representatives. I want to also address the question of what does it mean, a reasonable duration and independent trial. Currently, the judges are prepared in France in judge school, and we would like to also attract lawyers from the private sector, from state, from public administration, and they could obtain the appropriate education and become judges. We have a large amount of complicated cases that are related to economic offenses. And thank you for your attention. I am ready to answer your questions, should you have any.
These interesting insights from the experience of Luxembourg. As I had mentioned, many of the challenges that the world faces cannot be dealt with within the context of national systems alone. This is particularly true of some of the newer challenges that we face. And we have our next speaker who will share some insights from the experience of Eurojust to show us a model of transnational cooperation that can be effective in addressing some of the newer challenges that the world faces. So I welcome Ms. Anna van Harnier, Policy Officer for General Criminal Law and Judicial Training Unit, the Directorate General for Justice and Consumers from the European Commission. Ms. Harnier, the floor is yours.
Thank you very much. I hope you can hear me well. And yes, I wanted to start explaining briefly my take on this. So as what I was just presented, I work for the Director General, Justice and Consumer of the European Commission, where my unit is responsible for substantive criminal law and judicial cooperation in criminal matters. The focus of our work is the fight against serious crime with a cross-border element from a policy perspective, and also, of course, a policy and legislative perspective. Regarding substantive law, our initiatives focus on the harmonization of national laws. But harmonization of national substantive law is not sufficient to fight cross-border crime efficiently. For the investigation and prosecution of cross-border crime, obviously close cooperation between the national authorities is crucial. And to facilitate judicial cooperation in serious cross-border cases between 2 or more member states within the European Union, the EU Agency for Judicial Cooperation in Criminal Matters, short Eurojust, was established. At Eurojust, national prosecutors from the member states work side by side. They provide knowledge about the national legal framework. They can establish direct contact to the competent national authorities,
and they have the competence to authorize investigation measures in line with the national law of their respective member states directly themselves. This structure facilitates not only quick information exchange, but it also allows to conduct coordinated investigative measures in multiple member states at the same time. A special initiative reacting to operational needs was the establishment of the European Judicial Counterterrorism Register in 2019. Following the terrorist attacks in Paris and Saint-Denis in 2015, the need for closer coordination regarding investigations and prosecutions in terrorism cases became apparent. The objective of the register is to detect unknown cross-border links between ongoing and concluded terrorism cases. Therefore, member states now provide information about such cases to Eurojust. The information is shared through a national coordination system, which is established in accordance with the structure of the national judicial system. At Eurojust, the information is cross-checked with other cases, and based on such links, national authorities then can exchange information about the suspects or groups they are investigating. They can coordinate investigation measures or coordinate prosecution strategies, which increase the success rate significantly. First suspects have already been prosecuted and convicted. In the last year, we have strengthened the legislative framework to improve the functioning of the register and to allow for further digitalization. In addition to EU internal judicial cooperation, Eurojust also facilitates judicial cooperation with non-European countries. Based on a cooperation agreement with the European Union, non-EU countries may second a prosecutor to Eurojust. At Eurojust, the so-called liaison prosecutor will then work side by side with the prosecutors of the member states. Based on such cooperation agreement, Eurojust currently supports also the investigation and prosecution of international crimes committed in the Russian war against Ukraine. Relevant investigations take place in Ukraine for the International Criminal Court and in the member states. To facilitate this support, we have amended the Eurojust legal basis. Eurojust may now preserve, analyze, and store evidence relating to international crimes, not only in relation to Ukraine, I have to say. In the context of the Russian war in Ukraine, from the very beginning, victims and civil society organizations played an important role in the documentation of crimes committed. However, there's an obvious tension between the role of individuals documenting crimes and state authority and the monopoly and power. And civil society organizations reached out to us very early to provide information they had collected to us or to Eurojust. So when we amended the Eurojust regulation, we discussed if we should enable civil society organizations to provide information directly to Eurojust. But we finally decided against this. While acknowledging the critical role and rich expertise of civil society organizations in relation to accountability efforts, in principle, their role should be complementary to state authorities. For evidence, prior involvement and review by competent authority is necessary as a rule of law requirement. Competent authorities have to evaluate the evidentiary value of information and ensure admissibility of the information before court. So instead, we focused on strengthening the exchange and coordination between judicial authorities and civil society organizations through the European Genocide Network, a network of national contact points established in 2002 to ensure close cooperation between the national authorities in investigation and prosecuting international crimes, in which also many civil society organizations participate. And to build a stronger partnership, Eurojust, the Genocide Network, together with the International Criminal Court, have developed guidelines for civil society organizations on documenting international crimes and human rights violations for accountability purposes, which were published, I think, yesterday. And this shows that not only for cross-border cooperation between national authorities, but also for cooperation between authorities and civil society, close coordination and predefined paths and roles are elementary to ensure responsive and effective justice. Thank you very much.
Thank you, Ms. von Harnia, for sharing this example of successful transnational cooperation that can be applied not just to criminal justice, but has broader application. The other aspect of the discussion today is looking at or applying a justice lens to issues that one may not instinctively or traditionally think of as being related to the justice sector or to law. And a good example of this and focus of our session will be the issue of the environment and climate change. We know that there has been a history of cases on environmental law, but in recent years we have seen, both because of the accelerating nature of climate change, which has been defined by many as one of the most important generational challenges that we will face, we have seen it become much more important. We have seen demand from communities to address issues that relate to climate change, whether it's with the causes of climate change or the effects. Both of those are intrinsically linked with issues of justice, fairness, and equity. And with the exception of some landmark cases, recently, many of them here in Europe, we can mention France, Germany, and the Netherlands coming out with important decisions on this issue. The legal system really, at the moment, is not terribly well equipped or even cognizant that this is an issue that it should be seized with. And so I think one of the challenges of a changing world is how can justice systems reorient themselves towards issues like climate, which are going to dominate not just the present, but for future generations. It involves balancing interests between countries. It involves balancing interests within countries. It also involves balancing interests between generations. So very much an issue, I think, for lawyers. My organization, the International Development Law Organization, IDLO, recently adopted climate justice as one of our strategic objectives. And the way we have been approaching the issue is threefold. The first is looking at the bottom-up empowerment angle. In many cases, and this is particularly linked to issues of sustainable use of resources or extractive industries, communities do not have a voice in how land and resources that they live on or have a right to are used. And so empowering them to be able to engage with these processes, to be able to be cognizant of their rights and to be able to claim them through competent channels is an important part of this work. The other is working from the top down with laws and institutions to help them become ready for climate adaptation and mitigation measures. Many countries have taken on or willingly made nationally determined contributions internationally, but they lack the capacity, they lack the legal knowledge, they lack the institutions and laws to carry this out. And I think there is much that can be done to support countries that want to live up to their climate commitments to implement them, either through supporting access to climate finance, developing laws and policies, and supporting institutions in their implementation. And finally, there is a specific area of interest, which is to do with land. And land disputes, I think most surveys find, are one of the leading causes of legal disputes around the world. And this will only grow as the world gets hotter, extreme weather events become more severe, and there are very little in the way of laws, policies, or frameworks to address this issue. So working both at the domestic level and at the intergovernmental level is going to be important. As I said, there have been a number of important decisions taken by judiciaries. I already mentioned the ones from Netherlands, France, and Germany, but with us today, we have the opportunity to hear someone who actively decides and adjudicates on issues of environmental justice. We have a statement from Mr. Brian Preston, Chief Judge of the Land and Environment Court in New South Wales, Australia. So I will now ask that the statement be played.
It's a great pleasure to be able to present to this important conference on global access to justice. The particular session in which I'm speaking is responsive and effective justice systems for a changing world. What the particular focus is on Sustainable Development Goal 16. That provides to promote peaceful and inclusive societies for sustainable development, to provide access to justice for all, and to build effective, accountable, and inclusive institutions at all levels. Of these three objectives, the second and third are particularly relevant. That is, the need to provide access to justice for all and to build effective, accountable, and inclusive institutions. Starting with the second of those, that access to justice, there are two targets one target and one indicator for achieving access to justice. The particular target is to promote the rule of law at national and international levels and to ensure equal access to justice for all. Now, how do we measure that? What's the indicator? And one of them is the proportion of the population have experienced a dispute in the past few years and who access a formal or informal dispute resolution mechanisms. Into the strong institutions objective, there's one target and one indicator. So the target is to develop effective, accountable, and transparent institutions at all levels. The indicator is the proportion of the population that is satisfied with their last experience of public services, in this case, with the justice system. Now, achieving equal access to justice for all and strong judicial institutions requires people centricity. So there's a need for a people-centric justice system, and I'm going to give 5 reasons. The first is that law is a form of social ordering. It regulates the legal rights and responsibilities of people in society. The second is that the upholding of legal rights and the enforcing of legal responsibilities is not abstract. Rights, of course, are held by people, and wrongs are committed by people. Third, all people should have equal access to the justice system to resolve their disputes. Fourth, the law should be applied equally and fairly to all people by the judicial institutions. And fifthly, we can see, bringing this together, that justice is not an abstract concept. Justice is achieved by the just application of the law to all people in their disputes. Now, this brings us to user satisfaction and public trust and confidence. So user satisfaction and public trust and confidence in the justice system will depend upon the judicial institutions having a user-focused and people-centered orientation. So the judicial institutions need to facilitate people being able to access the justice system for the resolution of their disputes and to effectively, efficiently and equitably resolve their disputes. So the justice system needs to be organized and operated so as to achieve this people centricity. And there can be at least 4 ways identified. The first is to facilitate easy and affordable access to the judicial institutions, such as the courts. The second is those judicial institutions need to adopt this user-orientated approach from the filing right through to the finalization of the cases. The third is that the judicial institutions need to provide understandable, effective, and efficient practices and procedures for the management as well as the resolution of the cases before them. And finally, the cases need to be resolved according to law and the rule of law. And reasons need to be provided to the parties explaining how they were heard and their arguments have been addressed. So how do we measure this people centricity of the judicial institutions? There are a number of ways, and I'll identify some. The first is to identify any barriers to the accessing the courts, that access to justice. Secondly, measuring the extent to which people with disputes have actually accessed the judicial institutions. You recall this was one of the indicators for Sustainable Development Goal 16. Third, there needs to be an evaluation of the information that is provided on how to access and how to use the judicial institutions for the resolution of disputes. For example, looking at the court's websites and the information there provided. Fourth, there needs to be an evaluation of the practice and procedure for the management and resolution of cases. Fifth, there needs to be an evaluation of how disputes are resolved, including the provision and publication of judgments. Then there needs to be a measurement of both user satisfaction as well as public trust and confidence in the judicial institutions. Now, the types and issues of disputes that come before the courts will change over time and place. And this is especially true with environmental problems, which are often uncertain, complex, and polycentric. And these have been described as hot situations because they can evolve rapidly and substantively. And the triple planetary crises are examples: climate change, loss of biodiversity, and pollution. Now, the law and justice system needs to evolve to adapt to this evolution of hot environmental disputes if they are to remain fit for purpose. The evolution must be in the substantive law and policy. And that's made primarily by the legislature and the executive. But to the extent legitimate, it can also be made by the judiciary, especially in common law legal systems. But the justice system must also evolve, adapting and developing its institutions and governance to provide better access to justice and dispute resolution for these hot environmental disputes in order to deliver environmental justice. Now, the lodestar for such adaptation of the law and justice system to promote access to environmental justice should be people-centered justice. So the question that should be asked for every reform of the law or justice system is, will it improve people-centered justice? So what are the areas that we should be looking at in order to reform the law and justice system to better deliver environmental justice? And I'll identify 5. The first is institutional reform. And this could include establishing environmental courts or tribunals, and there are various forms. But these environmental courts and tribunals may be better equipped and able to resolve these hot environmental disputes. Secondly, there needs to be reform of the dispute resolution process. So there should be an offering of appropriate dispute resolution. By that I mean that there should be a matching of the forum to the fuss that is, the different dispute resolution mechanisms to the particular dispute, but there should also be a matching of the form of the forum, that is, the ways in which the dispute resolution is organized and conducted, so as to equip it to resolve the particular dispute. There needs to be reform of procedural justice. There needs to be an improvement of access to environmental information, public participation in environmental decision making, and access to justice in environmental disputes. There needs to be reform of distributive justice. This involves ensuring a fair and just distribution of the environmental benefits and burdens amongst people, both present generations and future generations. And finally, there needs to be reform of recognition justice. All people need to be recognized and need to be afforded dignity and respect. So non-recognition, misrecognition, and malrecognition of people needs to be addressed. I have sketched in this short presentation the need for people-centered laws and justice systems in order to achieve the SGD goal of achieving access to justice for all and strong judicial institutions. Such people centricity is especially important in delivering environmental justice. Environmental problems are ever evolving, and they demand that the law and the justice system keep up by adapting their substance, form, and function. And the touchstone for such adaptation will be people-centric justice. Thank you.
Thank you, Judge Preston. And of course, we're not dealing with climate in isolation. Many of the challenges and crises that we face are interlinked. And one of the ones that is very closely linked to climate is migration and the movement of people. So without further ado, I'd like to invite Mr. Jean-Pierre Gauthier, Senior Research Fellow in Public International Law and Director of Teaching and Training at the British Institute of International and Comparative Law, to give his intervention. You have the floor, sir.
Thank you very much. Thank you very much to the organizers, the Latvian government and the OECD for the invitation to participate in this roundtable. I have been listening to most of the past 2 days and taking copious notes and trying to adjust what I was going to talk about to make sure that I wasn't repeating too much, which meant that what I had planned to say has now gone out the window and will be adjusted significantly. What I'd like to do is give a few reflections on access to justice for different groups that I work with in the context of migration, in the context of climate change, but also in the context of human trafficking specifically. I'll be talking about findings from different research projects that we've undertaken at the Institute, including a project on determinants of anti-trafficking efforts, kindly funded by the US government, a project working with Asian grassroots organizations working with informal workers, kindly funded by USAID, as well as projects focusing on access to justice and the impact of lack of legal advice, kindly funded by the Policy and Evidence Center on Modern Slavery and Human Rights of the UK, in the UK. So one of the things that has come up in the last session, but also over the course of the 2 days, is the need for cooperation. Previous speakers on this panel have also talked about judicial cooperation as well as other forms of cooperation. Now, we mentioned that a lot when we speak about migration. Cooperation is seen as one of the key solutions to migration situations and migration issues as they arise. And there was a couple of things I wanted to mention on cooperation. So the first one is a slightly cynical point on cooperation, which is that very often in the migration and displacement space, what we are seeing is cooperation as a means of limiting access to justice rather than promoting access to justice. I say that in the context of, for example, cooperation at European borders, where people are not allowed access to the territory and therefore to the administrative and judicial systems that they might otherwise be entitled to access in order to achieve justice, achieve status, achieve some form of protection. The other angle that I wanted to mention on cooperation is the need to move towards cooperation at a much deeper level. Beyond state to state, institution to institution level, we need to think about cooperation between peoples across border in taking forward claims, judicial claims in front of courts, but also more broadly taking forward advocacy efforts in the justice space more generally. This might take the shape of cooperation between support organizations, for example, between organizations working with migrants, with trafficked people, etc., or indeed between individuals, young people, and organizations fighting climate change, for example. And we've seen some really positive examples of this, right? So if we look at some of the international claims brought to challenge the impacts of climate change, they have been brought by young people from a variety of countries coming together and bringing cases together. And I think promoting that level of cooperation remains critically important. If we're doing that, then we also need to think about how domestic and international judicial and quasi-judicial systems are ready to handle that sort of cooperation between people and taking forward cases that are brought by people from different countries and from different jurisdictions. Part of that and part of ensuring that our judicial systems and our systems more broadly are capable of dealing with these situations is to always have at the back of our minds the assumption of citizenship. And very often when we're talking about these issues, we talk about, citizens' access to justice, ensuring that citizens have access to justice, etc. And I think it's important to also keep in mind that for many people who need access to justice, who should have access to justice, that citizenship is not there. And very often, one of the things that we see in the migration space and in the trafficking space, for example, is that one of the key barriers to access to justice is the fact that there's no status and that therefore people get deported. The other point that I wanted to mention is about outcomes of judicial processes and kind of access to justice by some people. And those outcomes kind of I would split in different ways. So one is actually making sure that the green transition happens in a people-centric way, etc., but also the impact of, and keeping in mind the impact that judicial processes and judicial decisions can have on broader policy agendas, for example. So our research at BICL on the determinants of anti-trafficking efforts really highlighted a few points in this regard. Firstly, it was the incredible effective influence that case law, judicial decisions, and in some cases simply the filing of cases by individuals can have on improving anti-trafficking policies and efforts. These can be cases at the domestic level or at the regional or international level. So we looked at a number of countries and we saw cases both filed in domestic courts, but also filed, for example, in the European Court of Human Rights or in front of UN committees, UN treaty bodies that really helped influence the policies of particular countries. And it's not just case law, right? It's also about quasi-judicial bodies, whether that's UN special rapporteurs, whether that's other bodies at the international level. So as we think about judicial processes, we need to think about both the decision in the particular case, which obviously needs to be the key priority, and that needs to be the focus, but also the kind of broader strategic impact that those decisions can have. And then the second thing that comes out quite clearly from that research is the connection between case law and other aspects, other determinants of anti-trafficking efforts. The ability of civil society organizations to bring those cases, for example, the strengthening and the facilitation of NGOs being able to engage in cases, whether directly or indirectly, whether in a supporting role or as the entities bringing forward the cases themselves. And obviously, if we look at the kind of just purely kind of statistical correlation. If we look at countries and how they perform on the rule of law and access to justice issues, we also see that they tend to perform a little bit better on anti-trafficking efforts as well. We heard yesterday about the legal system being the tip of the iceberg of the justice system, and obviously I couldn't agree more. But we need to take that message to broaden public legal education, broaden the net of organizations and entities that are able to identify legal questions, ask the right questions, and ask those questions to the right people and to the right institutions. This would allow us to extend access to justice, ensuring wider scope for entities and individuals to support access to justice for vulnerable communities, whether that's migrant groups, whether that's trafficked persons, etc. The other point I wanted to mention is that very often we talk about, especially kind of in the climate space and the environment space, we talk about the need for specialization by courts. And I think that's a bit of a double-edged sword and something that I think should be kind of open to discussion. And the reason I say that is that because of the nature of issues like human trafficking, because of the nature of issues like climate change, we can no longer assume that an environmental court or a trafficking specific court, etc., is going to be able to deal with the variety of legal issues that an individual might be facing because of that particular concern. So we're doing this piece of research on the impact of a lack of legal advice on victims of modern slavery, on people with lived experience of modern slavery. And one of the things that comes across quite clearly is that the issues of trafficking and being access to justice in the criminal justice process, for example, in the context of trafficking, is only one of the factors where we see that impact. We see those impacts in all sorts of other areas which are directly linked, whether that's immigration, for example, and indirectly linked, issues such as family and custody matters, for example, which are all efforts, or which are all issues and legal questions that have very significant impacts on the well-being and long-term well-being of the individuals involved. And when we spoke to victims of trafficking specifically about what access to justice means for them and what are the impacts of lack of legal advice, one of the things we got back is obviously difficulties with accessing legal advice. But the other thing that we got back is about quality of legal advice. It's not about having people trying to kind of advise on different issues if they do not necessarily have the expertise. And very often there is expertise on trafficking, but there isn't expertise on family law matters, which is what the particular question at hand might happen to be, even if the person bringing that question is a trafficked person, for example. The other thing that the trafficked people that we spoke to also mentioned in terms of quality wasn't so much about knowledge of the law, but it was about knowledge of the situation. It's about skills such as empathy, skills such as communication with the victims of trafficking and the people involved in that situation. One of the things that was highlighted as being particularly problematic and really impacting people's trust in the system and people's engagement with the system was the fact that very often, especially when a trafficked person is supported by an NGO or by a support organization, by a frontline organization, very often lawyers, instead of going directly to the trafficked person and informing them of what's going on or asking them the questions, they will automatically go to the support organization. Now, that can very often be a good thing in terms of involving the supporting organization, but it is also very disempowering to leave the victim out of the equation completely. So whilst there is a role to be played by those support organizations, I think it's critically important that the trafficked person themselves is involved, especially in situations when that trafficked person has said, look, I want to be involved, I want to be informed of what's going on, etc., etc. The other thing I wanted to mention is on kind of reinvention of the wheel a little bit, and I noticed this in kind of a few different areas between kind of issues around in the context of climate litigation, whether talking about issues in corporations' supply chains, which have been addressed in the human rights context, and we need to kind of see how those conversations can be joined together, whether it's conversations around the use of science in the context of climate litigation, an issue which has already been discussed in other areas of law, and we need to make sure that we are learning from the situations and the developments in those other areas of law as well. The other key question that comes up in climate cases, but more specifically in migration/human trafficking cases, is what happens in the situation that I mentioned earlier, where people are deported before they can actually access justice, or they leave before they can actually access justice. We've talked quite a bit over the last 2 days about the impact of COVID, for example, and one of the things that we saw in many countries is that many migrant workers actually had to leave the countries where they were residing, and very often that meant leaving without getting paid, etc., without being able to challenge non-payment, etc. And one of the promising practices that we've identified on this is processes in Asia, specifically in Singapore and Hong Kong, where a particular organization is working with organizations in countries of origin, particularly Indonesia and the Philippines, to help people who have returned to those countries bring employment and missing salary and other cases and other claims in front of tribunals in Singapore and Hong Kong. Now, obviously, again, the justice systems, as Judge Preston said before me, would need to adapt to allow the system to allow people to bring those claims when they're not physically in the territory of the country where they're bringing the claim, that they're bringing the claim in. But I think that is a critically important way, at least to overcome one of the key challenges for victims of trafficking in accessing some form of justice. The other promising practice that I wanted to mention is issues around basically engaging grassroots organizations, informal organizations of workers, for example, to participate in processes at both the national and international level, both in terms of lawmaking, but also in terms of judicial processes, monitoring processes, etc., to make sure that justice questions that they have are also addressed. I think it's critically important to keep in mind that challenges to access to justice do not stop at borders. People might be fighting these issues from across multiple borders, and ensuring some form of accessibility to that kind of transnational element, transnational access to justice remains critically important. I'm conscious of time, so I'll stop there, but I'm very happy to take any comments or questions.
Thank you very much, Mr. Gocci. So I think I will now open it up to the audience. If there are any questions on any of the issues addressed by the panel, I'm sure our eminent panel will be more than happy to field them. Going, gone. Okay, so I think it's been 2 very fruitful days and a lot of insights. If I may just sum up some of the things that we've heard here. We've heard that justice systems need to be more effective and responsive to people's needs in order to rebuild trust and confidence. And in a changing world, this means people centricity at the domestic level, being more user-friendly, being much more efficient and better at preventing and resolving disputes. It also means more cooperation at the international, subnational levels, not only between governments, but between different entities, people, NGOs, and coming up with creative ways of doing that. And we also heard the importance of bringing a justice lens to issues that are emerging as key concerns for both sustainable development, peace, and prosperity. So with that, I would like to extend my thanks to OECD and the government of Latvia for organizing this lovely conference, on inviting me to moderate this panel. Thank you very much. The floor is over to the organizers.
Yes, thank you. Thank you so much. I am looking at my partner in crime, Anna, representing the government of Latvia. So maybe, Anna, you could say a few words before the OECD says.
Thank you very much, and it has been a great pleasure for us, and I would like to extend sincere gratitude on behalf of the Ministry of Justice to each of you for participating and coming to Riga. I would like to thank a lot OECD team for our kind cooperation, not only in preparation of the roundtable but also during all these years and working on the numerous projects related to the access to justice. And I would like also thank a lot my team working on the preparation of the roundtable. So Elina Ščipar, Liva Matuzel, Beate Stivrinja, and Aiva Maci. Thank you very much for everybody who have been involved in preparation of the roundtable. And to finish our day today, I would like also to remind us that we have planned a cocktail at 7 o'clock.
Discussing different elements when it comes to the implementation of the OECD People-Centered Justice Framework. It also shows that there is so much more work that needs to be done, both on digital transformation, on the role of data, on data governance, when it comes to also tailoring and adjusting services to respond to the needs of different groups of people. We also discussed just now the ways that we need to think about adapting justice systems to be able to respond effectively to the emerging and future global challenges. So many points that we are taking away to inform the OECD work for the future. I also would like to take this opportunity to encourage countries to invest in your capacities to report on the SDG 16.3. Just to mention again what I said during one of the sessions, that we only had a few countries. I will not say it publicly how few, but just to, again, a big plea to all of our members and, of course, our partner countries to really take this process seriously. And of course, on the OECD side, we have developed a range of tools, including the legal needs surveys, the adaptation of those surveys to the needs of children, to the needs of businesses, and then working with our partners in UNDP, UNODC, to also measure progress on the broader SDG 16. So just to encourage you to use those tools in order to be able to monitor progress, but also make progress in access to justice. So there have been a few papers, preliminary versions of those papers available at the back of the room. If you haven't had a chance to get a copy, please do. I'd like to thank all of our members for your contributions, for sharing your good practices to inform those documents. And I'd like to thank all of you in advance for any additional comments that you may have, so that we are able to finalize this work. And just to remind us that these documents are the framework on online dispute resolution, document on the digital and data transformation for access to justice, a framework on justice for business environment, a child-friendly justice framework, as well as some of the forthcoming work on the data needs for the justice sector and the skills framework for people-centered justice. And again, to mention that we are really pleased to join forces with partners in IDRC and the World Bank to continue advancing the agenda on global justice data. And finally, of course, we will be in touch with all of you on the draft OECD instrument on access to justice and people-centered justice systems. We will be welcoming feedback from our members, from our partners, but also the recommendation will be available for public consultation. So we would really like to encourage all of you to look at this instrument and provide us with your feedback in order to ensure that it is as relevant and useful to all of you as possible. So thank you again to all of our speakers, all participants, our partners in the government, of course, Deputy Prime Minister Bordans, Anna Skriabina, also in particular, because of course you've been exercising a leadership in this agenda, and also the teams on both sides, and I'd like to also mention the OECD team, and of course Chloe, Ben, Marianne, Irene, who are here, but also so many of my colleagues that are assisting us behind the scene, Melissa, Louise, Maria, but also many, many others. So big thanks to everyone and to our interpreters for working overtime on both days. So all of your help is greatly, greatly appreciated. So many, many thanks.